Good morning, ladies and gentlemen, and welcome to the conference on climate justice, new challenges for law and judges. It's my pleasure to welcome here in these most challenging times for looking at solutions which can help us to empower our planet and to find the way for a green transition. First of all, I would like to give the floor to Ms. Elli Schlein, who is Vice President of the region Emilia-Romagna. She's very committed in the attempt to find a solution for our climate challenges. She is leading a project in the region for just transition, social and environmental justice, and therefore we are particularly glad to have her here, also from the political side, for showing commitment for the tasks and goals we are trying to tackle today and in the next days. So I'm glad to give her the floor. Ms. Schlein, please. I'm sorry, Ms. Schlein, we have some issues with the audio. Can you try again, please?
Or you don't hear me?
Perfect. Now we can hear you perfectly.
Okay.
Thank you.
Should I start again?
Perfectly, yes.
Okay,
Please.
so good morning, everyone. I was just about to thank the Università di Ferrara and UCLA for this important conference, and thanking also all the experts that you have gathered today, not only from our country, but also from other countries. It's particularly important to face together the challenges that are posed by the climate emergency. And I think it's the first time that I participate to an event focusing on something very important. So let's say, the climate law and climate justice law. And we need to think about this because since the laws at the international, European, and also national and local level are changing fast in order to face climate change, it's important to understand how we can keep up, and we can follow the developments also from the court's point of view. And I think that you are focusing in the right direction. Just to take an example, I was a member of the European Parliament before being now the Vice President of Emilia-Romagna, and we were working in the last years, for example, on the issue of climate refugees. As you know, climate refugees are not directly, let's say, recognized by the Convention of Geneva, but instead it's a clear phenomenon. It's happening right now. I'm making usually an example that you probably know very well to understand why social justice and climate justice are so, let's say, united. You cannot separate them. And I'm thinking about what is happening in the Lake Chad across different African countries. And the Lake Chad was the seventh for its extension in the world, and now, as an effect of climate change as well, it has become 10 times smaller, and this is forcing thousands and tens of thousands of people to forced migration on one hand, or to extreme poverty. And what is happening in Lake Chad is about our choices. What I mean is that the clear and the first climate injustice is that if you think about it, the countries and the populations that are paying the highest price for this climate emergency are exactly those countries that have contributed the less to climate change and to the greenhouse gas emissions. So that's why I think that in the global approach, but also at the local, national, and European approach, we have to keep in mind that who is paying today the costs of climate change is once again the most vulnerable parts of our population, beyond our borders, but also within our borders. It's the same that we are witnessing in Italy, for example. You know that, and I'm saying this for the excellent experts that are coming from outside, we are facing a strong energy emergency in Italy right now, also because of the dependency on fossil fuels, and particularly the dependency on fossil fuels coming from Russia in these times of a dramatic new war. And again, we are seeing difficulties of our families, enterprises, civil society sectors, in terms of, they are receiving now energy bills that have practically doubled. And it's true, this hits everyone in the society, but in such an unequal society, it hits even harder the poorest parts of our population. That's why we say we have to be able to imagine and write down policies that at the same time reduce inequalities and accompany the so-called ecological conversion that we desperately need, and that could also bring opportunities for quality jobs and new good enterprises. So that's the spirit with which Emilia-Romagna has written down with 55 regional organizations in December 2020, a Pact for Work and Climate. The Pact for Work and Climate is a strategy of, let's say, common objectives and shared responsibility to reach these objectives. And between these ambitious goals, we have committed to write down, and we are working on it. There was a meeting also yesterday in the region. We are committing on writing down a path for reaching climate neutrality before 2050, which is, as you know, also one of the objectives signed with the European law on climate now. But we have to write down a strategy that every 5 years tells us where we need to be, and with which implementing strategy, sector by sector, we can reach the reduction of the greenhouse gas emissions. So that's the technical and difficult part of our discussion right now, which means also a political discussion engaging all the stakeholders in society, because we have written down the Pact for Work and Climate because we are aware that you cannot, let's say, have a top-down approach when it comes to, let's say, face climate change. We need to engage with all the social parts and social actors, so that every one of us, in the different role that we have in the society, we work in the same direction to reach these very ambitious goals that also are the goals of the Agenda 2030 for Sustainable Development. So feel very welcome in a region that is trying to do its part, with all the difficulties and contradictions that we are still living in. We are a strong industrial region, luckily, because we have so many important economic sectors, but we have to accompany them through this transition, investing resources, orienting our resources in this direction, like the Next Generation EU plan of the European Union is doing, and at the same time showing political will to make all our policies coherent with these new ambitions. So that's why we are trying to do this work also with our universities, because the universities of our territories have worked with us to write down this Pact for Work and Climate. And we are also trying to reach an ambitious goal of 100% renewable energy by 2035. So it's going to take a lot of resources in renewable energies, but that's the right path. And we want to embrace it. So thanks a lot for being here, and thanks for the contribution that you will give to our ambitions by supporting it with law, with the capacity of defending also in the courts what we need to do to make sure that the planet continues to live after us for the new generations. Thanks a lot.
Thank you very much to Ms. Vice President Schlein for her contribution and inspiration, and for showing what is the commitment, also the political level. Thank you again. Now I would like to give the floor to Professor Serena Forlati, who is the Dean of the Law Faculty, who is hosting this conference. Please, Serena, you have the floor.
Thank you, Alberto. I hope you can hear me appropriately. I know that my connection is not perfect, but I still am very happy to take a few minutes of your time to express my words of welcome to all of you. Vice President Schlein has set out perfectly what are the political implications of targeting climate change. As an international lawyer, I am, of course, fully involved and interested in the development of appropriate legal principles that may sustain the political effort in addressing such as a sweeping and high-impact phenomenon. And in this spirit, I really welcome the idea of working on principles that may guide policymakers and other actors. As Vice President Schlein explained, this is not a matter only for governments to tackle, also for all branches of states, including the judiciary, of course, and also for the private sector. The challenges are several from the point of view of jurisdiction, from the point of view of substantive standards to be applied, from the point of view of evidence and proof. And I am sure that the discussions today will bring about some fruitful suggestions, at least, that may be considered for maybe future hard law making. I will not take much longer, but I wish you all an excellent day and a fruitful discussion towards this end. Thank you again for your attention, and welcome again at the Law Department.
Thank you very much, Serena, for this warm welcome and introduction, which gives us an even sharper focus on our challenges, our today's and tomorrow's challenges. And now I would like to welcome you again to this conference on climate justice, and to give a special thank to two persons in particular, to William Boyd, professor at the University of California, Los Angeles, and co-director of the Emmett Institute on Climate Change and the Environment, and to Professor Henrik Andersen of the Copenhagen Business School. We are particularly glad to host this conference, which is actually a joint venture and the first physical meeting of the European Law Institute's project on climate justice, new challenges for law and judges. So we're glad to offer this platform and to stimulate an intercontinental dialogue on these issues, which are by their very nature cross-border, have cross-border character. A special thanks goes for the important also financial support given by the University of California, Los Angeles. We're very thankful for that, for their commitment and for being here discussing with us and trying to create a common approach to identify issues and challenges and to try to find common solutions. A special thanks goes to you, to each of you fine experts from several continents and backgrounds, academics, judges, practicing lawyers, representatives of NGOs, and data scientists being here today for discussing new solutions for climate justice. So this conference could not take place in more challenging times. Climate challenges, digital disruption, abruptly change of circumstances due to international conflicts. This makes all the more important to strengthen our synergies. And therefore, something about the background of this project on climate justice we are starting to discuss in presence today. This is not the first meeting of the participants in this project. It is just the first physical meeting, but as we were stuck in the pandemic, we already tried to strengthen our ties and to share our ideas in order to bring forward solutions in this regard. So we all know that more action is necessary and urgent concerning climate change. And while specific legal rules exist, they might not be sufficient. And moreover, their implementation by judges seems often questionable from the rule of law perspective. So, and as we said, climate change problems are of cross-border nature, and the courts must address extraterritorial issues as well as questions related to both private international law and public international law. Furthermore, the courts must face a multi-level system of law. That means international, European, and international. And in addition, the interface and overlap between specific international and European climate change law, national and international public law, national and international private law, and criminal law pose crucial methodological challenges for courts. And this is the very nature of today's and tomorrow's meeting. So we tried to set up this debate which goes across boundaries and across sectors in order to get the flavor of what is the systematic of the problems we are taking to trying to solve. Indeed, the risk we are already experiencing is that different methodological approaches can result in legal uncertainty to the detriment of citizens' legitimate expectations under the rule of law. And the question is whether courts can find common ground for improved judicial cooperation in their methodological approaches to climate change problems in order to ensure improved legal certainty at the European and at global level. And similarly, while legislators may have ideas for new statutory roles for individuals, private entities and public administration, they need to understand what problems might exist and arise at the level of implementation, especially by courts. These are just some of the aspects and some of the starting points for today's and tomorrow's meeting. And we need to invest much more in this direction and to open to interdisciplinary research and to research involving different backgrounds and different jurisdictions. Investing. We need to invest new energies. We need to invest in new energies, namely the sun and other renewable energies. And talking about the sun, our mind goes back to Copernicus, who graduated in Ferrara at the beginning of the 16th century, in 1503. So to say, today we need a new Copernican revolution, finding the balance between technological progress and environmental sustainability. This conference aims also at addressing and enhancing the synergy between the green and the digital transformation by exploring measures which can accelerate and maximize the impact of policies to deal with climate change and protect the environment. We would also like to thank all the other participants in the room for being here and for their contribution to the discussion, for strengthening our ideas and giving more ground to our solutions. So, jus est hominis ad hominem proportio. Facing the multifaceted disruption of the traditional equilibria, which required a new balance between different values, rights, and duties, we wish you 2 fruitful days of discussions. Thank you very much.
Good morning, everybody. Thank you so much for being here. It's a pleasure to be part of this climate justice project. And to have it here in Ferrara, in this lovely room. Thank you so much, Alberto, for all the organization that you've done in respect of this conference and tomorrow's meeting. Now, as you probably have seen, we have a long day ahead of us, and I will be very brief here. But I think we should make an agreement. Let's put a date and meet here in 100 years' time in this room in Ferrara. We would probably have a very different discussion about the legal landscape in respect of climate law. Now, I'm not equipped with a crystal ball, but I will assume that states and corporations' obligations and liabilities under the law will be much clearer than they are at this point. Climate law is in its infant stage, where the levels of obligations that states and corporations they have to reduce the anthropogenic emissions that cause harm to the climate, they are not clearly defined in respect of its legal substance. We have, of course, regulatory instruments to address climate change. We have, for example, the Paris Agreement, we have the European climate law, we have also specific regulations concerning deforestation and so on. But when we look at the whole package of climate law, it seems to relate to or to borrow from other disciplines, like human rights, tort law, private international law, public international law, both general and particular, like international environmental law. Furthermore, we are also seeing this increasing focus on corporate social responsibility or corporate climate responsibility, and that they may also play a part when we are looking for or trying to define what is climate law. We are here to learn, we are here to debate about the scope of climate law and climate justice. What are the challenges and what are the opportunities in providing climate justice? Can we see patterns between the different sectors of law and potential cross-sectorial application of law to establish a clearer picture of the whole set of climate law? Today's panels, they all have different headlines. But let's not forget that all of this, it elevates to an abstract duty to protect life and the planet. We are aware of the reports from the Intergovernmental Panel on Climate Change, and following these reports, we need to act now. The question is the scope of the present legal instruments which we apply to protect the climate while we at the same time keep our duty to uphold the rule of law. So I'm very much looking forward to today's discussions that we'll have both within each panel but also between the respective panels. Thank you very much.
Good, and you? Did you come over from the U.S.? But I've been here for a while. Yeah, I've had some work. Yeah.
Okay. Welcome, everyone. So I have the pleasure of moderating the first panel. I'm William Boyd from the University of California, Los Angeles. I just want to say before we get started how much I appreciate the opportunity to be here. I want to thank Alberto in particular for his leadership and his incredible organizational skills in bringing everybody together during a challenging time. To Henrik as well for helping to organize this workshop and this climate justice project, to the University of Ferrara for hosting the meeting, to the people of Ferrara, and to all of you for being here today and tomorrow. I'm going to introduce the panelists very briefly. I think their longer bios are all in the conference materials. And then the panelists each will speak for 20 minutes. We have two here in person and one person, Pasquale, who will speak to us via Zoom. And then hopefully we can get into some discussion. We're already ahead of schedule, so we have hopefully plenty of time for some discussion. And I hope those of you in the back maybe will feel like you want to move forward and we can have a very intimate discussion here on this first panel, and maybe set a high bar for the rest of the panels for the rest of the day. So brief introductions. First, we have Professor Gerhard Wagner, who is a professor of law from Humboldt University in Berlin. Professor Dr. Gerhard Wagner has held the position of professor of civil law, commercial law, and economics at Humboldt University since 2013. At Humboldt University, he is the founder and academic director of the English language LLM program, International Dispute Resolution. Our next panelist, and Gerhard will be speaking on a tort duty of care to avert climate change, ? Our next panelist will be Professor Dr. Marc-Philippe Weller. Professor Weller is the director at the Institute for Comparative Law, Conflict of Laws, and International Business Law at Heidelberg University. He is also, since 2019, been the vice rector of Heidelberg University. And then our third panelist, who will join us online, is Pasquale Pistoni from the University of Salerno. He is the academic chairman of IBFD, a professor of tax law at the University of Salerno, and holder of a Jean Monnet ad personam chair in European tax law and policy at WU Vienna. He is an honorary professor at many other universities as well, and we're very happy to have him joining us from Zoom. So the question today, the question we're starting off with this first panel, is the question of liability for climate harms. That raises questions about who we're talking about, what types of principles, of legal principles we want to think about when we think about liability, and the kinds of harms for which certain actors will be liable. This then I think will feed into the discussions we have in the other panels later in the day, and of course the working group session tomorrow. So without further ado, I will turn the floor over to Professor Wagner from Humboldt University to talk to us about a tort duty of care to avert climate change. Professor Wagner.
Thank you very much for your introduction, and thank you to Alberto and the organizers for this wonderful conference and for inviting me to it. As you suggested, my focus is on tort law, liability in damages, in relation to climate-induced harm. And I will approach the question from the perspective of a torts law scholar. And in doing so, I'm assuming that even if there is a very serious problem, it is not necessarily the case that every sector of society or even of the legal system should and must provide an answer. If you break a leg, it's no use to eat vegetables, right? Even though it may be very rational to eat vegetables for other reasons, that's not the cure to the problem. So what I'm asking here is whether tort law is a cure to climate change. And so I apologize if I'm skeptical in several respects. That doesn't mean that I don't take the problem seriously. Maybe I just am skeptical whether tort law provides a solution. With that said, I remind you of a famous case, and the author of this judgment is in the audience, namely the Shell judgment of the Den Haag District Court in the Netherlands. And I mention it because it is a prominent judgment assuming that there is a tort duty of care to protect the climate, to mitigate greenhouse gas emissions. I guess most of you are familiar with the judgment. I won't repeat it in detail, but I want to say that it was based on a provision in the Civil Code of the Netherlands, which I reprinted here, and which refers to a duty imposed by law or by unwritten law regarding proper social conduct. And from that basis, the court inferred that there was an obligation upon Shell to reduce greenhouse gas emissions by 45% until the year 2030, and that includes Scope 3 emissions, namely emissions caused by the customers of Shell who buy oil products and then burn them in their cars or heaters or whatever. Now, let's approach the duty of care. I reproduced the exact language in the Dutch Civil Code, but actually this is not peculiar to the duty of care. It's more or less the same in all developed legal systems. The expressions differ, of course, the concepts are not always the same, but the basic idea is identical. So when I'm talking about the duty of care, I think it is apt and adequate not to distinguish between legal systems, because they are all on the same plane with a view to the basic ingredients of the duty of care. And of course, you may hold different opinions as to how to apply these principles or what to do with them, but that's not related to some jurisdictional features or idiosyncrasies. That's just differences in opinion as we have them in national legal systems anyway. So I don't distinguish between these legal systems. And I also acknowledge from the start on that the duty of care is a very broad and vague concept. You can basically do anything with it, or you can restrain yourself and not do it. But it allows for both options, so there is no right and wrong in the strict sense here. But there are certainly core elements and also limits to the duty of care. One is the scope of protection, the question which interests are protected. The second is that the duty of care embodies or incorporates an ex-ante perspective, the perspective of the actor at the time when he or she made the decision to act this way or another. Therefore, foreseeability of harm and technical feasibility of precautions play a major role. And even to the extent that precautions are feasible, they are not always required. They are only required to the degree of reasonableness, whatever that means, but there is a limit to precautions. And that limit, I think, and now it gets a little controversial, but I'm confident not much, it involves some kind of cost-benefit analysis here. However you frame that, whatever you include in this analysis, but it's a balancing of costs and benefits. So with that said, I think the duty of care may capture the most of climate change-related harm that is already caused and we must expect for the near future, namely infringements of the classic interests of individuals' life, health, bodily integrity, and personal property. This includes animals, ecosystems, and natural resources to the degree that they are located on private real estate. So if a private lake dries up, that may be property damage and may be recoverable under tort law. It usually, and that's not true for all the legal systems I'm talking about, but generally, in most jurisdictions, it does not reach pure economic losses. So, for instance, to the tourism on lakes and other natural monuments, and it doesn't reach pure ecological harm, meaning, for instance, animals, wild animals in the high seas or in forests or something. But these are fringe cases, if you want. It's more directly ecological, yes, but it's not true that natural resources are always outside the scope of protection because most of them are subject to private property rights. But it remains true that the climate as such is not protected. Now the duty element. I already mentioned that it doesn't require the avoidance of any harm, but only reasonable care to avoid this portion of the harm that would be unreasonable to incur. And this reasonable element refers back to elusive concepts in Roman law, the bonus pater familias, in common law, the reasonable man, or now reasonable persons. These are all empty shells, these concepts. They need to be filled with something else. You cannot apply the standard of a bonus pater familias without thinking more about the purpose of this area of the law and about other considerations. But what I said before, the ex ante perspective is essential to the reasonableness requirement. So it's an historic perspective that relates back to the time and the situation of action. And here I think an important distinction must be made between cases that look at future behavior of defendants, like the court did in the Shell case, where it was about what actors had to do in the future, and others, the classic liability situation, where the harm has already materialized, and the question is, who is accountable for it, if somebody is accountable at all? That's a different perspective, because the ex ante perspective is now, right, with regard to the future harm. And the liability perspective is historic, so you have to think about the situation in the 1960s, 70s, 80s, whatever the relevant time is. So I'm looking first at future emissions. Here, it is, I think, straightforward to say that as of today, the negative effects of climate change are foreseeable. And it's also true, as we all know, that there is technology and other means available to reduce emissions. The question is here, I think the main problem is by how much? And the Shell Court and other courts have done the same, usually refer to this goal of 1.5 or at most 2 degrees in the Paris Agreement, which itself goes back to IPCC recommendations about the zone where humans are not affected very much by climate change, 1.5 to 2 degrees. And from that number, you can compute a global budget for greenhouse gas emissions, and that then in turn can be broken down to individuals and corporations. That was the approach there. same in the German Constitutional Court with respect to state action, but here was applied to a corporation. And that has certain problems. One problem is that the Paris Agreement applies to states only and not to private entities. And that is not only a conceptual feature, but it poses serious problems of transposing this budget, which looks at the globe in total and then to jurisdictions, to national states, to private corporations, because their customers produce emissions in various jurisdictions, so they reduce the budget, not only in the Shell case in the Netherlands, for example, but also in Germany and in the UK and in the United States, everywhere where they do business and sell products. Furthermore, states have these budgets also for the reason that they should have leeway and discretion to allocate them differently across different sectors, for instance, industry, traffic, air traffic, land traffic, and also heating and use in private households. So this discretion is removed to some degree if you apply the Paris Agreement budgetary approach to private entities. And finally, the level of greenhouse gas emissions of fossil fuels differ greatly between coal, oil, and natural gas in descending order. So this is an extreme situation, and I don't think it's realistic, but you can imagine a case where Shell moves entirely to the production of and distribution of natural gas. That would help the climate, actually. And even if Shell itself, which accounts for around 2% of global emissions, would thereby increase its share, it would still do good to the climate because it would decrease coal production and oil production, which causes more carbon dioxide emissions on the part of other actors and corporations. And therefore, it's problematic, I think, to apply this budgetary approach, which goes back to the Paris Agreement, to the IPCC, not only to states, which is a problem in itself for some reasons that I don't want to go into, but also to private entities. So this is what I have to say on future duties to combat climate change. I think that it's much easier to argue in their favor because the ex-ante perspective is now and not decades in the past, but it has some problems which I tried to highlight in what I said before. Now, with respect to historic emissions, a threshold problem is foreseeability. And foreseeability does not mean that, yes, back at the turn of the 19th to the 20th century, the greenhouse effect was already known. There were physicists who did experiments, and you can replicate them in the classroom by using a greenhouse and then increasing the fraction of carbon dioxide, and then the temperature goes up. That was known. But whether that posed a serious problem for humanity or the planet, that was not known at the end of the 19th century, and it remained kind of in the bagheads of some specialists for decades. And it's also true that the realization that we really do have a problem didn't come out yesterday or today only, but years back. The question is, when exactly did it happen? Was it in the mid-60s, 70s, 80s? That's a matter of debate. If you look at the year when the United Nations took up the problem by establishing the IPCC, that was 1988. But it's a little bit an empirical question at what time the density of scientific findings on the effects of carbon dioxide on the climate was dense enough to say now it became readily foreseeable, not only for experts somewhere in the ivory tower, but for corporations operating in these sectors. And wherever you draw the line, and I'm not in a position to draw it now, I could, pull out some findings or studies and say, oh, this is the relevant point in time, but you would have to go back to the literature and study it for yourself. But wherever it is, there is no liability for anything that was caused before, at least not under tort law. Now, if we have that baseline, I mean, in terms of time, a date in time, then we have to look at the availability of precautions. So what else could energy companies and other actors have done to mitigate climate change from that time on? And here the problem is it's certainly no answer to say, oh, they shouldn't have emitted anything, because that's impossible. We all cause carbon dioxide emissions just by breathing, and every human activity, certainly every human activity that involves the consumption of energy causes these emissions, at least if the energy is produced from fossil fuels, which it used to be for centuries or more than a century, let's say. So it's not to say the optimal or the required precaution is don't cause carbon dioxide emissions. That makes it so difficult. And then the first thing to look at is, was there a reasonable alternative for these companies to produce energy from? And there was nuclear power. That became available in the late or mid-50s. Does it count against this precautionary standard? Is it reasonable to say to energy companies, you should have used more nuclear power? That's the historic version from the very controversial debate in Europe on the taxonomy regulation, namely whether nuclear power is green energy or just the opposite, whether it's even worse than fossil fuels. Difficult to answer. Now, if you throw out nuclear power for one reason or another, then let's look at renewable energies. They became available for private and industry use in the 1990s, and the boost for their development came from Germany when it enacted a Renewable Energy Act, which was meant to subsidize these forms of energy production in order to stimulate technological progress. And that's exactly what it did. And not only this measure, but it's usually said that the turn of the 20th to the 21st century with this legislation as a symbol marks the point in time when renewables became a serious option for energy companies for the production of energy in large measure. But that is rather late, isn't it? That means that we are now looking at the early 2000s, which excludes much of the damage that we are now looking at. Hydrogen, I just want to mention, is still in the making. It's a huge promise that it offers, but whether we will, at what point in time we will see a major contribution from hydrogen to the world's energy needs is still an open question. So if you buy that story that I'm telling, if you commit to the view that the availability of reasonable precautions at the historical point in time is relevant, then it doesn't look too good for claims for compensation of climate damages caused by historic emissions. Now, the basic way to circumvent this problem is to look not at precautions but at activity levels. To say, okay, maybe there was no alternative to fossil fuels, but then we should have consumed less energy and thereby have reduced carbon dioxide emissions. And that seems really to be the only strategy that was available back then to seriously mitigate emission levels. But then the question is, for our parents, did they behave in breach of a duty of care when they went on holiday by car? Is it really true that you can say that historic consumption was in breach of a duty that was incumbent on these actors back then. I think it's fairly easy to blame large corporations for their contribution because they are so large and their contribution is so comparatively large. But after all, what they did is they supplied the products and the services for a welfarist society that persisted for decades and still does persist. And to say that this, in retrospect, but from an ex-ante perspective, was negligent involves a stretch, I believe. And to me, it seems that there is more hindsight bias here than anything else. But that's certainly debatable. All of what I say is debatable, but this is most debatable. Now, if one looks deeper into this question, and then confronts it with traditional principles of tort law, then one thing is that usually courts start the breach of duty analysis by looking at industry custom, by asking, what do other actors in this sector do? Are they behaving more prudently? If so, that the behavior of the defendant may be found negligent or not. Is it just industry custom? And then if it is industry custom, that's not the end of the story. You can still question industry custom and say the whole industry misbehaves, but the threshold is a little higher. Now, under this measure, if you just take customary behavior as the baseline, then it's difficult to make out a case for breach of duty, as a high level of fossil fuel generated energy consumption was the norm, not only in market economies, capitalist societies, but the same in socialist, fascist, communist societies. And they are still, if you look at North Korea or the former Soviet Union, Chile, Cuba, India, Taiwan, mainland China, they're all built, all these economies of any economic order and model of society are based on fossil fuel consumption. That's nothing special to Western societies, to European or North American ones, but this is sort of the oil, the pivotal oil, proverbial oil that these economies are built on. So custom certainly does not help the case of finding negligence. And then there is another aspect here, regulatory compliance, whether the compliance with public law, administrative law, whether that is a defense to liability is very controversial. I think in general one can say it is not. Tort law can go further than public law and administrative law, but I think that is the right solution if you have certain behavioral requirements that may be outdated or may have been affected by lobbyism, other problems. So I don't want to go further in there. But here, with carbon dioxide emissions, I think it is a stretch to say that an activity that was not only permitted by the governments, but sometimes supported, fostered, pushed by governments in order to supply their economies with rich energy supplies, that this is a breach of duty. In retrospect, ex ante, I find difficult to say. Now you might say, and this is my last slide, and now I'm going a little bit beyond the pure duty analysis and ask the broader question, isn't it still reasonable to nail the carbon majors to the wall, at least? They had maybe superior knowledge. There are these stories that I think ExxonMobil had a study at hand which it commissioned itself back in the 60s, 70s, I don't know. So they're certainly not the good guys that deserve our compassion or consideration. That's an option, to only focus liability on carbon majors, oil, coal, electric power companies, the large automakers, and so on. But there is a doctrinal problem to this, because minimal contribution usually does not attract liability. That's not a duty issue, but a causation issue. There may be causation in the technical sense, but a 2% or less contribution would usually not expose yourself to liability. It's only because the damage is so large and that all other actors contributed even less that this is a thinkable option. A practical question, of course, is how large is large enough? 2% is a lot in comparison with regard to carbon dioxide emissions. But what about 1%? What about 0.2%? 0.02%, and so on. You must draw the line somewhere, and it will be very arbitrary. There is no rational answer, I think, to the question how small is small enough to be safe from contributory liability or proportional liability. And finally, there is a policy problem, and that brings me back to my introductory note, namely that tort law is not a solution to any kind of problem. And here, the introduction by our learned colleagues was impressive in appealing to our sense of responsibility. We have to do something, right? Okay, granted, we have to do something about climate change. Then the question is liability for harm caused in the past, is that a contribution to this kind of responsible behavior towards climate change? And I'm not sure about it. Of course, liability for harm caused in the past generates incentives to take care now. But if the harm in the past was not foreseeable at that time and there were no reasonable precautions available, then imposing liability retroactively does not make matters better, except for the compensation and justice rationale of tort law, that you may argue that it's fair to compensate the harm, but it doesn't do any good to improve the climate. That's different with a forward-looking obligation, of course. If you impose obligations not to emit now, that, of course, has a climate effect. But I'm here only talking about holding companies financially liable for harm caused in the past, which at that time, I assume, they did not foresee. That wouldn't have a preventive effect and therefore wouldn't help the climate much. Thank you.
Thank you, Professor Wagner. A very interesting, very provocative first presentation. You set us off with an excellent start here. I know there are going to be a lot of questions and comments on Professor Wagner's presentation, but if you could please hold those, we will go through the other presentations and then we'll come back to the discussion. So now I want to turn it over to Professor Marc-Philippe Weller from Heidelberg University to talk about climate protection and corporate governance. Professor Weller.
Yeah, thank you very much, William, for the kind introduction. Thank you to Alberto, Henrik, and William for inviting me here to this interesting conference. Sophia Schwemmer from Heidelberg is just providing you with a short handout with the outline and some provisions. Gerhard Wagner just talked about the question if tort law is necessary to cure the climate challenge. And I would now like to make a focus on another field of law, company law. And I do not want to discuss if it's necessary to cure the climate challenge, but I would like to show how it is used by the legislators, the European and the national ones, to help to cure the climate challenge. Well, the starting point are the Sustainable Development Goals of the United Nations. And as you know, the goal number 13, climate action, obliges the states to take urgent actions to combat climate change and its impacts. And the states are addressing the climate issue on different levels, perhaps not on the tort law level, as we have just heard, but as we will see, on the company law level. I would first show you the development from the shareholder value approach to corporate social responsibility and environment social governance, ESG, and then give a little overview about the status quo of climate action in company law, which are the instruments already applied, and which will be, in the future, probably instruments which the legislator, especially the European one, are discussing with regard to the board of directors, the supervisory board, and the shareholders. The development started with the Chicago School. The starting point, Milton Friedman, all know his prominent phrase, the social responsibility of business is to increase its profits. And the so-called shareholder value approach was the dominating approach in the 1970s, 1980s, and 1990s. There was a little bit switch in the discussion beginning with the millennium. There, the stakeholder aspects were discussed. However, it took a while until there were legislative acts in this respect. We had the first one in 2014 of the European Union, the Directive on Corporate Social Responsibility with a non-financial statement. And then you see two more examples from Germany, the gender quotas, which has nothing to do with climate, but with the social responsibility, as well as the Supply Chain Act of last year. And what I want to demonstrate is that at the beginning, the dominating aspect was the social responsibility. That means the focus on the human rights aspect. The climate was only a subtopic of these human rights. However, beginning with the Paris Agreement, especially, Gerhard Wagner mentioned it already, we had more intense discussion on these climate aspects, which induced a switch to another term. Now we are talking about environmental social governance or environment social governance, ESG. That means the climate aspect is now more prominent. It was a subtopic of social responsibility. Now it is on the same level, on the prominent ESG level. So in the literature, there's already, this development is characterized by the politicization of the corporation. That means company law helps to solve societal problems, like the gender problem, but also the climate problem, via company law. So what are now the instruments of climate action in the domain of corporate law? And I would like to give you a little overview of that. The first pillar is the climate reporting. The climate reporting can be traced back to the CSR directive with the non-financial statement. And in this non-financial statement, companies have also to address greenhouse gas emissions concerns. However, this was a very weak, from a regulatory point of view, a very weak instrument, because there's only a so-called nudging function. It was based on a comply and explain mechanisms that mean that companies can be dispensed when they justify their dispense from this non-financial statement. And this now is to be changed by the European Commission. The Commission proposed a renewal of the CSR directive, and it will be called Corporate Sustainability Reporting Directive. And what is new in this succeeding directive? It is a switch in the focus. The first switch is that now the term sustainability is more prominent in the directive. Sustainability in a double sense, in the social and in an ecological sense. And what is more important, that the scope of this directive will be enlarged, increased considerably from, at the moment, 500 companies in the European Union to 15,000 companies. That's really a huge increase. It will be legally binding. That means there will be no comply or explain approach anymore. And there should also be an assessment through an accountant firm of this statement on sustainability. This is the first pillar. The second pillar, and this first pillar is also in line with international developments. As you can see here, the SEC in the US issued an order for listed companies, the New York Stock Exchange, that they are obliged to report on the scope 1, 2, and 3 emissions. In the UK, we have a similar approach since 2019. So this is the reporting approach. The second pillar is the green finance pillar. It goes back to the Commission's action plan of 2018 of sustainable growth. And there is already enforced the taxonomy regulation. Gerhard Wagner talked about it with regard to the nuclear discussion, if nuclear energy is a green energy, because this taxonomy regulation has the aim to flag out ecologically sustainable businesses. And the idea of the Commission is to link this taxonomy regulation to the new Sustainability Reporting Directive. And as you remember, the Sustainability Reporting Directive will have a much larger scope of application. That means that also the taxonomy regulation will profit from this larger scope of application, so that 15,000 companies will have to comply with this taxonomy regulation. Then there is a second regulation, this is called Disclosure Regulation, which shall inform financial market participants about green financial products. There is an interlinking of these two regulations in the green finance sector. The third pillar, and this is new, is a new due diligence obligation, a new duty of care, but not in the sense of tort law, but in the sense of company law. And this new due diligence obligation shall be introduced by another directive, which is named Corporate Sustainability Due Diligence Directive, not reporting, due diligence directive. And there is a draft from the Commission, which is a few weeks old. The main focus of this directive are the supply chains, the international supply chains. We have regulation in Germany and France, but not in the entire Europe. That is the main focus. However, there is an interesting article, and I would like to draw your attention on it. It's the Article 15, and you can see here it's named Combating Climate Change within this supply chain directive. And here there will be a link of the human rights discussion and the climate change discussion. The companies are obliged to adopt a plan with their business model and strategy, and, important, they have to show how this business model is in line with the Paris Agreement. And you remember what Gerhard said? Gerhard, of course, said that the Paris Agreement is a public international law agreement which only binds states. And here, via this directive, if it should be adopted, this Paris Agreement will also be relevant via private law for companies. That's an interesting shift. The question is if it's a good idea to apply the budgets, the CO2 budgets, which are designed for states, to companies, but you can see here that there is a clear interlinkage between the human rights discussion and the climate discussion. The fourth pillar, we'll discuss it later, is the climate litigation. We have prominent actors here in the auditorium. We have the public climate litigation, that means the litigation from NGOs via states. Urgenda was the first prominent case. In Germany we had it too. We have the private climate litigation, the Shell case was already mentioned, from private NGOs to private companies. And I would like to draw the attention here on this aspect, the corporate climate litigation, which is now new on the agenda. And we have a first example from the UK, from the NGO Client Earth. And they are taking legal action against not the company, but the board of Shell for mismanaging climate risk. And the argumentation of the NGOs of Client Earth is that they failed to adopt a climate strategy, also with regard to the Hague judgment. And the legal basis are the sections 172 and 174 of the UK Companies Act, that are the duties of the directors, which are argued that they were breached here by Shell. That's an interesting move. It's not tort law now, but it's this similar reasoning with this duty of care now here in company law, which is addressed here in this corporate climate litigation. So if we make a short interim assessment, we see there are a lot of developments. We have in the field of climate reporting, also in the green finance aspect. Really new is the climate due diligence, the new due diligence obligation, and the climate litigation. And I think we can already now say that we have a far-reaching transformation process of company law, at least, of company law. And in the following few minutes, I would like to show you some implications of this transformation process for the board of directors, the supervisory board, and the shareholders. Let's start with the management. As we have seen, there is a new due diligence obligation, and we can speak here of the climate compliance obligation. In this aforementioned Corporate Sustainability Due Diligence Directive, we have it explicitly named here, the director's duty of care, which also now are extended to climate change. This is the directive of the supply chains, but as we remember, the Article 15 makes the linkage to the climate discussion. The second question is if climate protection can be taken into account as a corporate objective. In Germany, we are discussing also to introduce a new legal entity, a new corporate form, which would have sustainability as a corporate objective. Well, there is an advisory council to the German government, Sustainable Finance Advisory Council, and this council proposed an amendment of the existing Stock Corporation Act. And at the moment, the board of a company is obliged to manage the company in the long-term interest of the company, and now it should be amended with the addendum with due regard to sustainability objectives. That would then oblige the management to take into consideration the sustainability with every business decision they are taking. A similar proposal from this advisory council is going, or is with regard to the business judgment rule. The business judgment rule, as you know, is a safe harbor rule for business judgments of the board of directors. And here, the sustainability aspect shall also be introduced. The safe harbor rule only will work if environmental sustainability risks are taken into consideration when the business decision is taken as one aspect which has to be taken into consideration. This would also be a new aspect. The fourth aspect concerning the management is the remuneration. You know, the board of directors usually has a variable remuneration, and of course you can link it to climate reduction objectives, for example. In the literature, here a proposal from Oxford, Armour, Enriquez, Wetzer, they are talking about green pills. That means sanctioning the non-achievement of emission reduction targets through penalty payment. But even if you don't introduce such green pills, of course you can link the remuneration of the board to the climate improvements. Let's now look at the supervisory board. In Germany, we have a two-tier management system, board of directors and the supervisory board. In Italy, you have it too. You have both options, I think. And the supervisory board has to monitor the board of directors. And of course, if the board of directors has now the climate compliance obligation, then the monitoring obligation of the supervisory board is extended to this obligation. And the German Corporate Governance Code, which is a soft law instrument, this code stresses this aspect of monitoring sustainability aspects by the supervisory board. What is becoming more and more important in practice are the sustainability committees within the supervisory board. The supervisory board, which contains about 20 persons, can establish committees within the supervisory board, and a new committee in this aspect is the sustainability committee. It is discussed in company law, in German company law, if the climate expertise on the supervisory board should be mandatory. At the moment, the German Stock Corporation Act requires only a competence in the field of accounting, but it is discussed now to introduce also an expertise in sustainability or sustainability reporting on the supervisory board. Let's finally turn to the shareholders, probably the most important drivers of this evolution. And here we have already large institutional investors like pension funds, which are following a sort of stewardship policy and invest only in green businesses. Here an example of the New York State Pension Fund, one of the largest institutional investors worldwide, who established such a new policy. It would be a soft transformation by this green finance investments. A more dogmatic discussion is if you can introduce the climate protection in the Articles of Association as a corporate purpose, as a statutory corporate purpose, and of course the shareholders can amend the Articles of Association by a 3/4 majority. And however, according to German law, there are some limits of this freedom to integrate the climate protection as statutory corporate purpose. We have the so-called autonomy of the executive board. They need a certain margin of discretion. And we have a nice example, not with regard to climate change, but with regard to the automobile industry. There was the idea a few years ago to introduce in the Articles of Association of Mercedes-Benz the prohibition to produce certain types of cars, especially the Maybach and the Smart. You probably know them, the big one and the little one. And the higher regional court in Stuttgart said this was too far-reaching, such a concretization of the statutes of the company, of the Articles of Association. That means you can include climate protection as an aim in the Articles of Association, but you can't concretize too much the concrete goals. The third aspect with regard to the shareholders is what is called the shareholder climate activism. And here, when we look at the US, Klaas Lewis counted in the last proxy season 530 resolutions in general assemblies of US stock corporations, resolutions with regard to climate aspects. And we have here an example of Chevron. Here there was a proposal brought by the investor Follow This, and this proposal was voted to encourage the board of directors of Chevron to reduce its emissions. And in the US, it's the most dominant aspect of the General Assembly season. Now the question is it transposable to Europe, this development? In Germany, as we have this two-tier system, governance system in the stock corporation, it is not possible for the shareholders to initiate such proposals or such resolutions. Shareholders have only the right to ask questions, but they do not have a decision-making authority with regard to business decisions. Only if the board of directors asks the shareholders, they can decide on business decisions, but they can't take the initiative. The same holds true with regard to shareholder actions, which we have seen in the UK with Client Earth. In Germany, there are high hurdles, also due to the two-tier board system. You need a 50% majority of the shareholders to initiate such a shareholder action. It's not possible for a single shareholder to initiate such an action. But some shareholders are tricky, and there is they try to discuss the climate issues in the shareholder assembly, and a way to do this are very technical requests for additions to the agenda of the general meeting. This is possible with regard to structural measures because the shareholders are competent to vote on structural measures in a company. And we have a very prominent example. A few weeks ago, there was an investor called Encraft, which wanted from RWE, which is a huge energy company, you probably know it, which wanted to, which asked for a spin-off of the coal division of RWE. As you know, the main aspect of RWE is the coal, and this investor asked to prepare a spin-off of this coal division. This motion was dismissed by the majority of the shareholders, but you see there are such tries to discuss climate aspects on a general meeting. And that leads me to the last point. It's the so-called say on climate discussion, which we have in German company law at the moment. The say on climate vote is also coming from the US, these motions I mentioned in the shareholders assembly. What is meant by say on climate is a consultative vote. It's not a decide on climate issue, but it's only a consultative vote, but of course, which has an importance for the board of directors. And we have a already existing example in the German Stock Corporation Act, is the so-called say on pay. That's the vote of the shareholders on the remuneration of the board of directors. It's not binding. It creates no rights, no obligations, but of course it has a factual impact. And in analogy to the say on pay, it is discussed in the German literature to introduce such a say on climate provision. The alternative would be to introduce it on the soft law level of the German Corporate Governance Code, and here we have a proposal by the German Company Law Association that the management board should submit such a say on climate vote to the General Assembly if 5% of the shareholders request this vote. That would be a sort of compromise, and this proposal is discussed at the moment. I would like to conclude. In the US, the question was raised if the law of the corporation is the new environmental law. Perhaps it's going in this direction. However, it's always necessary, or the whole discussion on stakeholder approach shows that there are a lot of interests with regard to companies. That means that we have to balance these different interests. Also the climate protection interest has to be balanced. Here an article from the Financial Times which argues that ESG topics are important, but they have to be balanced at the moment with regard to the Ukraine conflict with energy security as another essential interest. And indeed, if we come back to the Sustainable Development Goals, we see that there are 17. We talked about the goal number 13, which is certainly one of the most important ones, but others are important too, and that means are the corporations, what is the correct approach for corporations? And we have here a proposal, a prominent proposal of Hart-Zingales in the literature. They are arguing in the favor of including or activating the shareholders for broad outlines of corporate policy. That means not only with regard to climate change, with the say on climate, but with general broad outlines of corporate policy. And I also would say, if we introduce such a new instrument, we should introduce it not only with regard to climate, but with the general topic, environment, social governance. There are good reasons for activating the shareholders. They are the owners of the company, and they should also be able to decide about the correct direction. Thank you very much for your attention, and I'm looking forward to this discussion.
Thank you, Professor Weller, for that excellent presentation. A lot to think about there. So we started with tort law. We've now done company law. Now we're going to talk about taxes. So our third and final speaker on the panel here is Pasquale Pistoni from the University of Salerno, who will be joining us by Zoom to talk about fair global taxation and the environment.
Thanks very much, William. I hope you can hear me.
Yes, we can hear you.
Okay, I'll share my screen. So let me, let's see if you can see my slides. Can you see my slides?
Yes, there we, yep, perfect.
Yeah, I've put them in the, yeah. Okay, so I think it's quite important for me to start by thanking the organizers, Alberto, Henrik, and William, for including tax in this panel and in the overall research that you are about to work on. And that is because normally tax works like a black box and is not always taken into consideration at the international level when we discuss technical issues. And that also applies to matters related to the environment. So if the overall question of this session is to understand to what extent we can hold somebody liable for polluting the environment, then here the issue is not just doing that from a tax perspective, but also understanding that it is unclear from a tax perspective to see who is to be held liable for the contamination of the environment. And that is because to one extent we have business which pollutes the environment, and on the other hand, as Professor Weller already said, states have an obligation under UN SDG 13 to do something in order to protect climate, to do something against climate change. And the problem is that companies relocate. So in the points that you see here on the screen, I will go through these points, and I hope that this will be giving you a sort of preliminary idea of what the issues are from a tax perspective. Now, when we talk about tax, we have to understand that taxes are levied for the purpose of funding the budget and also for the purposes of intervening in the behavior of, let's say, players or stakeholders with the so-called incentives and disincentives. And these are the so-called regulatory goals of taxation. So essentially, with those types of measures, you deviate from the equality and try to nudge some desirable activities or behaviors, or to discourage somebody from doing something that is undesirable. Now, it's really important to understand that these are two separate goals and that sometimes we mix them up. And that is something which, in my view, is rather critical, because we often use the exploitation of the environment as a source of revenue, but in other cases, it's just an object of protection. Now, if the protection of the environment is the object of some regulatory goals measures, then we need to make sure that whatever is collected through those taxes is earmarked to the environmental protection. Otherwise, we just increase the state budget with those taxes, and it's a kind of compensation for the fact that you pollute the environment. Now, at the international level, we have to understand that generally states are not free to exercise their taxing powers in a general way. They need a nexus. And the nexus is really important to understand whether they are exercising their powers in line with the principle of territoriality. We don't understand territoriality just based on the objective nexus, so where the event takes place, where the taxable event takes place, but also based on the connection of a taxpayer. So when we talk about groups of companies, we go beyond territorial-based taxation, but that also applies to persons, private persons and individual, because we try to make sure that the overall tax burden complies with their ability to pay. Now, recently, there have been important efforts of international coordination, which will be important also for my presentation here this morning. I want to make one caveat, and that is, if we are dealing with regulatory goals of taxation, so discouraging some behaviors, then international double taxation, so two states taxing something, is actually not necessarily bad, because you want to discourage some undesirable behaviors. However, at the same time, if you want to encourage some behaviors and the interference by another country, which creates some form of repetition of the exercise of taxing powers, that is not as good. Now, let me go to the second point. As I said, there have been attempts to create a coordinated bilateralism during the past few years in the field of international tax law. And the main conveyor of that coordination is the OECD, which is currently shaping what we call global tax governance. And essentially, global tax governance is making sure that at the global level, states coordinate their exercise of taxing power in a way that pursues goals that are desirable. And I have given you some examples where states' interests are aligned and some examples where states' interests are not aligned. So if we look by the ones which are aligned, we see that there is a common fight against multinational enterprises not paying taxes. There is a common goal of enhancing tax transparency, and that is basically making sure that tax havens disappear and that tax authorities can exchange information on tax relevant matters. But then there is also environmental protection, which is a common goal. So in principle, we can say that the UN SDG 13 is something which could go in a direction that is globally desirable. But I want to say that this is something that I will focus my attention upon because it is more complex than it appears prima facie. Now, there are other areas where states are having different priorities, and that's basically because countries want to tax as much as possible. And also the fact that for some countries, economic development is more important than for other countries, and this may imply some problems of priority when it comes to determine how we fight climate change from a tax perspective. What I find extremely important, and this is something that has not been researched yet sufficiently, is that global tax governance goals may not justify unfair measures. So if we have a globally desirable goal, it's not fair that some states impose their will on all others, because the fact that something is globally desirable does not give those countries any legitimacy to impose their solution on the others. And this is something which I find it important. Elly Schlein before was talking about the climate refugees and the fact that some countries do not produce climate change but bear the consequences. Now, here the point is that some countries in the world have stronger energy needs, and for that reason, we pollute the environment more, and we only have one planet. So when it comes to see what we can do with taxes to create a fair and sound global framework, I think that we should take into account those differences. Now, I think that from a national perspective, it's quite clear. If we pursue regulatory goals, it's okay to apply more burdensome or less burdensome taxes and deviate from equality. But at the international level, things are much more difficult because if we increase environmental taxes in one country or block of countries, then business may simply relocate and pollute elsewhere, but the planet is still the same. So this is very problematic. And also, as I said before, some countries have stronger needs to foster economic development, and sometimes they are more tolerant towards pollution, and in particular, they welcome polluting business. And that is something that we, from the countries producing the pollution and the climate change, we have to be accountable for. This also means, in my view, that there could be a way to justify, from a global tax fairness perspective, what I call a different toll for different countries. Now, here I see that the position of developing and developed countries differ, because, essentially, if we need to have a strongly polluting business, and that business is no longer accepted in a developed country, then it relocates to a developing country. But then the problem is that from a tax perspective, if business relocates, the developed country is unable to exercise its taxing powers except on what is repatriated. And as I said, developing countries might see polluting business as a way to promote their economic development. And then, of course, I think we have to be very specific. Most of the world produces in China, and I am not too sure that China has committed to compliance with strict environmental standards. Now, I think it's quite important to say that if we look at who should bear the burden of climate change liability, I think that developed countries should do that to a greater extent than developing countries. But then, as I said, the situation of China is potentially different, because China is certainly not a developing country, or not any longer. Now, this basically means that developed countries must make sure that products which originate from countries that contribute to climate change have to be penalized. And it's easy to say, but it's more difficult to do in practice. I thought that it could be interesting for this brainstorming conference to focus on the so-called border tax adjustments, because this is something that the European Union is currently discussing. Now, with border tax adjustments, essentially you alter competition and you create compensatory levies that could be potentially incompatible with free commerce, WTO, and similar other international legal agreements. But the point is that there could be ways to justify if we pursue general goals of environmental protection. And here I want to stress that not all taxes are the same. At the beginning of my presentation, I said some taxes pursue regulatory goals. If those taxes are earmarked, so what we collect through those taxes stays within environmental protection, then I think it would be easier to support this type of intervention. But let's look more concretely at the carbon border adjustment mechanism by the European Union, which was proposed on the 14th of July last year within the framework of the Fit for 55. And this is essentially a border tax adjustments at the external borders of the European Union for goods that originate from countries that do not comply with the EU environmental standards. It applies to some types of business, which I have listed on the slide. But the interesting feature is that the CBAM is meant to turn for 75% into an own resource of the EU. Now, this basically means that the CBAM is potentially, at least from a mixed perspective, an instrument of tax collection rather than something that necessarily is characterized as a tax for regulatory goals. So the idea is that if we make the revenue collected through CBAM, if we turn it into an own resource of the EU, we minimize regional arbitrariness within the European Union and reduce the nexus issues. Whatever is brought into the EU will be liable to that CBAM to the extent that it comes from countries that do not comply with the environment. But then here the idea is also that the way in which this operates could raise some issues of extraterritoriality, because it's levied on the exploitation of the environment outside the EU, and it funds the EU budget. So this is a bit tricky, and from my tax perspective, we need to understand if it is a tax, and there are different views in this respect, and if it is a tax, if it is done for revenue collection purposes or regulatory goals. And the point is also understanding whether and to what extent this measure is globally fair and how we can make it fairer, because the point that I want to make is that the EU gets extra revenue out of the fact that business pollutes other parts of the world. So is it really fair that the EU, to prevent business from relocating, gets extra collection of tax? And here I want to make a comparison with another proposed measure, which is the so-called Global Corporate Minimum Tax, which we call GloBE. Again, the EU wants to prevent, in this case, the tax race to the bottom of multinational enterprises by applying a minimum corporate tax of 15%. So whenever business is not taxed at 15%, then it will be topped up by this tax in order to make sure that there is some regulated competition. Again, also this can be an EU-owned resource. So it is something which also funds the EU budget. These are measures which have not been approved, and the GloBE was rejected by Hungary a couple of weeks ago. But the point that I want to make is that both in the case of the GloBE and of the proposed CBAM, we have the EU making extra collection of tax out of things that happen outside of the European Union. And I find rather disturbing that essentially this, what is collected through those taxes, which currently do not apply, they're still at the level of proposal, is that it stays within the European Union. I don't find it fair. I think that this is potentially problematic. If we want to help those countries with the mechanism of earmarking, we should do something that could be, I say, returned to those countries whose environment is polluted. So we give them no chance to be indulgent towards the companies that pollute more, but also we give them money back. And this is something which, in my view, can be fairer from an environmental perspective, but also from a tax perspective. Otherwise, Europe pollutes the world and Europe gets extra money from that. But the idea is that if we only have one planet, we should meet our responsibilities for business relocation and also the fact that they pollute the rest of the world. So this is essentially to show that in my point of view, from a tax perspective, when states enact UN SDG 13, they have to go beyond the fact of discouraging relocation, and they should not indulge in forms that essentially lead to hidden tax protectionism. In other words, if we impose this tax and we compensate lower taxes for products coming from countries that tolerate pollution of the environment and that contribute, in that case, more to climate change, then business can also say, why bother going to Vietnam if Vietnam doesn't have that infrastructure that Germany has? If I am anyway taxed in the same way, I would rather just stay in Germany. And one can say that is also one goal. So in other words, that we don't pollute the rest of the world, but we pollute Europe. But I think that if we want to discourage relocation, we should also avoid that the mechanism turns into something that makes the poor help the rich. Thank you very much for your attention.
Thank you, Professor Pistone. Excellent presentation. We now have almost half an hour for some discussion. So I hope that you were all formulating questions or interventions, and maybe if you could just introduce yourself, please, here in the front row.
Thank you very much.
Do we have a microphone, perhaps?
Well, thank you very much. My name is Eva Maria Kieninger from the University of Würzburg, and I have two comments relating to the first presentation given by Gerhard Wagner on climate change liability. Well, the thrust of his argument, which as always was very compelling, of course, was that for historic emissions, we all did the same thing. We issued CO2 emissions, some people more than others, large companies, oil companies, fossil fuel companies more than the individual, but basically we all did the same. We turned a blind eye on what we were doing, what the effects were for the global climate, and that's it, and nothing can be done about it, and we have to look into the future. How can we tackle the problems that we have created ourselves in common, so to speak? And my argument as far as the so-called historic emissions are concerned is that they are not just sort of seeking compensation for something that has been done in the past. That's right, but that's only half of the truth. The other half is that the money that has been claimed and is being claimed, for example, by the Peruvian farmer in the famous RWE case, is money that the farmer wants to use for adaptation measures. And climate adaptation, we have not talked about climate adaptation. The climate change is there. The CO2 will not disappear from the atmosphere in the next hundreds of years. And so we have to live with it. And why is it not fair to make the carbon majors pay, at least in part, for the adaptation that needs to take place, not so much, but also in Europe, but also in other parts of the world where the nature is even more vulnerable than it is here. That would be my first point. And my second point is that you also said something about foreseeability, and that one may doubt, and about the responsibility of companies for what has happened. And one factor that has been left out for time reasons, I suspect, in this discussion was the fact that it's very, very well documented that fossil fuel companies, to a very large extent, participated in disturbing policymakers and scientists and the scientific community from doing their job in the past decades. And I'm just citing one small paragraph from a publication by Greenpeace. And there it turns around ExxonMobil and what they were doing in the US. And for the year 1989, it says, Exxon and other fossil fuel companies created the Global Climate Coalition. This coalition is created to oppose mandatory reductions in carbon emissions by obscuring the scientific understanding of fossil fuels' impact on the climate. The coalition created a scientific background for lawmakers and journalists that claimed the role of greenhouse gases in climate change is not well understood. That happened in 1989. So I would say that the large emitters played an active role in preventing action when the climate change, the dangers from climate change were already scientifically known. And that is one of the reasons why, in my view, they should pay damages.
Professor Wagner.
Yes, thank you, Eva Maria, for these questions and comments or disagreements. I acknowledge that some of the claimants that are visible already will use the monies paid as compensation for adaptation measures, and that's fine, and I don't have any problems with that. I just think that in itself does not generate a claim, and that is not something which may be taken for granted. I see no way to say, okay, there is a claim for monies that are needed for adaptation measures, but no compensation otherwise. So it's a either or, in my view, with regard to the duty of care, and therefore I wouldn't know what to make of this in itself, other than what I already said. And that brings me to the foreseeability issue, but they're linked in one aspect. First, I have to say, I didn't commit to any particular point in time. If there has been misinformation caused by energy companies, I take that into consideration, and I wouldn't think that they had the ability in a normative way to postpone the point in time when climate change became foreseeable by just funding or otherwise instigating studies that called that effect, the greenhouse effect, into question. But 1989, for instance, is rather late. I was just saying there is a point in time beyond which, looking into the past, there is no foreseeability. Wherever that point is, I don't know, but it seems to me it's rather recent. But there's one more thing, and that is I see the so-called carbon majors not so much as the bad guys in the room who for profit sacrifice the interests of others, but I see them as representatives of us. I see them as those that enabled us and our parents to lead the lives that we got accustomed to travel for a conference in other countries, to spend holidays somewhere on the planet, to consume all kinds of things, to have fancy cars, and all this stuff. And this is something that, looking at past emissions, these profits largely went to consumers, to some degree also to their shareholders, but not excessively. The main benefit was to consumers of welfarist societies. And we can debate the question whether we as welfarist societies owe a duty to countries in the global south that suffer from climate change, that we help them in financing these measures that you were talking about and adapting in many other ways, or compensating them for lost lands that are livable and so on, habitable, I mean. But I'm not sure whether I buy this story that there are these bad companies that did all this to the planet and to us. I think it is a feature of welfarist societies that these companies helped to bring about or to support, but it's not their invention, and it wasn't only to their benefit, it was to ours.
Very interesting exchange. More questions or interventions from anyone? Yes, Henrik.
Right, thank you very much. And I don't think I should introduce myself. You saw me before. I have a comment to Gerhard Wagner, and I have a question for Marc-Philippe Weller. The first thing, the comment is not too much about Gerhard Wagner's presentation, but I like to put it into a perspective also. And we heard Gerhard Wagner talk about tort law, whether it can apply to climate situations. And as I heard you said the duty of care would not apply to the climate itself, but it could be used in respect of protecting animals who are harmed because of climate change. So, and what I find very interesting with that is, if I'm going to move this away from tort law into public international law, the relationship between states and perhaps also some corporations who are acting under special permission granted by the state, we will probably see a different picture here. Because under public international law, we would say that states, they must not cause transboundary harm to neighboring states. But that has been extended to also harm caused into res communis, which is the land where there's no owner to it. That would be, for example, the high sea, or that would be in space. So there's a whole space law that's developed from that idea that harm caused by a state, it will also concern not only neighboring states or their territories, but also these areas where there are no owners to them, common areas. And that would, in my view, from a public international law perspective, also include the climate. So that's what I find very interesting, a difference between the tort law approach and the approach from public international law. That was the first thing, and then the question I have to Mark Philip Weller, that is about this reporting system that is going to be established. How is that going to work in practice? Will corporations have to report back when they make the annual accounting reporting, or do you know how it's going to work in practice, and who will they report to? Thank you.
Yeah, thank you, Henrik. Yes, the climate reporting is on the annual reporting basis, indeed, the annual reports, and they have to include in these reports then an aspect on sustainability. That's the idea. And within these financial reports, there is this non-financial explanation on sustainability, and this will also be assessed by the accountant firms within the annual report. And then, of course, it's published, this report, and it's published especially for the capital markets. And they, together with the green finance idea, then they can decide if it's a green investment, for example, and invest in these companies.
Thank you. Other questions or interventions? Gerhard, please.
Thank you so much. I have one question to Professor Pistone. Thank you very much for this interesting outlook on tax law. What I was grappling with this border tax adjustment mechanism, which in my view was a great invention to enable the EU or the Europeans to push ahead with regulation and all kinds of cost-intensive measures in the interest of climate protection without sacrificing their own industry, which would have to compete against others where no such duties applied. And so to adjust sort of the level of cost-intensive duties to protect the environment or perhaps also human rights is a smart idea. Whether it's workable is another question, but conceptually I think it's very smart to have a level playing field for the products and services offered in this market. We're not trying to govern the whole world, Brussels effect or something like that, but to say in our market we require a certain level of environmental protection, and if goods and services come in from other jurisdictions which do not comply to this standard, we add the costs saved in production in order to provide a level playing field. So what I want to ask you is, isn't it true that this adjustment mechanism goes much beyond the objective to avoid carbon leakage by relocation to countries with low standards? But I was thinking rather it enables the European Union to impose an ambitious standard of climate protection without leading or instigating a race to lower prices in the market where goods and services from other jurisdictions are imported. A second question I have for Mark. The first directive on corporate social responsibility, I must say, I understood the approach of saying we have to increase transparency for shareholders, and then the capital markets, the financial markets, will select the shares that shareholders like, And they do this, or it enables them to do this not only with a view to financial return, but also with a view to ecological concerns. Great. But if I'm not mistaken, this new directive has thrown out this approach, but uses the same tools for a different end, actually. Why should I inform shareholders about efforts on sustainability and so on, if the law requires me to do it anyway? I mean, not to inform, but to implement the measures. Isn't that something which is incompatible to, on one hand, label this as a kind of transparency thing, you know, a corporate reporting measure, so it's for shareholders, their decision to invest or not to invest, but at the same time impose substantive duties to comply with certain ends that have nothing to do with shareholder information, which are rather the other way to regulate the same thing. And isn't there a tension there, and what would you make of it?
Great, thank you. Professor Pistone, you have the floor.
Yeah, thanks very much. I want to make it clear that I think that CBAM is a good mechanism. And let me make a comparison with customs and also dumping and countervailing duties. Now, CBAM is meant to promote worldwide protection of the environment and to stop the tolerance towards polluting business. So basically, as you rightly indicated, if you want to sell your goods in Europe, there is no chance for you to have them produced somewhere on the same planet where you are allowed to pollute. What I think needs some further thinking is that we are in fact using this pretty much in the same way as we would use customs, or we would increase customs duties in order to prevent that there is unfair competition. And the way I see this is that if the ultimate goal is to protect the environment on the same planet, we should find ways to share what we collect also with the countries whose environment is being polluted. So in that way, at least, we will not get extra revenue, because I am okay with the idea of the border adjustment mechanism. I am not okay with the fact that we will be richer because of this. So that's how I would formulate that. But as I said, this is something which could be meaningful to research in an interdisciplinary environment. Thank you.
Thank you. Professor Weller.
Yeah, thank you, Gerhard, for the question. Indeed, we have on the one hand the reporting issues with the existing Corporate Social Responsibility Directive and with the taxonomy regulation. This fits together with the green finance. And on the other hand, now that's the second new directive, the Corporate Sustainability Due Diligence Directive. And historically, or with the background of this second directive, the background are the supply chains. And now they introduced in this supply chain directive, they introduced this Article 15, which is indeed a little bit strange or a foreign aspect to this supply chain aspect. And as you said, there is a sort of tension. Yeah, it's only a proposal. It's not adopted yet, but we will see if it comes. And indeed, it would be another different approach, which has nothing to do with the reporting and financing approach.
So I have another question for you, Professor Weller. Going back to your example of the shareholder proposal for RWE to spin off its coal unit. One phenomena that we see in the United States now is that the pressures for ESG for public companies are such that some companies are shedding assets, and those assets are now ending up in the hands of private equity companies. Some of these could end up in the hands of state-owned oil companies, and so there's a concern that some of these pressures could be creating, capital market dynamics where the fossil fuel assets that we're concerned about end up owned and controlled by entities that don't have the same obligations that public companies have. So I'm interested in the kind of story, as you see it, around that in Europe, and the extent to which, say, if RWE did sell its coal unit to some other entity, that doesn't solve the problem. In fact, it could make things worse, actually, right?
Yeah, thank you, William. Indeed, that can make things worse. That was also the argumentation of the board of directors of RWE, and that was also the reason why it was not, didn't got the majority, this motion. Well, the idea is not to introduce such binding votes of the General Assembly, because this move here from Encraft, from this investor, would have been a binding decision for the board of directors, but to introduce this say on climate votes, which are consultative votes, non-binding votes, with regard that there might otherwise be too many pressures or also other interests behind which are not serving the climate protection.
Thank you. So I want to go back to the exchange between Eva Maria and Gerhard here a minute ago, unless anyone else has an intervention or a question. Gerhard, what I heard you saying at the end of your remarks was that we as consumers in the rich countries have benefited substantially from fossil fuels, perhaps more so than the shareholders and the managers of the fossil fuel companies. This is what I heard you saying. Therefore, if anyone has an obligation, it's we as consumers, not so much the carbon majors. But I don't see those as necessarily mutually exclusive. It seems to me you could argue that the large companies also have obligations because they have extracted enormous profits or rents from their fossil fuel business and were instrumental in creating an economy that was structurally dependent upon fossil hydrocarbons. And so this is an argument that the fossil fuel companies often make because it conflates individual responsibility with structural forces and the structures of the economy that as consumers we don't necessarily have an option from sort of opting out of, right? It's very difficult for us, I think, to opt out. It's not to say that we don't have responsibilities, particularly to other countries of the global south that are obviously experiencing the harms. But I'd love to hear you say more about this whole question of kind of corporate responsibility in addition to the responsibility of these welfare estates, because it seems to me you're suggesting perhaps there really is no recourse through tort law for sort of climate harms for these very large companies.
Yeah, that's exactly what I was trying to say.
I just wanted to make sure I understood.
Yeah. Well, first of all, I think regardless of what your overall political approach is, I think on the basis of existing tort law, the question is at what time was it foreseeable? If you don't get beyond that, I think all the arguments are fine and interesting, but they're not sort of on point on this point. And of course, you could say, I don't care about foreseeability, but that's not the way this branch of the law operates, in my view at least. And I think it is difficult, or in my view, it exposes a high degree of hindsight bias to now say, this is what they should have done all along, in addition to the fact that I don't really see what it is that they should have done all along. For instance, in Germany, we have now a so-called energy crisis because we depend largely on natural gas from Russia. And it's interesting to see how people panic about this, about the prospect that in winter time, their heatings may not be powered up to the same degree that they've gotten used to. And it's not at all the case that the energy companies are running around complaining. It's the consumers that are saying, oh God, what's happening here? And so that politicians of all colors are really under pressure to deliver something so that the usual degree of energy consumption may be sustained. This is one aspect, and the other is that people are complaining that German airports are not functioning to the same degree they used to before the corona crisis, because airlines have sized down to save costs when nobody was flying, and now it's a political topic. Oh, the airports are stuck, and these are just examples where I think it's not that Lufthansa is forcing flights on people who would rather stay at home and save the climate. Rather, it's the people who want these companies to provide cost-effective or even cheap services at the cost of consuming energy to a sizable degree. That's what I meant, and that is something where I'm not sure whether one can tell this story like in the tobacco cases, that here's an industry that advertised its toxic products and we as consumers were misled. We thought, oh, this is harmless, but now we are suffering. I think that doesn't apply here. It's something we even today desperately crave for. We all do that. And therefore, it's more that we have to restrain ourselves, not so much that corporations must restrain themselves. That's my view of the thing.
Eva Maria.
Well, if I may, once again, I mean, your remarks about the current crisis are absolutely correct, of course, and I think we will come back to the issue of whether the political system is functioning well enough to give the right incentives to really tackle the climate problem. We will come to that possibly in the second panel of this morning after the coffee break. I just wanted to come back to the issue of foreseeability. And what do you think about the proposition that climate change that was possibly already foreseeable since 1965, which is an often cited date, the date on which, or the year in which a committee of scientists suggested to the White House, to the American government, to the president, that that climate change was possible through the greenhouse gas effect, and that it would have disruptive effects. Is that not the point in time when we should think that climate change was foreseeable, even perhaps with a few years lapse for the large fossil fuel companies? And I mean, I sort of hinted at the story, which is very well documented, of fossil fuel companies actively promoting insecurity, uncertainness on the scientific findings, and sort of actively hindered politicians to make stricter decisions on CO2 emissions.
Thank you, Eva Maria. We have Evelyn in the back. Maybe we'll take a couple more and then we'll go to our coffee break. I know we're getting very close to the coffee break.
Well, thanks a lot for the discussions, and thanks also. I'm here with Eva Maria. I think points of view on responsibility and whether individuals are to be blamed. I just want to add one point, and I do think that there is a comparison to be made with the tobacco companies. I just want to add one example. It's BP that actually launched the idea of the individual carbon footprint in 2004, working together with a communications company, so that if we all would believe that it's in our own, it's our own responsibility and that individuals are responsible, it takes away the pressure from large companies that have indeed cooperated and installed uncertainty for much longer than was actually necessary. So I do think it's quite dangerous to put all responsibility on individuals. Yes, of course, we can reduce our carbon footprint. And yes, if you look at the IPCC reports, consumption decisions matter to a major extent, but we also need structural changes, and we also need, I do think, the large companies involved, and they have made huge profits or still making huge profits that could be used to make this transfer to renewable energies, and this is not done to a sufficient well, level at this point in time. So I do hope we can use tort law there as well, but we probably won't agree on this point.
Thank you, Evelyn. Any final question or comment from the group before maybe I'll give the panelists one last word and then we'll go to the coffee break. Okay. Gerhard, you get please, well, you don't get the last word, but you can speak and then we'll have Marc-Philippe speak and I'll give Pasquale a chance and then maybe I'll get the last word.
Yeah, you should. Well, I wasn't taking a position exactly what the point in time is. From different quarters, you can hear, don't take it wrong, anecdotes about what happened in this year and that year. It's difficult, I think, to come to a decision. One would have to look at the full spectrum of information available at certain points in time. I'm definitely not saying that the point in time is only now or 5 years ago or something. What I would say is that given that we have the threat of crises all over since eternity, we're talking about potential crises. This alone wouldn't, in my view, trigger foreseeability. It would that there are reports and so on. I would think that you need some kind of public awareness that this is a serious problem that must be tackled. That is certainly not only today that we realized it, but I'm a little bit skeptical about 1965. For most of my life, I lived with the fear that we may run out of oil and gas, oil and coal. It was always said, these supplies are limited. And in the end, humanity will sit there and we will have nothing to burn to heat our homes and to drive our cars with. So we must economize on fuels because we don't have enough. Now the situation is we have far too much. We must leave them in the ground in order not to overheat the planet. It's a reverse problem. There were newspaper title stories, there were studies made, hundreds of pages about how much do we have in stock, what is peak oil, when will it be reached, and then we will decline. Now it's completely reversed. We must pay the Saudi Arabians not to produce oil, even though they're floating on it. So that's just an illustration of the hindsight bias that may be at work. It seems now that all along it was wrong to think that way, but I admit that I believed that this was a problem and that global warming, yes, may be a possibility, but what it really meant, how urgent it was, and what 1.5 degrees means to us, I think that is a pretty recent experience that we all made. So I would be a little cautious to say, oh, back in the 1950s, people already knew that the clock was running.
Marc-Philippe.
Yeah, thank you. Thank you for your remarks, and I'm looking forward to the discussions in the coffee break.
Yeah, and as far as I'm concerned, I think that what I've learned this morning from this session is that this group.
Okay, I think we lost Pasquale. So, yes, thank you all very much for a very interesting first panel. Please join me in thanking the panelists, and we go to the coffee break, which is in the building on the opposite side of the entrance to this building. That way.
Thank you very much.
Father
Bye.
Alberto, thank you.
Bye.
So, Alberto, are we going to start or still, we still wait for the YouTube? Okay. Can we start? Okay. So we will start the second session of this morning, and we're a little bit behind our time. I don't know whether it's possible to shift the lunch break a little bit for like 10 minutes or so, so that we have enough time for the panelists of this second panel. Just by way of introduction, I want to say that I think that one of the fundamental problems for the combat of climate change is, and the combat against the CO2 emissions, is time. We have a certain time lapse between the occurrence of the CO2 emissions and the damage they are causing, and that time, and also we have a certain time lapse between what we're doing now to cut down on the emissions and to adapt to climate change, and the time when the benefits for us will be seen in the future. And possibly we won't see the benefits even if we cut down emissions now. And we in our lifetime, I mean. And that problem in time means that it's very difficult for the political systems to deal with climate change. And that is why I see such a crucial role also resting with the courts and with international, and of course the other dimension is that it's a global phenomenon, and we absolutely need international cooperation to fight climate change. And that brings me to the panelists of this second session. The first intervention will come from Tim Eike, who is a judge for the UK in the European Court of Human Rights. And we've discovered that we were both at the University of Passau in the years 87 and 88, but didn't meet there. But we meet now in this project. I mean, it seems like a very small town in the very far east of Bavaria, but at the time it was quite a huge law faculty, and so it was not too improbable not to get to know each other. Tim has been a QC since 2011, and he has been appointed judge at the Strasbourg Court in 2016 and has served there in this capacity ever since. Then to my right, I want to introduce Ms. Larisa Alvin, now from the Amsterdam Court of Appeal. She probably does not need any introduction here because she is the author of the famous Shell judgment, and I hope we will get some information on this very famous case from you. Next to her is Stijn Franken from the law firm. I hope I somehow not totally mispronounced your name. I'm sorry if I did. From Nauta Dutil, a large law firm in the Netherlands, and he told me over the break that he has also taken instructions as well from Shell as from Urgenda. So he's really a proper lawyer who can defend both sides and present to us both sides, I hope. And then the fourth and last intervention will be by Filippo Fantozzi, who is a lawyer working for the Urgenda Foundation, the famous Dutch NGO who fought its way through, until the Hoge Raad for the famous Urgenda judgment. So the floor is yours. Tim, you would like to, you will start?
I will. Thank you very much. Can everybody hear me? Or do I need to press the button so the light goes green? Is that it? Good? Well, it's the other way around in my court. If the light goes green, then nobody can hear me. Good afternoon. Thank you very much to the organizers for inviting me to this exciting conference. It's a real pleasure to see you all here in person in the beautiful Ferrara and in the first physical meeting of the project. I'm really looking forward to our exchanges to discuss climate justice, one of the most pressing issues of our time. As if I needed reminding, as I traveled here yesterday by train from Strasbourg, the headline in the Guardian newspaper was, I quote, "Climate crisis. Italy declares state of emergency in drought-hit northern regions. 5 areas have experienced unusually early heat wave and lack of rainfall, in particular the Po Valley," close quotes. This is, of course, only the most recent and for us now most tangible and most local expression of the problem we've had over the last, or the expression we've had over the last few years of the problem of climate change and the wholly unprecedented scale of the challenge it poses to us and to humanity. And I think as came out of the panel this morning, and to some extent will hopefully come out of ours too, the real challenge confronting us all, and that is not just as lawyers, is what concrete steps are we individually and collectively willing and able to take in order to meet the challenge. Of course, today we're concentrated on what role can or should law and judges, and in my case in particular international human rights mechanisms, play in that context. As you will be aware, there's been an almost exponential growth of climate change litigation across the world, and Savarese and Setzer in an October 2021 paper suggested that there were nearly 2,000 climate change cases, of which 120 or so were rights-based. And interestingly for me, while in terms of overall climate change cases, the vast majority is brought in North America, rights-based cases seem to be predominantly brought in Europe and South America, which may be a pointer to the fact that they are the two continents with perhaps the most developed regional human rights jurisprudence. Now, looking closer to home for me, you'll be aware that there are currently 9 climate change cases pending before the court, the last having been lodged only on the 21st of June. The last case, which I'll say a word or two about without going into the details, adopting a different strategy to the first 8. Of the first 8, 3 have now been relinquished to the Grand Chamber of my court to enable it to consider, as the Convention suggests, the serious questions affecting the interpretation of the Convention raised by those cases. And they are, in order of relinquishment, Verein Klimasenioren Schweiz against Switzerland, Carême against France, and Duarte Agostinho and others against Portugal and 32 other states. Now, as I'm a sitting judge, I hope you'll understand if I keep my observations today general and do not comment on these pending cases specifically. I may say, though, that one of the consequences of the fact that these 3 cases are now pending before the Grand Chamber is likely to be that the remaining applications will be stayed at chamber level to await the Grand Chamber's determination and guidance on some of the fundamental issues these cases raise. Now, the first 8 of these cases seek to rely on a number of convention articles with a view to establishing an obligation on states under the convention to take adequate and necessary steps to mitigate the consequences of climate change and to prevent a deterioration by limiting the increase in the global average temperature to well below 2 degrees centigrade above pre-industrial levels, and to pursue efforts to limit the increase to 1.5 centigrade. Those are, of course, the standards agreed under the Paris Agreement. So they're, in a sense, looking more generically at mitigation. Now, recent reporting in The Guardian and Le Monde, amongst others, suggests that the 9th case, which I haven't yet seen, is taking a different approach, because it seems to, so it is reported, not in fact look at the acts more generically at mitigation states undertake or don't undertake, but is a specific challenge to the adherence of 12 selected member states to the Energy Charter Treaty. The selected states include France, Germany, and the UK, but as I understand it, not Italy, for example. And the basis for that is that adherence to the Energy Charter Treaty enables or facilitates international litigation which is said to unjustly protect or incentivize fossil fuel investors. And the aim is, so it is stated in the press, to remove the incentives created by the Energy Charter Treaty. One of the interesting things for me in that is, and that comes out of the debate also we had this morning, is one of the examples cited in the press about the advantages or incentives the ECT is meant to create arises out of the recent exit challenge of the RWE against the Netherlands, where they're complaining about not having been given enough time to transition from coal to biomass. Now, arguably, that is something the Dutch state couldn't have given them, because the Supreme Court, of course, ordered within a particular time frame certain steps to be taken. And therefore, the argument is, and I'm not commenting on the merits or demerits of it, in part because I haven't seen it and it will have to be adjudicated, but it shows, in a sense, that the issues we're talking about are not one-sided. There are always the measures that may be required to be taken to mitigate or protect against future deterioration will almost inevitably impact the legal rights and interests of others, most of which are equally protected by the law, including some, of course, by human rights law. So property right is protected under Article 1 of the First Protocol in the Convention. So the balancing aspect, I think, is an important one. Now, can I just say, by way of introduction in relation to the court, as I said, we have the first 3 climate change cases pending before the Grand Chamber, but there have been about 360 decisions and judgments in cases raising environmental issues, through which I think the court has shown that within the boundaries of its competence as a court of law, and mindful that the Convention has to be effective and real, these issues are unlikely to be such that they are per se beyond the reach of the Convention. And the other thing I think is worth emphasizing is the court only recently has again reaffirmed that the political nature of the issues, and of course lots of these issues are deeply political, the fact that they are political by itself, again, does not suffice to deprive the questions of their character as a legal question, and therefore do not deprive the court of jurisdiction to consider them. But then it's perhaps important to look at some of the challenges which confront an international or regional human rights court like mine, and I will try and highlight a few, both general and more specific. The first is, of course, we are only charged with supervising the compliance or observation of member states of their obligations under the Convention. So we are very much a vertical instrument rather than deciding horizontal
disputes, which of course is different to the work done by Judge Alwyn and Mr. Franken, amongst others, who are, in a sense, more concerned with the horizontal than the vertical. The issue that arises out of that is that we are only looking at the compliance of the member states with their obligations under the Convention, is that the Convention imposes a requirement for exhaustion of domestic remedies, and we are very heavily dependent on our dialogue with the national courts in order to frame the dispute as it comes before us and to understand both the factual matrix of the case that comes before us, but also the competing interests that are to be balanced in any balancing exercise that has to be done, and in the context of any margin of appreciation that may have to be allowed. And I think it's important and interesting, perhaps, to note how important the exhaustion of domestic remedies requirement is, because, of course, in September last year, the Committee on the Rights of the Child, having found that they have geographical jurisdiction over the dispute, rejected petitions by 16 children from 12 countries under that convention on the very basis that they hadn't exhausted domestic remedies. And that, in a sense, goes to Eva Maria's point about time. Certainly when you're looking at us, of course, the cases will have gone through the domestic process, the domestic courts, up to the Supreme Court, and will come to us. So the law is not necessarily a speedier, or certainly not the speediest process to resolve a problem which I think we all accept is one that is pressing in time. But it's also, I think, interesting how that dynamic works, because you might have said before there was a successful case like Orenda, or other sort of successful cases like before the Irish Supreme Court and others, that international human rights mechanisms may have been receptive to an argument that there are no effective remedies. And when there are no effective remedies, you can come straight to the court. But of course, the more litigation is brought domestically, the more litigation is brought domestically successfully, the more difficult that argument becomes. And therefore, actually, international and regional courts are more likely to say, well, actually, there are states which have shown, Netherlands, Ireland, Germany, have shown that remedies can be effective. So you need to have tried before you come to us. And again, I must emphasize, this is an abstract and general observation rather than being an engagement with a particular case pending. One of the other challenges we face, and that's where the Committee on the Rights of the Child was much more flexible, I think, than my court has so far been, is that the court's jurisdiction is territorial, and territorial is defined by reference to the state, to the respondent state, rather than to the convention area, or even more globally to the impact of decisions around the world. So the court has not so far accepted a cause and effect jurisdiction, which of course is something that Bundesverfassungsgericht in Germany seems to be moving towards, having to kind of then work out what that means, but we're not there yet. And therefore we are very much focused on the causal link between the act or omission of the state in all its emanations and the impact it has on a victim within the territory of that respondent state. Now, when we look at victim, the next hurdle, okay. Can I sum up in 2 to 3 minutes? To be a victim, you need to have serious, specific, and imminent, established that there is a serious, specific, and imminent risk to you personally, which again makes the evidential requirements in terms of victim status rather more difficult, one would have thought. And again, it's interesting to see that Verein Klimasenioren Schweiz in 2020, it was that point which led the Swiss Federal Court to dismiss that claim and to reject it, and that will now have to be accommodated. Unlike some might say the Orenda case in the Netherlands, in our case the victim status is quite specific, and an actio popularis, i.e. an action on behalf of the population of a whole country, has not yet been accepted. Now, there are a whole host of other challenges. One is the absence of a proper substantive legislative basis on which we can adjudicate this. There's no right to a clean and healthy, sustainable environment in the Convention, and despite requests since 1999, this has always been rejected by the member states. And only in September 2021 was a proposal made again, which the Committee of Ministers is now looking at. Therefore, we don't have the benefit of applicable domestic law, such as Article 28 of the A of the German Basic Law or Article 37 of the EU Charter. So we're lacking a legal basis which was passed by a democratically legitimized legislature, which creates a binding or enforceable fundamental right. And that creates, to me, one of the other issues which is difficult for courts, in particular international courts, is the legitimacy question. Because the absence of a legislative basis means one will have to develop the law on the basis of the living instrument doctrine. That means developing it purely out of judicial dicta, which is already subject to significant criticism. And the flip side is, and we've seen this in EU context too, if judgments are handed down in relation to climate change and governments don't execute them, then there isn't a mechanism by which a court like mine can force the states to execute. And the real question, I think, that more globally that poses for me is, one, legitimacy of the court and the system, and two, the broader question, what does that do to the rule of law? And I think that's a question that's really out there, which we haven't yet grappled with. Now, there are lots more points I could make, but as I am, my time seems to be slower than Eva Maria's, I will just make one final point and then I'll stop. The living instrument doctrine, we do draw inspiration from international agreements. And you will have seen that in terms of procedural obligations, we have drawn attention to the Aarhus Convention and the like, which sets very clear standards of what is required. A question that we will need to think about, and we can think about here, is the Paris Agreement deliberately didn't set those clear standards. It set an achievable goal, but it didn't set any requirements. And as the Bundesverfassungsgericht said, it relies on mutual trust and the states sorting it out between them. Now, how much can that then be an inspiration for us to create out of Article 2 or Article 8 a right for a clean, healthy, and sustainable environment, which imposes clear standards of, or clear measures of what you need to do in order to stay below the Paris targets. So one of the ways of doing that is for the court to limit itself, as it has done so far, to procedural obligations and mechanisms which are in part drawn on the Aarhus Convention about making states go through mechanisms in the planning and licensing of activities to do the right research and to take into account the interest of all parties and to enable parties access to that information and, if unsatisfied, to challenge it in the domestic courts rather than in mine. I will stop there. There's lots more I could say, but I apologize, I've overrun.
I'm very sorry to be so strict, but I just want to have everyone on the panel a fair share of the remaining time. So without going any further, I will give the floor to Ms. Alving.
Yes, thank you very much. Yes, oh great, right. And the PowerPoint, I've included all kinds of pictures in my sheets, so it would be nice if you could see them. These are the statues in front of the Dutch Supreme Court. But first of all, thank you very much for this opportunity to speak here at this conference in this lovely venue. I hope to provide some further insight in the Dutch approach and give some input for further discussion. I speak from my position as a Dutch judge and a judge in one of the cases, and I hope you understand that limits in what I can say about these cases, but still. What are we talking about? The Dutch approach refers to the rulings in the Agenda case and against the Dutch state and the Shell case, and here we see the first a remark on the procedure. The agenda case has gone through the complete procedure up to the Supreme Court, which you see at the right. And the Supreme Court, the third instance, only examines the application of the law. The other two instances, the District Court and the Court of Appeals, they are both in the building that you see on the left in The Hague. They examine both the factual and legal grounds of the claim completely as the claim is presented. And I think it's important to note that in Dutch procedural law, both of these courts perform their own examination and reach their own conclusions. So you have a completely new case in second instance. And it's also important to realize that the rulings are based on the facts at the time they were issued. So in appeal, the ruling in the Shell case will be based on the facts probably in 2023, or if things move on slowly, 2024. And of course, the world is different then than it was in 2021 when the District Court issued its ruling. So needless to say that the appeal can lead to a completely different outcome. Both cases were civil law cases, and they were both collective or class actions based on Article 3305 of the Dutch Civil Code, and the text is on the sheet. And this article allows for a collective action in protection of similar interests of an unnamed group or class. And these actions can only be brought by associations or foundations established under Dutch law that represent the interests of the class according to its articles of the association. And in both cases, the interests that were represented were those of the residents of the Netherlands, and the Shell case is more international than many people think or know, because it is always also the residents of the Wadden region was represented, and the Wadden region is partly in Germany and Denmark. The Dutch state was addressed by Agenda as the decision-making body of the Netherlands, responsible for the Dutch climate policy, and Royal Dutch Shell, then I will also say RDS, was addressed as the entity that determines the general policy of the Shell group. So it was not a case of a mother-daughter responsibility, but it was a direct responsibility of setting the company's policy. It is important to know too that the court decides on the claim that the applicants present. So the court cannot, under Dutch law, assign more than is claimed, but it can assign the lesser. And one could say that the orders that were given were both defined by the claims. For example, in the Shell case, people have said, well, why 2019 as a reference year? Well, the answer is very simple, because that was the claim. That was not something the court made up, but the court had to answer the question, is there an obligation of a 45% reduction with 2019 as a reference year? And the court has to stay within the boundaries of the case as it is presented by the parties, though it can use facts that are considered common knowledge, and it can also complement the legal grounds if they fit the facts. And in appeal, the Court of Appeal and the Supreme Court also have to stay within the boundaries of the objections. So the parties define the discussion. Then the discussion. Here we see the Netherlands. You see the effects of the rising sea level after climbing warming. But this sheet shows the dispute in both cases. The facts were in fact hardly in dispute. Parties agreed that there is a great problem and there is a need to take action, etc. But the dispute focused on their obligation and the scope of the obligation. So on the left you see what parties agreed on, and on the right you see the arguments about the scope of the obligation, saying like, why me, where the rest of the world does nothing? others should also live up to their expectations, etc., etc., etc. The legal basis for the order in all of the cases is the same. This is the second time you're seeing this. This morning we also saw the whole article, the legal basis. Oh no, this is, sorry, that is the next sheet. This is not the second time you see that, but the legal basis for the orders is Article 3(296) of the Dutch Civil Code, and the text is on the sheet. And the court has to answer two questions. The first is, does the defendant have an obligation as described in the claim? And the second question, if the answer to the first is yes, is the defendant's conduct in accordance of the obligation, or may the defendant maybe violate this obligation? And if the answers to both questions are yes, the court has to issue the order unless something else results from the law or the nature of the obligation or a court ruling. And the burden of proof for the first two questions is on the applicants, and the burden of proof for the last is on the defendants. Then we see the article you saw before, Article 662. And what is important, it states that tort has an obligation to abide to the law, but also the unwritten standard of care. And here we see that all the rulings applied this same article in a different way. In the first instance in Agenda, the court applied case law, Dutch case law for endangerment. The Court of Appeal and the Supreme Court based their ruling on the law, on the positive obligations of Articles 2 and 8 of the European Convention of Human Rights. And in the Shell case, the court applied the unwritten standard of care using soft law obligations of companies to respect human rights in its assessment of the unwritten standard. As I said before, the facts were hardly disputed, and all the rulings in both cases take into account the dangerous effects of climate case, the IPCC reports, reduction paths, things like that, and all the courts found the arguments of the defendants that I made before that they failed. Here we see the order, both orders, and in short, both defendants were ordered to contribute their share. That's the essence of both orders. Well, there's a lot more to say about these cases, even within the boundaries of what I can say. I conclude with a few thoughts on the inherent tensions in climate cases. And here we see, I think, an historic moment. This was the day of the deliverance of the agenda ruling in 2015 by the district court. The first inherent tension is caused by time. We've talked a lot about time, but as we saw in the agenda case, it can take years before it's clear that an obligation exists and what its precise scope is. And as I mentioned before, the Shell case can lead to a different ruling with different outcome, different reasoning. So it can take time, years of uncertainty, but the upside is that it allows for further discussion and refinement of the arguments. Another inherent tension, which is specific for civil courts, is that they rule on a claim by party A against party B on a problem, on a mondial issue. And this tension in the Dutch cases is solved by the reasoning that the defendant has to do its part. And then there is another inherent tension in climate cases, and that is that they solve part of the problem. They answer some questions, but they leave many unanswered questions that maybe can be answered in the future. But I'll name a few. Which measures are actually fitting? When does a party do its part? What is the relationship between the obligations of the responsible parties? Is there a hierarchy in these obligations? And how is the combined effect best organized? And these are in fact general questions regarding the effectuation of the Paris Agreement. When it comes to the question which measures are fitting, we also have to keep in mind that the Dutch courts are not permitted to issue an order to create legislation with a particular specific content. So the courts can only say you have to, well, like you have to reduce up to a certain percentage at a certain moment, but the state is free and has to be free in how it lives up to this obligation. And in fact, in the Shell case, the same idea was put into the ruling. Now, I'm really concluding now. A lot more is to be said. And I think first and foremost, it's important that all these tensions I mentioned show that the courts are part of a system of checks and balances and act in interaction with society. Thank you very much.
Well, thank you very much. And we will immediately continue with the second presentation on the Dutch approach by Stijn Franken.
Thank you very much. Thank you very much also for the invitation and the opportunity to sit together and discuss today and tomorrow this very important topic. I will not comment this morning on the Dutch judgments. I will also not take a position on one of the parties, it being Urgenda or Shell, not because I'm defending both sides, because I actually believe that both sides have the same story to the Dutch court, but because I want to share something else with you today, this morning. And I was very much intrigued by the contribution of Professor Wagner this morning. It may all well be true what he said, but I like to tempt him this morning to take it a step further, because I do think that it does not need to be the end of the story of tort law. So my contribution today will be whether the duty of care may well transform to a duty of contribution. And I think that is the hidden agenda behind the Urgenda decision and also the Shell ruling. But it's a development in transition, because crisis calls for action. And if anything makes unhappy, it's the feeling as human beings in an emergency situation in which you feel abandoned and not deprived, basically deprived of an opportunity to take effective actions. And the climate crisis is a manifest example. But the challenge of climate change is enormous. There's no individual on Earth who can prevent the process of climate change, as Professor Wagner this morning said very clearly. We will only prevent climate change together. So, as Mrs. Almen said, what is a realistic, effective measure in order to achieve net zero emissions in 2050? How do we determine everyone's share of it? And I think 3 types of reduction standards seem eligible for application as it stands now. The first basically is a worldwide average, resulting in a 65% reduction in 2030. That was basically the standard being applied by the Shell judgment by the Hague District Court. The second standard will be a normative standard, tailored to each and everyone's common but differentiated responsibility. And arguably, for the EU, this would mean an almost 100% reduction in 2030, as is being advocated by Urgenda slightly differently, but on a normative basis now in Italy. And that also should be remembered was the basis of the Supreme Court ruling in the Netherlands in Urgenda. It was a normative norm of 25% reduction, not an average. And the third option is basically whatever is considered to be individually achievable. For example, the nationally determined contributions from the Paris Agreement. And for the EU, this has resulted in a Green Deal proposal with 55% reduction in 2030. Now, compared to what is needed or fair to the rest of the world, it's clear that the European ambition is extremely low. And this applies not only to government, but to businesses as well. The gap between what is needed and what we actually do is huge. And basically, we are driving a race car which we know is about to hit the wall. We may survive, but our children may not. And we therefore need to speed up our effort to slow down our emissions, not only top-down, waiting for appropriate regulations that may never come or will be likely too late, or Supreme Court decisions, but also bottom-up. We need a race to the top instead of a race to the bottom. And the recent United States Supreme Court EPA decision shows a remarkable reluctance to intervene and a disturbing willingness to surrender the risk of climate change to the tragedy of the commons. Courts do not need to capitulate, I believe, but can contribute and provide appropriate relief. Climate change not only requires a change in lifestyle and a change in processes, climate change also requires a change in legal thinking, if you like, a paradigm shift. From our Western point of view, human autonomy is paramount. The pursuit of happiness, United States Constitution, is a fundamental right that may only be restricted under special circumstances. And with the onset of industrialization, the individual footprint of some has become disproportionately large. And in the 20th century, this led to extra protection for consumers, for example. The increase in prosperity now also results in an increasing scarcity. It's not only about climate, but also about raw materials, drinking water, public provisions, prosperity. And the 21st century will unmistakably be dominated by the question of how this scarcity should be evenly distributed, not out of altruism or mercy, but only because a fair distribution of scarce resources will allow the community access to the various pursued benefits associated with all its achievements. Civil law must also make this transition. Only if liability law continues to adequately apportion will it be able to respond to the pressing questions of the present day. And in order to understand what this transition means for liability law, I think we should realize that duties of care always occur in a threefold sequence of investigating, taking measures, or providing information, warnings. And the paradigm shift from corrective justice to distributive justice affects each of these three manifestations. Research has traditionally depended on the calculation formula of United States Judge Learned Hand. I think that was what Professor Wagner inter alia had in mind this morning, speaking about this setting of 19th century. If the cost of the measures is less than the chance of particular damage occurring, there's a duty of care, otherwise not. Quite simple. An ordinary person does not need to spend 100 euros to prevent damage of, let's say, 25 euros. But not everyone is ordinary. More is expected from some people because of their self-appointed position. For producers or employers with an enlarged footprint, a more extensive duty of care has developed. They must also take into account dangers that cannot be foreseen by ordinary people. Now, the next step is no longer based on individual risks, but on the generic need to know what risks can be. And certain industries, such as aviation or pharmaceutical industry, have adopted this principle, the principle of just culture. And in such a culture, learning is not an individual, but a collective responsibility. It's no longer about individual correction or blame, but about the extent to which mistakes can be learned from. And one attempt to introduce this principle in liability law was the proposal in the European Product Liability Directive already in the 80s of the last century for an additional force majeure defense for producers of defective products who, after discovering the defect, made every effort to comply with their recall obligation. This attempt then failed. The defense was not incorporated in the EU Product Liability Directive. However, under the present circumstances, I believe we will see an urgent need to revisit and rethink these types of defense and obligations, which are quintessentially designed to improve prevention. ESG regulations, as was being referred to earlier this morning, require due diligence and the performance of a self-scan. I think we need to step up this process. Every responsible institution should have a thorough climate plan. The first question my clients ask me, so what is your firm doing? Yes, we are making our own climate plan. Measures are traditionally aimed at compensating for individual disadvantages. The individual damage inflicted is the measure's main criterion. To give a typically Dutch example, anyone who damages another's bicycle must compensate the foreseeable cost of repair. No more, no less. However, more is expected from some individuals. Producers, employers are also liable for damages that cannot be foreseen by ordinary people, partly because they profit from their products or their employees, but mainly because they are in a better position, better placed than anyone else to regulate the risk associated with putting products on the market or having a safe workplace. Now, the risk of climate change demands a step further. The extent of the measures and costs to be taken is no longer determined by individual costs or a particular measure of damage. The individual causing effects are too uncertain for that. Climate change is about everyone's contribution, and this is not determined by individual damage or costs, but by the principle of equality and what is considered a proportionate distribution of the burden and benefits given certain advantages that someone enjoys due to his or her special social position. We spoke about extensively earlier this morning about Shell. Shell basically is having a lot of profit. That's true. But it's first and foremost a clearinghouse of interests that are being set off via the company of Shell in the past, in the present, and will be likely in the future. Some people or institutions have more opportunities and power to do so. And that's why we speak about Shell. And that's why fair to ask Shell to come to the court and express itself and show itself, and it's the way it sets off the interests. I will come back to that later. Traditional examples of where an increased duty to contribute applies are expropriation, vicarious liability, traffic liability, and other pure strict liability cases. Some advantages can only be obtained if we share the downsides equally, without a requirement that someone needs to be blamed for the consequences. Pure strict liability is applied when we use, for instance, nuclear power, and is likely to be applied in order to enjoy the benefits of robotics. Climate plans need not only to show willingness, but a clear, immediate contribution, and that's very important. We don't have time to wait for another 10, 20, 30 years. Where measures are not effective, liability law requires at least adequate information. It may be justified to warn of a particular risk if effective measures cannot be realized. In recent times, the number of information obligations has grown rapidly. More and more information obligations are being tailored to more personal risks. For climate risks, again, we need to take it a step back further. Information is not meant to explain how specific risks are prevented. In the case of climate risk, information is intended to clarify what within a given community, it can be the EU, it can be worldwide, it can be a certain part of industry, is considered to be a proportionate distribution of burdens and benefits. For example, given the maximum emissions allowed in a certain country, what is a proportionate distribution of those emissions between the citizens and the businesses? The answer cannot be given in advance. In the absence of a clear standard, the institution addressed, Shell, government, can best provide insight in its own individual trade-off and why it believes such trade-off results in a fair contribution. Such information is not primarily aimed at replication, but rather to serve market transparency and to explain why something might be seen as a bottom-up, proportionate distribution within that community, society. Good example are the regulations for financial instruments, the ESG rules for companies, and the option to file a public OECD complaint with the national contact point. My trade-off may not be the same as yours. However, by sharing my certainties and uncertainties, I do provide others with an opportunity to better understand and determine their own. And ultimately, the exchange of facts creates best practices and shared values. In many countries, for a variety of reasons, the legislative and executive branches are unable to make it clear to citizens and businesses in time what their fair share is in the energy transition. And this worries people and stirs up feelings of loss of autonomy and isolation. Judges do not have to leave people out in the court. Distribution standards are fundamental, and if done right, based on social support. And this support can be generated from the bottom through initiatives or self-regulation. Failing clear top-down regulations, for instance in the Netherlands, distribution standards are also from time to time formulated by judges. Both the Agenda case and the Shell ruling are examples of this. The difference between the two cases, however, is that in the Agenda case there wasn't sufficiently clear international standard, and obviously in the Shell case it was far more difficult. Well, in this state of ambiguity or intransparency, the best thing for a court to do, in my opinion, is not so much to invent a reduction standard. What should it be? Average achievability? On what basis? What will be the consequences? Rather to facilitate the process of setting reduction standards as much as possible. I'm nearly finished. Suppose that Shell had to report to the court within 1 year, i.e. now, what its global footprint looks like, what its span of control is with regard to reduction of emissions, which measures Shell is prepared to take in order to bring its business processes in line with the Paris objectives for the future, which sacrifices Shell is prepared to make in this respect, and why Shell considers this to be a sufficient contribution. It would have given a clearer debate and a much stronger signal or leverage to the outside world than what's happening now. A rather abstract discussion about a limitedly defined duty of care, of which it may only become clear in years to come what it may or may not mean when the question is most likely superseded by another political, social, or factual reality. Thank you very much.
Well, thank you very much. So we will have a fourth presentation now by Filippo Fantozzi, and the floor is yours.
Thank you very much. Thank you very much for having me. It's a pleasure to be here in person with all of you. And thanks for incorporating notably the view of NGOs that are engaged in the climate litigation movement. I think it's really important to have this kind of conversation altogether. I've been engaged in climate litigation strategies for quite some years now, since 2017. And now I'm currently working with the Climate Litigation Network, which is a project of the Urgenda Foundation, supporting individuals and communities that are filing cases against their governments. And since 2017, I think the starting point of this conversation is almost always the same. We are seeing with our own eyes these increasing climate impacts, especially here in Italy. I'm Italian, I see the water scarcity, I see the heat waves, the Marmolada disaster a couple of days ago. And citizens are really starting to question what the government is doing, if the government has actually the ability to protect their fundamental human rights from dangerous climate change. And citizens are increasingly doing so through litigation. So I think an interesting way to conclude in kind of an essential way the debate in this panel is to provide you with the state of play of climate cases against governments that are targeting governments' inaction in the fight against climate change. A couple of the disclosures. The main findings that I will be addressing are part of a chapter that I'm co-authoring with my colleagues at the Climate Litigation Network. It's going to be for a climate litigation research handbook that will be published next year. And I will also be focusing just on state liability because that's the focus area of our organization. But we are, of course, aware and we are noting a significant increase in cases that are targeting corporations for their material contribution to the worsening climate crisis. I think it would be interesting to start by exploring together the context. So why governments are being increasingly targeted in these climate lawsuits. The IPCC reports the Glasgow Climate Pact that was signed by the International Community of States in November 2021, they all reached the same conclusion. We need to reduce emissions fast. By the end of the decade, we need to achieve this drastic cut of emissions. But according to the UNFCCC, we are far away from that. State policies, current state policies are actually insufficient, and we are probably going to have an increase of greenhouse gas emissions in the current decades. And with these state policies, we are going to go around 2.7 Celsius degree of global warming by the end of the century. This is clearly incompatible with the long-term temperature goal of the Paris Agreement. So we have a dual problem, if you want, because first of all, state policies are not aligned with this 1.5 goal, and at the same time, state policies are weak, but also what is weak is the implementation of existing policies. So states are not complying even with their insufficient targets. So we have this dual level of failure, and this state systemic inaction, systemic delay, and systemic failure to achieve strong emission reduction efforts is really making us close a rapidly, making us miss a rapidly closing window of opportunity to really grant a sustainable and livable future for all of us. And that is why I think that as the climate crisis is worsening, several years after the groundbreaking precedent that was established by the Urgenda Foundation, climate litigation is still a very effective and necessary tool to help reduce this existing emission gap and make sure that we can accelerate the transition towards a more sustainable society. What I think it would be interesting to explore is kind of the trend, where these cases are increasing, where these cases are being filed. Someone mentioned before the LSE report on trends in climate litigation that was published a couple of days ago, and we recorded around 73 government cases against governments filed globally, and we see that these kind of cases are being targeted especially to countries that are in the global north, and that's because of the historical responsibilities and the capacities that these governments have in accelerating the climate transition. At the Climate Litigation Network, we identified at least 31 systemic mitigation cases filed in at least 21 OECD countries. We call these cases systemic mitigation cases against governments because these cases are targeting the state systemic failure to reduce emission, the structural, the overall inadequate efforts to reduce emissions in a way that is compatible with the goals of the Paris Agreement. And what we also registered is that there are at least 9 successful cases in OECD countries, which is quite a promising success rate. The first question that climate litigators are facing when bringing these kind of cases is, of course, what kind of state conduct can be addressed? What kind of state behavior can be challenged? Because, of course, the broader idea is that insufficient climate action is unlawful. But what does it mean, insufficient climate action? And we see that climate litigators are increasingly relying on a broader and broader range of so-called state behaviors, and we identified at least 6 of these so-called behaviors. For example, the failure to set emission reduction targets that are adequate to achieve the state fair share. So knowing that the state is a developed country, for example, a state that has historical responsibilities and capabilities to reduce emissions, that state should be doing way more than the global average of emission reduction efforts. The second point is, for example, the lack of consistency between short-term targets and long-term targets. We want to achieve carbon neutrality by 2050, for example, but how are we doing that in the short term? Then we also can challenge the heavy reliance on negative emission technologies, all those carbon sinks and accounting tricks that are being used by states to show on paper that they are reducing emissions, but actually in real life, they are not doing so. We also can challenge the state failure to meet its own emission reduction efforts, as showed in France, for example, and also the state decision to postpone or to downgrade emission reduction efforts. And lastly, of course, the lack of any kind of reduction targets in any given period. That being said, I think that the second challenge that climate litigators are increasingly facing is assessing the available legal basis in the establishment of the state liability. And what we identified is that there are mainly two trends. The first one is that climate litigators are increasingly relying on a so-called climate-oriented interpretation of existing, for example, liability regimes or judicial review mechanisms. This is a real reliance on traditional tools and well-established rights at the domestic, at the national level, and courts are familiar with this mechanism, are familiar with this kind of basis and remedies. And the second trend that we are noting is that often these kind of cases are brought on multiple legal bases, because these kind of cases are not only the possibility and the opportunity to establish the state liability for its failure to act, but it's also an opportunity, for example, to clarify the interpretation of international law and its application at the national level. Or, for example, it's also the occasion, the opportunity to claim the existence of a brand new right. And I'm going to quote the pleadings of the Italian climate case right now, Giudizio Universale, that we are supporting. In that case, the lawyers behind the litigation are claiming human rights violation on the basis of well-established frameworks like the Constitution, like the European Convention. But they are also claiming the existence of a brand new right, so a right to a safe and sustainable climate system. And this is, of course, going towards the overarching trend of the presence of human rights law arguments in these cases. This is a trend that is exploding, and we see a lot of cases, a lot of climate cases that are presented to the courts, and courts are willing to recognize that climate change is harming human rights. States have positive obligations to protect human rights, and if states are not doing enough to reduce emissions, states are violating human rights. And I will just provide some examples of what are the most common legal frameworks that are providing the actual basis for the order against the state. As we've been mentioning throughout the whole morning, tort law is one of the first elements, one of the first legal frameworks that climate litigators are relying upon when it comes to state liability. We've already been mentioning the Dutch climate case Urgenda, but for example, also in Belgium, the Klimaatzaak climate case. In that specific case, the court found that the state didn't reduce emissions enough. That was a negligent conduct towards society, in particular towards the plaintiffs. And that basically was a conduct, was an unlawful behavior that was sanctioned on the basis of a general clause of extra-contractual liability that is present in the civil code, in the Belgian civil code. And a similar approach was also followed in the French climate case, L'Affaire du Siècle. In that case, the court recognized that the government generated excessive amounts of greenhouse gas emissions, and these basically keep exacerbating climate change, and this is generating a so-called ecological harm, préjudice écologique. This is a provision of the French civil code that is specifically addressing damages, systemic damages to the ecosystems, and so that was the basis to sanction the French state. And one of the other, the key legal frameworks that are justifying this, the recognition of a liability against the state is the constitutional law framework. In this case, climate litigators are trying to enforce the state's constitutional obligations. Usually it's the obligations to protect human rights that are protected by the national constitution. And the most striking example is probably the German climate case, Neubauer, where the German Constitutional Court recognized that climate change poses a threat to our society, and that not doing enough in the short term is actually creating a mitigation burden. This mitigation burden is on the shoulders of the younger, of the future generations, and this is basically violating these generations' fundamental freedoms, and fundamental freedoms are protected by the German constitution. Therefore, the government's action was partially unconstitutional. And the last legal framework that proved to be successful in providing a basis for an order against a state is administrative law. We have cases, for example, in Ireland and in France again. In Ireland, the Irish Supreme Court quashed the government mitigation plan because it wasn't following the climate change framework legislation that was set at the time. And the court found this plan to be excessively vague, aspirational, not clear, and it was not complying with the Domestic Climate Change Act. And another really exciting and interesting example is the French climate case Grand Centre that was brought by a municipality against the French government for its failure to reduce emissions. And even in this case, the government was condemned because its failure to reduce emissions was not compatible with the binding targets that were part of the national legislation. And so the last strand that I'm going to present is basically the fact that courts are increasingly finding for the plaintiffs in the systemic mitigation cases. We see that the challenge is obviously selecting a remedy that is going to leave enough margin of appreciation to the government. But we see that in cases that are following this approach, for example, with alternative remedies, for example, with a declaratory relief or with an injunctive relief at the same time, courts are increasingly accepting these cases and adjudicating in favor of the plaintiffs. And we have so many successful cases, especially in Europe, as someone mentioned before, the Dutch Supreme Court, the Irish Supreme Court, the German Constitutional Court, the French Supreme Administrative Court. Recently, there was a successful case in the Czech Republic. So we see that at the very least in Europe, courts are ready to assess the unlawful conduct of the state when it comes to climate action. And this is leading to real impacts because this is often reshaping the government's concrete response to the imperative of tackling the climate crisis. So I think I'm going to conclude here and just stressing once again that we are experiencing these worsening climate impacts, and this kind of systemic mitigation cases really have a role to play to narrow this emission gap and accelerate the achievement of stronger climate mitigation efforts. I think all of us in the legal community, we have a role to play to support these systemic mitigation cases and make sure that we can support and defend all those fundamental rights and freedoms of individuals, affected communities, vulnerable people, and actually entire generations. Thank you very much.
Well, thank you very much, Filippo, also for concluding with this rather optimistic note, because I think one of the dangers which you are facing at this point is really that we think we've already reached the tipping points, we've already reached a point in time where we cannot change the path to a disastrous outcome of climate change, so we'll do nothing. So I think that's a real danger, and so let's stay optimistic. One question before I give the floor to Gerhard. One question to the organizers. We've now practically consumed our time until lunch, so we should have lunch now. We could do two things. Either we continue with the discussion now and have lunch half an hour later, or the other possibility would be to have lunch now, resume here, be in this room again at 2 o'clock and have the discussion of these 4 speeches from 2 to 2:30. But that's the decision which I cannot take, but the organizers have to take. 2:30, 1:30. Okay, so we'll have the discussion now. So it's Gerhard first, then Mariangela, or Mariangela.
Well, thank you very much all
four of you for these wonderful presentations. I have a question specifically for Stein Franken. It's stimulating to listen to your proposals to develop the law further, particularly liability regimes towards a contributory regime. I suppose we share the view that the law is about, or the rule of law is based on rules and principles which apply across the board equally to many different situations. And I was asking myself when I listened to you, is that a proposal for tort law in general, or is it only designed to grapple with liability for climate change-induced harm? Is it sort of a niche only for climate change liability, or is it something general? And in that connection, I was asking myself, let's assume it's only for climate change damage. And you were talking about proportionality. As far as I know, what proportionality means is a matter of serious dispute. It was so in Paris, and it was also so in Glasgow. Many countries in the global south believe that those of us, namely we in the north, who have contributed so much already to carbon dioxide emissions, should disproportionately bear the burden, meaning contributing more than our fair share in terms of per capita approach to the future reduction, to the attainment of the reduction goals. So the question is, what does proportionality mean in this regard? Are we so sure that it's only per capita share that we need to contribute? And the second question is, what happens if it turns out that for reasons of population growth, arbitrary regimes, and so on, the reduction goals calculated on the basis of proportionality will be missed? If I've discussed that with Eva Maria a couple of times, let's assume China increases its emissions by 10% until 2030. That means that if the Netherlands and Germany reach their reduction goals on a proportionate basis, this gain will be wiped out immediately. So what happens then? I mean, the danger is the same. Then global warming continues or even accelerates. Now we could, what does proportionality mean then? I mean, would we then say, okay, we've contributed our share, it turns out it was in vain, shit happens, now we continue like that? Or is that adaptable to the threat, meaning that now we have to save even more to make up for? This is something, you know, I have difficulties imagining that it's not in terms of polemics or about let's do nothing because China may not reach its goals. I was just interested whether such a rule of contribution, how it would work across time and secondly across sectors, because it seems to me if you disregard the climate crisis, then we wouldn't need such a rule. It's only for that problem that we need a new rule. That's a question to you. If you think there are more sectors, I would be interested to learn about them.
Well, I think it's best to answer directly, and I give the floor to you.
I will try to answer. There are many questions, but thank you very much for this reaction. So I think when it only applies to climate change, I can't answer that question. It's clear that climate change gives us a very urgent example and need that we need to be creative as lawyers. But to be very honest, I think the mechanism I just tried to describe is not unique or new. It basically says that the legal industry, as I put it in the last slide, is only part of a larger mechanism of what I call clearing interests. And in the Netherlands, we are very sensitive to it. You know, you may be familiar with the polder model, as we call it. and is now being, I think, used in Germany as well. And I think that in the US, they were very curious at this as well. So when we have a problem, we prefer to sit together and to see whether we can solve the issue. And for us, the Urgenda case and the Shell case were in a way traumatic, because they showed that we were not able to sit together and to come together and to strike a deal. And now the government finally has organized these tables and tries to get people together and to have the various industries sit together and take their responsibility and the achievability and decide on the proportion. Now, what I advocate is not that the proportion will ultimately be set top down, but that it will be steered up bottom up by creating transparency in process, and that the legal industry should help that process. So it's for the legal industry not so much to set the standard or to determine the exact proportion. That may differ from time and place and circumstances, that's clear. But to help the community and society on all kinds of media, you can see it also with these type of litigations, it's not a legal case. It's a case that's being followed in politics, it's being cases followed in social media. It's a whole exchange of basically trying to sit together and mediate a certain result. And the more it is being steered up, and sometimes it's often thought, for instance, also in Urgenda position, that the government needs such a case to get political background, to get in parliament certain regulations being done. So it's not for me to say this will be the proportion, but I think lawyers do have an obligation and a responsibility, and particularly an opportunity to do better than what's happening now. That's basically my proposition, and I think it's useful for climate question, and it may well be useful for other questions as well. What?
Thank you. The next one on my list is Mariangela. Do you have the micro?
Yes, thank you. Good morning, everyone. Thank you, Madam Chair. What a round of excellent presentations. I have a question out of curiosity to Filippo, if I may. We follow one another on LinkedIn, I suppose, concerning the human right to a stable and safe climate, as it is envisaged under the atto di citazione in the Giudizio Universale case that you mentioned. I'm not entirely comfortable, if truth is to be told, with the human right being figured out of thin air, literally. I mean, I would feel much safer if it were to be premised, grounded on existing positive envisaged under human rights catalogue positions. Still, if that is the case, if the Tribunale Ordinario di Roma ever gets to accept the claim on the part of the representatives of the ASUD ONLUS, do you think it would be a first generation right, a second generation human right, or a right of the peoples, if we are to use this petty and probably old-fashioned classification of human rights? Would it be individual in nature? Would it be collective? I'm trying to get a bit of a blueprint here to try and foresee where this might be going.
Thank you for your question. This is a great question. I think we are all open to speculation on that second aspect that you mentioned, absolutely. But I think this is directly relating to the second trend in the choice of available legal basis for this kind of litigation, because we see that the human rights violations that are being pleaded in that case, they are merely relying on the Italian constitution, so the protection of the right to health, with the interpretation of the Constitutional Court on the right to a healthy environment, and clearly also the rights that are protected by the European Convention on Human Rights. So Article 2 and Article 8 are included in the summons. But the fact that you can claim this article, the human rights protection that is part of these articles doesn't exclude the fact that you can also try something new. And the legal team in Italy that is supporting this case is deriving this right to a safe, sustainable climate system from Article 2 of the Constitution that provides the open catalog to human rights protection. So I hope that answers your question. I'm sorry, what?
Thank you. Absolutely, by all means, it does answer my question, but it triggers yet another question. If the legal ground is supposed to be Article 2 under our Constitution, possibly together with Article 32, Article 9, I'm guessing, it will be quite a long step to have it copy-pasted under other jurisdictions, I guess.
Let's have this conversation once we have the judgment.
Oh, I cannot wait.
That will be a great perspective.
Oh, God, I cannot wait. Thank you.
Okay, then there is a further question over here.
Is it on? Yes. Yes, good morning still. My name is Christine Bakker. I'm from the Netherlands, but I work in Italy. I teach at Scuola Superiore Sant'Anna in Pisa, and I'm also affiliated with the British Institute for International and Comparative Law in London, where I've edited, together with my colleagues Ivano Alogna and Jean-Pierre Goussy, a volume which came out with Brill Nijhoff in 2021, entitled Climate Change Litigation Global Perspectives. And there we invited special experts from around the world to comment on national climate cases in different jurisdictions, from the US to Australia, also the Netherlands obviously, but many other countries, but also looked at the perspectives and challenges to climate litigation before regional human rights courts and before UN treaty bodies and other international judicial and quasi-judicial fora. And my question, I have two questions, if I may. One to Judge Eike, if I may, and the second to Larissa Alwin. The first concerns the obstacles in using human rights remedies related to climate change. And you already mentioned some of them, including the exhaustion of local remedies. And I've seen indeed that the Committee on the Rights of the Child on that basis has declared inadmissible this very interesting and promising claim before the committee. This might obviously also be an obstacle in cases before the European Court of Human Rights, but I understand you cannot comment on that. But there's another obstacle, apart from also standing, right? Children, young people probably don't have direct standing before the European Court of Human Rights. NGOs on behalf of the population don't. That's another legal obstacle. But I'd like to focus on the victim requirement. You were saying, of course, a case only admissible if the victim can prove it is directly affected. Now, is it not true, as the Supreme Court in the Uganda case has affirmed, based on the jurisprudence of the European Court of Human Rights, that in environmental cases, the protection does not only apply to individuals, but also to population as a whole? And the Dutch Supreme Court referred to cases like Cordella versus Italy, Di Sarto versus Italy, and others. Would you agree that in these climate cases, this would be, let's say, an opportunity for regional human rights courts to continue in this direction of more broadly interpreting the strict victim requirement? That's my first question. If I may just ask a very short question to Larissa Alwin. I find it extremely interesting, of course, to read the legal reasoning in all the Dutch cases, and in particular, the interpretation of the duty of care, which is given, if I understand correctly, in the Dutch cases, goes, and this is my question to you, would you confirm that the interpretation of the duty of care in the different Dutch cases goes into the direction as proposed by Stijn Franken, basically from a duty of care towards a duty of contribution. And would you see that this could contribute to an evolving interpretation of the duty of care also in other jurisdictions? Thank you.
I guess we should, the question should be answered in the...
Okay. Thank you very much for that question. I'm, again, slightly hampered in how far I can answer that, because it is almost the exact issue in the Carême case, which is now before the Grand Chamber, which of course comes out of the successful litigation in France, where a local community was successful, but the mayor who brought it on behalf was the other party, was not successful and was rejected on grounds of standing. And that to some extent puts into sharp focus the very question you raise. I mean, I think there are, and the court will have to look at that, so I'm not going to tell you what I think, because I might have to decide what I think at some point. But it raises a fascinating issue, which also comes out of the cases that the Dutch case the courts, of course, relied on, and that is also one of the points about the choice of basis for the litigation. If there are mechanisms in national law which national parliaments have adopted, you know, we're all in the global north, it's largely functioning democracies, and therefore, if it's been adopted and it's then, that is one basis, and it's dressed up in human rights, that in a sense is probably much easier than coming at it from a freestanding, you know, I'm a victim of a right of a breach of Article 8, without any of those stepping stones, because in a sense you're asking the court to do two things beyond the whether you can be a victim. And it goes to that question. You're asking for the creation or the reading of a right into a provision that doesn't provide for it. It is asking it to, you know, actually in the instrument that was adopted in the 1950s, very much a first-generation human rights instrument. It's either asking it to step outside that and make it a community right, or to stay within that and make it a right that has an anchor somewhere. And that, I think, is where it's so far been easier, because there was a choice where domestic law provided for the stepping stones, where the kind of the human rights provided an additional mantle to something that existed already, rather than being the freestanding claim. But I mean, we will have to see. But so I'm sorry I'm dodging the question, but I hope that was helpful anyway.
Well, I have to, the question, in fact, invites me to comment on my own case, and that is exactly what I cannot do. So I would say, read the cases carefully and draw your own conclusions. And I would like to return to my earlier remark that these cases, of course, contribute to the discussion about the obligations and the scope, etc. So that's all I can say about it. Yeah.
I didn't write the judgment, so I can maybe easier to make. The funny thing is that's typically what we see of our clients. So we have a lot of corporate clients, and after the sale judgment was delivered, the first reaction was shock, to be honest, really shock. We never expected that judgment to be delivered. We believed Urgenda was a fair case, a fair claim, and that it was a good chance of success. Shell, we were surprised. So it was a shock within the government, it was a shock within the industry, but what followed now, and we are actually, large part of my present work is sitting with corporates in the Netherlands and discussing with them how they should adapt, because the one big lesson that they learned from that judgment is you cannot sit and just wait until the regulator has done something in the future. Just act. And that's the interesting part. And that's also the basis for my suggestion that we should stir up, that we should use the civil law and the courts to stir up that position, because there's a great willingness. There's a huge willingness in society, also in the corporates, to adapt. They see a chance, they see opportunities, they see profit. They only need a level playing field.
So there is a last question from Hendrik, or intervention.
Right, thank you very much for these very interesting presentations. I have a question to Tim Eike, and it concerns the judicial dialogue between national courts and the European Court of Human Rights. Now, if we just assume for a moment, if there is a case there is an Allwins court concerning the European Convention, I will assume that you look for case law from the European Court of Human Rights to see if there can be some answers there. If we then assume that there aren't clear answers, we are in an area that hasn't been dealt with by the European Court of Human Rights. We'll see that the national courts, they will make an interpretation of the convention, and that interpretation, if we see some general tendencies about the interpretation of the convention, general tendencies at national level, will the European Court of Human Rights take that into consideration when a case will land at the table of the European Court of Human Rights?
Thank you for that question. Well, I think the reality is on something like this, we follow very closely the national jurisprudence across the currently 47, soon to be 46 member states where it arises. Because it is conscious that we're being invited to step beyond what the court has found so far. And therefore, under the living instrument doctrine, the court will always look at, is there developing consensus, where does it lie, etc. And that, in that context, of course, national decisions are hugely important, and that's why, we're very conscious as soon as they come out of the decisions in the domestic courts at all levels, frankly, because this is such a novel issue that, if we restricted ourselves to the Supreme Courts, then we'd be a bit more limited. So we look more broadly, and we look beyond. So we're conscious of what the Inter-American Court does. We're conscious of what the UN treaty bodies do. And therefore, that is an ongoing dialogue, which we have through judgments. And you can see, it's not always very clear, but you can see in some judgments of the court where actually we show how much of the other jurisprudence we've taken on board. So, I mean, on a very different field, but which poses some similar questions. The bulk data interception cases, Big Brother Watch and Centrum for Rättvisa, against the UK and against Sweden, placed huge emphasis, paid huge attention to the Bundesverfassungsgericht judgment on bulk data interception, because it was a superior court from within the jurisdiction which was grappling with an issue where we were invited to identify what the requirements of the convention were in relation to a problem we hadn't previously addressed. So, yes, I mean, that is a dialogue that goes on, and I mean, one of the reasons I'm here is that the dialogue doesn't only happen through judgments either. So, I mean, there's lots of conversations we have, in particular with the national courts, but also more broadly, away from the judgments, to get a sense for where we are. But I think one of the things you can also see, and of course Filippo was right, that there is a significant success rate, but in relation to the narrow question we're confronted with in the convention context, if you look at all the sources I've identified and you've identified, actually the answers aren't all singing from the same hymn sheet. I mean, that area of the law is still very much trying to find its way. So again, coming back to the difficulty as an international court, without the democratic backbone of other legislation and bases, is that identifying a growing consensus across the 46 member states as to how far Article 8 encompasses the right to a clean, healthy and sustainable environment is a tricky endeavor. And the question really is, does that consensus yet exist? Because so many of the cases, rightly, are brought on a variety of bases, and the courts will choose the bases with which they're the most comfortable. And frequently, my impression is, and others may disagree, the human rights mantle, they're using that as an expression of the democratic legislature to say, well, this is something a meaning we might be able to impute onto human rights. So human rights provide another mantle rather than, and I think it goes to the point about bottom up rather than top down, which I think so all feeds into that. But I mean, yes, we do pay very close attention to all of that. I hope that answers the question.
Thank you.
Well, not far from Ferrara, there is the ancient city of Ravenna. And if someone who is staying here for this conference has not seen the Mosaics of Ravenna, I would very urgently invite you to have a look at them if you find the time during the coming days. What we've seen this morning is that climate change litigation is a very important, in my view, a very important part of the mosaic of climate change, of the measures which we can take in order to mitigate climate change and in order to prevent a disastrous outcome. Strategic litigation is important, and I think we have also seen that sometimes in the discussion, and Gerhard, we have had quite a number of discussions already on the topic, the argument is if we go down the drain of holding companies liable for what they've done in the past or do in the future, then everyone could litigate against everyone. I could sue the farmer next door for the greenhouse gas emissions of his cattle. I'm not going to do that. We've seen this morning that is not the case, the type of case which is happening in reality. What is happening in reality is, I was very happy to hear what you told us about the ensuing proceedings and the talks with the companies. How can they comply with their legal obligations? And I think that's a very optimistic conclusion. Thanks to all the panelists, thanks to everyone who intervened in the discussion, and I think we have rightly deserved a break and a lunch now. Thank you to Alberto for providing that.
Okay, excuse me. Before to start with our session on enforcement of climate-related issue, I give the floor to Professor Massimiliano Mazzanti, that's the Dean of the Faculty of Economic and Management. Please.
Okay. Good afternoon. First of all, I am very pleased to have you here, so welcome. University of Ferrara, clap to Alberto for organizing the event, and thanks to all of you for being here. It's an event. I'm just using 5 minutes of your time, so to present some food for thought from my perspective of, say, social scientist, economist also, but broadly social scientist on climate change and justice, I mean, giving one perspective, which is maybe additional to what you have talked. As you know, but we have to recall even maybe you had the targets, but I think the targets are useful to, in terms of communication to society. This is a very radical challenge, which implies radical incremental, but radical transformations in behavior, technology, culture, organization of society. And yeah, so that's the time plan. When I talk to firms, like it or not, believe it or not, this is a binding target. So you have to cope with it by innovation and new way of thinking. I mean, maybe you also have the link to, you know, there are movies and books about utopia and dystopia, so that's also a side on humanities on that, but which is important because of culture. So you know that I'm not replying this. What I'd like to stress, that's maybe it's not my obsession, because you see here that the just is bigger than the European Green Deal. Maybe a coincidence, maybe not. So the point is that in order to have an ecological transition, Green Deal, you must have a just transition as a pillar, okay? Which may imply different things along social perspectives. Given that my first degree was also, I mean, actually I graduated in labor economics with a thesis on environmental taxation 25 years ago. The point on labor is really important, okay? In the 90s, we had in Europe, when I was a student, I read the Jacques Delors White Book, in the Jacques Delors White Book 1991-92, okay? There was a chapter on the ecological tax reforms. Okay, now the term tax, it is not so fancy. We have the emission trading, which is another market-based system. And just in brackets, I'm sharing this with you as well. We didn't, no, I did, because I'm in favor more of a carbon tax compared to emission trading, but I'm fine with emission trading as well. The point is that when you talk about a tax, okay, then people fight, okay? 90% of SMEs don't even know that the emission trading is in place. This is interesting, okay? While if you talk about a tax, we fight, yes, no, okay. They don't know, and people, I think that people don't know. The biggest climate policy in Europe and maybe worldwide, people don't know about it. Then the directive, you know, is 2003, and the price is today 95 euros. I don't have numbers about people awareness. I mean, if you have, but I'm pretty sure that People don't know, but they pay. If I take a flight, now I pay, because the aviation is included in the emission trading system, okay? So before, I had the possibility to voluntarily pay for the compensation. Now it's also, I mean, my last flight me to Copenhagen after 2 years, I could pay in addition to compensate, to offset in CO2, but in the price, given the aviation is in the emission trading system, you pay. And you don't know because the price is, the additional price of CO2 is included. To say what? The just, and the slide I'm going to present, and then I'm done in 2 minutes, sorry, is this one. I'm pretty obsessed by this fact, very well-known fact, okay, which is the decrease of labor versus capital and profits. As you know, sorry to bother you with that, even in terms of GDP, strict GDP terms, we know works by Nicholas Kaldor, John Maynard Keynes, and others, we have to have a balance between profits and wages. Henry Ford saying we have to increase wages because workers have to buy my cars. Okay, so that's the intuition, very simple. You see this decrease in the labor share, which is a decrease in the wage share of the economy, which is not sustainable in social terms, but even in economic terms. This decrease in labor share is behind recessions, because demand is not enough, okay? So that's the point. So we have to increase wages, minimum wages. You see differences, okay? You see, which is fine, I mean, with all the pros and cons. France and the US. In France, they pay 48 tax on GDP. I mean, in Sweden, Denmark, in Germany, 46, 47, different models of capitalism with all the pros and cons. I'm not saying Germany and Sweden is better than the US. I'm just saying different models. UK, 33, US, 26. 26 of taxes in the US, 48 in France. Okay? Which is stunning. I mean, it's really astonishing. But we have implications in terms of all different things. But the point is that I think that the green economy and the climate policy implementation should be analyzed with a concrete connection to the type of capitalism you have, and with attention to the fact that the social pillar, I mean, which is also inequality, which is, as you know, much higher in the UK and the US compared to Sweden, Japan, Germany, okay, is an issue that we have to have in mind, because without a strong social acceptance and also economic demand, I would say, because you have to buy greener goods or you can't have a sustainable transition. For sure. Okay, so that's final slide. If I may, if you want me reading, this is a report I'm pretty proud of. A report we published for European Environment Agency, downloadable. If you Google the title, you download the report. Why, and this is our conceptual model, which goes back to what I was saying. You have to integrate the ecological transition with all the other transitions, okay, in place. The technological one, okay, which is not enough. The demographic, economists tend to overlook. I mean, the demography, which is absolutely crucial for aging, and aging is relevant for pensions. And then you have taxes that could interact here. Okay, and then the financial system. I mentioned emission trading, which is a financial system. You may have stock markets now focusing on climate change assets, climate stress test on banks, an evolution of things, okay, that from the public and private thing. So trivial to some extent, but let's recall that we have to have an integrated picture of the transitions. Okay, so thanks again for being here, and The floor is yours.
Thank you very much, Professor Mazzanti, for your really interesting consideration and for your speech. We start with the session on enforcement of climate-related issues. Different reports and working paper on climate change litigation confirm litigation role in influencing the targets of climate policy. Most especially, strategic climate litigation is all cases where the plaintiff motive go beyond their individual concern and aim to affect climate policy, create public awareness, or change the behavior of government or industry actors. The global mosaic is complex and includes cases brought before various administrative, judicial, other adjudicatory bodies. This is why I think Professor De Franceschi organized this session taking into account different kind of law and judiciary court. First of all, I give the floor to Pasquale Fimiani. Pasquale Fimiani has been a member of the judiciary since 1986, acting as a public prosecutor in criminal and civil matters, and since 2011 is Advocate General. And he currently works in the criminal sector. He teaches at several Italian universities. I think that is in line. I don't see. You see?
Can you see me?
Oh, yes. Thank you very much. I give you the floor, please.
Thank you very much. Good afternoon, and thanks for the invitation. I have some slides, so I can switch on the slides. Okay. I will speak about criminal law issues and the matter of climate justice. The first step is that the Paris Agreement doesn't state that states should introduce criminal rules to ensure the respect of the measures they shall impose to reach the reduction of the greenhouse gas emissions. And the same law can be found in the European climate law. So, in criminal law, the main principle is the principle of legality, nullum crimen sine lege, which is expressly referred to in almost all international conventions. And therefore, a relationship between criminal law and climate justice can be established only if a criminal rule exists. As a consequence, this scenario entails two approaches of research. The first is the introduction of a new criminal rules to safeguard climate change. The second is the assessment whether criminal law already existing in the various legal system in the area of personal injury, pollution, or damage to biodiversity can be applied by the different courts on the basis of shared principle as far as it is possible. But does exist an obligation of criminalization? The existence of a criminalization obligation in relation to conducts affecting climate change can be based on the European Court of Human Rights case law, which identified criminal protection as a necessary tool to protect the fundamental rights guaranteed by the Convention, when other tools are insufficient. Environmental value is not expressly acknowledged by the Convention, but has been acknowledged in the European Court case law as an element characterizing individual rights, such as the right to respect for private and family life, Article 8, and the right to life, Article 2. The court hasn't dealt with the topic of the criminalization of conducts affecting climate change yet. Therefore, no theoretical hindrance seems to exist to the application on the European case law, even on the safeguard of climate change by the means of criminal law, as a matter of fundamental rights, and an opening toward this perspective, even if it is a national opening, comes from the decision of the Dutch Supreme Court of the famous climate case Urgenda. We have two possible models of criminalization. The first possible model is the so-called international criminal law model stricto sensu, which basically includes the so-called core crimes. The crimes provided for in international customary law and included in the statutes of the international criminal codes. And the main effect of this legal system is to raise to direct individual criminal liability for the violation of key rules for the international community with no need for a national implementing legislation. The second model is the so-called TFRI crimes that defined by TFRI based on agreements whereby states have the obligation to criminalize conduct with the national legal system and prosecute the alleged criminals. Okay, just a moment. The first model, in the first model, we can find this proposal in the last year from the Stop Ecocide Foundation. This proposal provides to introduce the crime of ecocide in the Rome Statute. The new Article 8-ter, ecocide, for the purpose of this statute, ecocide means unlawful or wanton act committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. The proposal explains the definition of ecocide in the second paragraph, and we can read this, but for time I pass to the next slide. For scholars, there are critical aspects of the proposal. The first is that ecocide appears to be a fluid concept, which may take different forms and contexts, in open contrast with the principle of legal certainty adopted by the Rome Statute. Second, difficulties in selecting the standard to find a person guilty, as ordinarily required by the Rome Statute, in order to impose a criminal sanction. It has intent and knowledge. Third, lack of technical and scientific specialization in environmental matters within the International Criminal Court. Fourth, limitation of the scope of the ICC to natural persons only, while, as is well known, environmental crimes are known to be a typical consequence of corporate crime. And last, the lack of a specific rule allowing the ICC to order the repair of the environment. So the University College Cork proposal and supplementary of the proposal of the foundation. First, the introduction of an aggravated ecocide in the event that it has or had a considerable impact on greenhouse gas emissions or climate change as follows. Ecocide is to be considered aggravated if it has or had a considerable impact on greenhouse gas emissions or climate change as a result of an intentional action or an omission. The second part of the proposal is the proof, the trial. The proposal underlines that the proof of major impact on the greenhouse gas emissions for climate change is purely scientific in nature. It suggests to be privileged probative force to the reports of the main environmental authority of the United States, as per IPCC. And the third part of the proposal is the introduction of new procedural rules, but you can find on internet all the text of this proposal. Also, the European Union did a lot of actions about ecocide. First, on 20 January 2021, the European Parliament encouraged the EU and the member states to promote the recognition of ecocide as an international crime under the Rome Statute of the International Criminal Court, this resolution. On the 20th of May, the European Parliament stated that it took note of the member states' increasing commitment to working towards the recognizing of ecocide at the national and international level. At the same time, it asked the Commission to study the relevance of ecocide to EU law and EU diplomacy. This is another resolution. Third, the 15th of December 2021, the European Commission submitted a proposal for a new directive on the protection of the environment through criminal law, replacing the directive of 1999. And in the recital 16, stated that when an environmental criminal offense causes substantial and irreversible or long-lasting damage to an entire ecosystem, this should be an aggravating circumstance because of its severity, including in cases comparable to ecocide. But the new directive, the proposal, new directive, does not include the criminalization in general of action that have or had a considerable impact on greenhouse gas emission or climate change among the conducts that constitute a criminal offense. Article 3 of the proposal only refers to limited and specific conducts that may have such effects. Letter A, the discharge or emission of intrusion of a quantity or materials of a substance or ionizing radiation into air and other elements of the environment. The crimes against biodiversity, two letters. Why biodiversity? Why the European climate law envisages among the goals of the Union's and member states' climate action the protection of the integrity of ecosystem and biodiversity against the threat of climate change in the concept of the United States 2030 Agenda for Sustainable Development, recitals 3, 9, 22, 23, 52, and Article 5. And the third provision is letter R, the production, placing on the market, import, export, use, emission, or release of fluorinated greenhouse gases as defined in this article. Okay. So we have the lack of specific national and supranational rules for the climate protection against the climate change, but this lack could be compensated by a dialogue between the courts on issues of a general nature to be resolved according to the same approach, if it's possible. These issues have to be addressed on the basis of shared principles in application of criminal law that already exists in the various legal systems in the matter of person personal injury, injury or homicide, pollution, or damage to biodiversity. Here, I would like to point out 4 issues that could be debated in the study group. First question. May an authorized activity considered unlawful when it is carried out contrary to the precautionary principle? Why this question? In Italy, in the act of environmental crimes implying an unlawful conduct, it is debated whether this qualification can be attributed to the violation of the precautionary principle, even if the activity is authorized. A recent ruling of the Italian Supreme Court has deemed legal and authorized activity in contrast with the best available techniques as established by the European Commission, even before the deadline for their implementation as part of the periodic updating of the authorities' authorization required by law. For an authorized activity, this is the particular of this case. And this decision was criticized by scholars. Why? In the presence of a legitimately authorized activity, which is carried out in compliance with the requirements of authorization, they believe that the conduct cannot be defined unlawful for the violation of the precautionary principle when there is no rule or a precision to make it concrete. This is the object of the debate in Italy now. Second question, which are the standards of evidence for stating that the conduct contributes to climate change? This is an issue of penal cases and civil cases. It's the same. IPCC reports clearly underline that human behavior is a major cause of climate change, but it is difficult to establish the impact of the human factor and the causal link in court when they are compared with the damage suffered by individuals and communities, even if it is only considered as a significant increase in the probability of its occurrence. The problem consists in identifying those who can legally be held liable for these damages. In fact, even if the causal link between an event and global warming is proven, we need to establish from a legal point of view whether the responsibility for the warming can be attributed to one or more subjects, whether they are governments or large industrial groups. The problem gets ever more complicated when the responsibility is theoretically attributed to several subjects. In this case, we should establish whether at least some of them can be clearly identified and find the links between the specific individual responsibilities. Some scholars suggest to use attribution science, which is based on a statistical method called the probabilistic event attribution method, comparing the world as it is, therefore with human influence on the climate, with the world that might have been without that influence. It's a counterfactual analysis that has been widely used in the legal field for facts where the stakeholders and events are well defined, for example, in the field of medical liability. Instead, its application to assess the presence and intensity of anthropogenic influences with respect to extreme climatic events has yet to be verified, at least for the purposes of asserting criminal responsibility. The third question, what could be the level of mens rea required for criminal liability of natural persons? The proposal of the Stop Ecocide Foundation suggests that the provision of Article 30 of the Rome Statute stating that a person has intended where that person means to cause that consequence, or he or is aware that it will occur in the ordinary course of events, is too narrow and would not have been conducted with a high likelihood of resulting in severe and either widespread or long-term damage to the environment. Therefore, the panel proposes a mens rea of recklessness of dolus eventualis, requiring awareness of a substantial likelihood of severe and either widespread or long-term damage. This mens rea is sufficiently onerous to ensure that only those persons with significant culpability for great damage to the environment will be held responsible. But the proposal of the new Directive of Criminal Environment Protection provides that in general, criminal offenses must be committed intentionally, so a different approach, and that only some conducts constitute a criminal offense when committed with at least serious negligence. And a third approach is the proposal of the University College Code that refers for aggravated ecocide to an intentional action or omission. So we have three different approaches to this issue, the issue of mens rea. And this could be one of the issues that in the study group we can approach. And the fourth issue is this. What is the minimum organizational standard that legal persons must adopt to show that they have done everything possible to avoid the commission of environmental crimes? Companies often use for the management of environmental problems internationally recognized regulations such as ISO 14 and 1 standards and the regulation, the famous regulation, EMAS regulation. The Italian Supreme Court considered that the proof of the adoption of this system, not binding system, but voluntary system, does not automatically entail the intention from liability because they not contain the identification of the offenses to be prevented, the procedures to know the models, the code of the conduct, and the directed procedures, and the system of internal sanction for violation of the model. And these systems are of a general nature, whereas the models suitable for preventing the commission of offenses must be measured according to the specific characteristics of the company. However, in Italy, companies, organizations, and several scholars consider this approach too severe and suggest that these models and category guidelines may represent a useful basis to be integrated. And the aim is the realization of a specific organization model according to predetermined patterns whose compliance should lead us to presume the compliance and transfer the burden of proving the organization fault to the prosecution. These are, in my opinion, four of the most relevant issues to be focused by the study group about the criminal responsibility and the criminal law. Thank you very much.
Thank you very much, Dr. Fimiani. I think that in general it's very useful, the dialogue between the courts as you suggest. Thank you for your really interesting speech. And now I give the floor to Matthias Keller, Hague and Administrative Court, on new challenge for administrative judge. Professor Dr. Matthias Keller is judge, as I said, in the Administrative Law Court in Aachen. In 2004, presiding judge on administrative law court. He got a doctorate in administrative law at Würzburg University. Please, Professor Keller, you have the floor. Thank you.
First of all, thank you for being here. Do you hear me good, loud and clear? And it's a wonderful event. I've learned so many things here, and I'm very happy to be here. New challenges for administrative judges, from my perspective. I am an administrative, oh, thank you. So I think I have a loud voice, perhaps I do not have to repeat my first sentences. I'm very happy to be here. New challenges for administrative judges, from my point of view, it's a special perspective. I've been busy with judicial training since more than 20 years, 30 years almost, and training for my fellow judges. So my biggest challenge was to keep my fellow judges awake, because training is done after work, and training was in European law and environmental law. So this may explain my special take on the topic for today. So first of all, we should have a short word on complexity. I mean, we're dealing with a lot of open questions, and my question goes out to you. What do you do when you're faced with a lot, or confronted with a lot of complexity? So my personal experience is, as a judge, I leave the context. I go to something more general, something out of the legal context. So, and fellow judges do this, and it's very interesting to see their different approaches, because it shows a little bit the education, the personality, the take on problems, and some refer to literature because they have an education from school, from university in literature. I like this approach very much, especially when it's Italian literature. And I'm told it's a standard literature in Italian schools, I Promessi Sposi. And it's very interesting to see this old wisdom, la ragione e il torto. You can never split right and wrong with a cut, no matter how exact, so that each part contains only one or the other. So it's always a little bit flawed. Something I mean to keep in mind when we discuss what climate justice, what climate injustice should mean for us. And perhaps you know, among your colleagues or among other students, there is this other mindset, this bright mathematical mind. And perhaps this is more appealing for the mathematical minds. This is an impossible triangle. And look at it. You cannot define the distance. It changes. It's an optical illusion. So when we talk about climate justice, it's near and it's not so near. We have a sort of impossible triangle here: factual problems, policies not comprehensive, and of course a public law that may be not fit for purpose. And when we come back then to a real life scenario, and you would talk to judges about climate change, I would assume that at least you got 2 or 3 of the reactions that I have here. So 10 probable reactions of a judge. I am not a policymaker. It's up to the legislator to decide on the law. I have to say what the law is, not what the law should be. I am not an enforcement agency either. I have no policeman at hand. And very important, I have life tenure. I have life tenure. I am not elected and cannot be held accountable. So this poses the question of democratic legitimacy. I have an education in law, not math, physics, statistics, biology, meteorology, whatsoever. So sorry, I cannot assess the relevant science context. And more legally, that is referred to judicial self-restraint. I will, and this is a very important one for us judges, I will not base my decision on uncertain facts. When you enter in the judiciary, you say, oh, well, I have a law degree. We will have a talk on legal things. And then you're kind of frustrated because the talk is all about facts. And therefore, it is difficult if you have very remote causal links and uncertain facts. Next one will be, I have to respect the limits of the state-of-the-art interpretation of the law. I cannot make out of white a black color. I have, and this another one, I have only a local jurisdiction. Climate justice is a global problem. And for those who had Latin in school, I know the meaning of ubi jus ibi remedium. However, sometimes there isn't. And number 10, which is for me the most dangerous, I'm beginning to think that climate cases should be treated like any other cases. So what should we do in this situation? My proposal would be just look at the judges that we have here, that we heard this morning, and judges from around the world have set an example and taken into account the new challenges of climate change. And here's my approach then. I will take some illustrative cases with solutions found or not found. So first we go to Vienna, Austria. It's a very simple case, and I can summarize it. The old question from '72, should trees have standing? And the Austrian Administrative Court of Appeal said, yes. Even after being cut down. Isn't this inspiring? It's a classical public law case. Mr. A wants to cut down trees. He gets a permit. The permit is challenged. But the judge says, too late. The tree's already cut down. and then the NGO goes to the Court of Appeal, and then a miracle happens. The action brought by the ENGO is admissible even after cutting down the trees. Defending the trees make the ENGO a special party. The ENGO's action is a public interest proceeding under Aarhus and EU law, and not a traditional subjective rights claim within the administrative justice system. So no Rechtsschutzbedürfnis, no subjective legal protection interest. For Germany, Austria, Czech Republic, this is a bomb. Inspiring, isn't it? United States, at the moment, not so inspiring, because you have certainly heard the question in the US is the scope of the delegated powers to the EPA. And there was a Supreme Court ruling, Massachusetts v. EPA from 2007, where a 5-4 majority said, yes, the Environmental Policy Agency can make a rulemaking on CO2 emissions because CO2 is a greenhouse gas and it's covered under the US Clean Air Act. But we have a brand new decision, West Virginia versus EPA, decided June 30, and a 6-3 majority says no. The given delegation to EPA or to the agency does not cover such major questions that are to be decided by Congress. This is a little bit like in German the Wesentlichkeitstheorie. Essential matters have to be decided by Parliament. Well, Judge Elena Kagan was very frustrated. Whatever else this court may know about, it does not have a clue about to address climate change. Dissenting. Well, Germany, and here we have a little miracle. Federal Constitutional Court, they are able to establish standards and rights from non-binding norms. This is the famous case Neubauer. It's a little bit our Greta Thunberg in Germany. And how to derive from non-binding targets, so to say, Paris Agreement, binding norms. This is a legal miracle. What did the German Constitutional Court say in essence? This binding comes from a governmental self-commitment. We have constitutional law, but there are no binding standards as to CO2. The government, in his law, made a self-commitment to the Paris Agreement. So, conclusio ergo, this is binding the legislator on the constitutional level. Yeah, it's interesting. And as it was said before, you even have fundamental rights against incomprehensive CO2 legislation, against a Climate Protection Act that is too generous with CO2 budgets till 2030. I'm a first instance judge. For me, the verdict of the Constitutional Court is a little bit too overloaded. Too many professors there, sorry to say that. And they like concepts, and they like creating concepts. And if it's a German concept, it's like a big sausage. No one can understand that. And it's the key concept is eingriffsähnliche Vorwirkung, advanced interference-like effect. Who talks like that? So, I mean, if we're here in Ferrara, if we go back to Rome and Roman law, and we could coin it so easily I do neighborhood law, and Roman neighborhood law in the classic period, they developed damnum infectum. It's a loss not yet suffered, but it's a loss threatened or apprehended. And then you have this Latin coin, everybody will understand. If you don't understand, you wouldn't admit at least. And therefore, it is very interesting. The problem is government should not offload the problems to the next generation. And therefore, young Luisa Neubauer has a fundamental right against the legislation on climate protection that was too generous concerning the budgets till 2030. There's already this effect because later on there will be severe restrictions of fundamental freedoms for the young generation. So as time is very, very important in climate change, I hope I keep my time here and come to the conclusion. Climate justice is complex. That's not very new, but it is complex and has been treated as such. Austria transforms its administrative justice system concerning public interest litigation. It's only the beginning, but it's very interesting to see that. Well, the US, for the Environmental Protection Agency, necessitates a broader empowerment for rulemaking on CO2 emissions. And Germany, Karlsruhe, the German Federal Constitutional Court, established binding CO2 budgets and fundamental rights against future restrictions of liberty. Thank you very much.
Thank you very much, Dr. Keller. Also to remember us the famous case Neubauer versus Germany decision. Also because different complaints were filed against Länder on federal state, not just state. So it's very interesting for our discussion. Thank you very much.
You're welcome.
And now I give the floor to Gregor Waziewski on climate justice, Polish perspective, internal and external challenges. And Dr. Waziewski is a legal advisor, and he holds the PhD degree in and also an MA in sociology. Thank you very much to be here, and I give the floor to Dr. Waziewski, please.
Thank you very much. I hope you can hear me without any problems. Okay, I do hope so. Thank you very much for inviting me to share few thoughts. Many thanks to Henrik and Alberto for having me here. And I must admit that I very much enjoy participation in this discussion and hearing on different perspectives regarding climate justice. And I'm happy to have my humble contribution to this debate. And what I wanted to briefly present, I'm a practicing lawyer, a partner in a law firm, but at the same time, I'm a university lecturer. So a kind of a brief overview of the climate justice problems which could have been recently identified in relation to Poland. And maybe to begin with, I would say that considering also the progress of this debate today, I think that countries like Poland and alike are an interesting arena to observe in terms of climate justice, because on one hand, these are countries where the consciousness of public, the general social consciousness, as far as environmental issues, as far as climate issues are concerned, are growing. And obviously, people are getting more and more aware of the climate challenges that lie ahead of us. On the other hand, there is, of course, a number of obligations and requirements resulting from the EU membership and the subsequent European regulations. But this, in the end, needs to be confronted with the status quo of the given countries, and especially countries like Poland, where the energy market for many years has been based on firing coal. The energy market transformation is obviously a challenge and something that not always goes that easy. So therefore, we can observe with the struggle some challenges regarding the need to reduce emissions, the need to reduce pollutions, the need to improve quality of the air. This struggle and this discussion regarding transformation of the market can be seen on different dimensions. And for example, when after the aggression on Ukraine, Franz Timmermans said that it may require adjustments to the schedule of the Green Deal, geopolitical situation, and possible disturbances within the European energy market. Polish coal industry, for example, tried to interpret this statement as a possibility of returning to the business as usual, where again coal will be a key fuel, which I do not think was neither the intention of Franz Timmermans nor that that would happen. Quite contrary. Personally, I think that the current complex and geopolitical situation will rather result with speeding the process of transformation of the European energy market rather than to the contrary. So that's obviously a kind of a challenge that lies ahead of countries alike. And for this brief and short presentation for today, I tried to find some examples of different dimensions to illustrate how the climate justice problem affect Poland or how they are dealt with in Poland. Two of those examples are of an internal nature. One is the judicial decisions of the civil court, one of the administrative court, so illustrating different perspectives and different problems arising. The remaining one is of a more regional European nature, because as properly was noted by Henrik in his opening statement, the climate justice issues, of course, become more and more cross-border issue, not only a national, a domestic one. Thinking of those internal elements and those internal dimensions that I wanted to briefly discuss, meaning the one resolved by the civil court, the one resolved by the administrative court, what they do have in common is that both of the cases were initiated by individuals. And that can be something which is observed, the growing number of claims which are being submitted by individuals. They may be often some climate activists, so to call them, or they can be some well-known celebrities. But that maybe not that wrong, because in the end, if the claimant is the famous person, a well-known and well-recognized person, this gives more public attention to the case and more public attention to what the court in the end will decide. So from a kind of a public dispute perspective, from the perspective of the public sphere, it's quite an interesting. To observe how those cases, even if initiated by the individuals, try to deal with or try to put some pressure on the state to deal with the climate changes issue and with the environmental problems, because it is indeed one of those examples of the situation where some individual concerns are the basis of a claim, some, so to say, individual discomfort related to a climate change process and to environmental problems. But eventually, the aim of those claims is not only to address this individual discomfort, but to bring attention to some more general issues and to bring attention to some more general systematic problems related to climate and climate change. And both of those cases, the civil one and the administrative one, are of that kind. And to say so, they are quite positive examples, illustrating also, on one hand, how the individual claim can interfere with some more general problems and some more general perspective. But on the other hand, also, how the Polish courts try to solve the new challenges with the traditional tools they do have and they are used to. The civil court case, which I wanted to briefly discuss, was, and it is interesting because it went through all instances and became binding. So in a way, I mean, even if Poland is not a country of precedent, obviously, because the Supreme Court was also involved in this discussion, it is a kind of a road sign, a possible guideline for other courts which would deal with this issue in the future. So the case was initiated by a citizen which sued the state treasury for compensation on the basis of violation of his personal right. And the argumentation of the claimant was as follows: that he lives in a town where the emission norms exceed the standards for most part of the year. Therefore, because of this level of pollution, he feels that his personal rights, like personal right to clean environment, personal right to health, private life, freedom, are violated because he cannot enjoy fully his life in this situation. He cannot fully enjoy his property if he cannot open the window because of the pollution. He cannot go for a walk or hiking and should stay inside. May have some health problem as a consequence of the pollution. So that was the basic argumentation which was raised by the claimant, and the court of the first instance decided to dismiss the case on the grounds that the right to live in a clean environment, however important, is not a personal right within the meaning of the Polish Civil Code. So it's not a value, a personal right value, which should be protected as a personal right. The claimant appeal and the Court of Appeal dealing with that problem asked the Supreme Court for the interpretative guidelines. There is an institution in Polish in the civil procedure that a court dealing with particularly complex and important issues can ask the Supreme Court for some interpretation guidelines, so-called legal question. The importance of the decision which is being undertaken by the Supreme Court is that although the response to the question is binding only for this particular case from the formal perspective, of course it becomes a guideline for the cases in the future. And what the appeal court did was to ask the Supreme Court, should we treat the right to live environment as a personal right protected under the Polish law or not? And the response of the Supreme Court was that, which was made in the form of a resolution, was that, first of all, if you think what the personal rights under the Polish code, it's the right to, these are the rights which are connected with human nature, the rights which are dependent from our will, the rights which are constant, which are explicit and objective. And in a way, they are decisive for human physical and psychological integrity. And as the court observed, even though the catalog of the personal rights is an open catalog and it changes in time, depending on some social relations and changing of how the general public perceives certain issues. Natural environment is not a personal right, but it's a common good. So it cannot be treated as something that's protected on the level of personal rights. However, at the same time, what the court did in the resolution was indicating some open door how those kinds of claims should be treated, because the Supreme Court indicated that the violation of environmental standards, of course, can result with violation of personal rights, which harm personal rights like health, like freedom, or like privacy. So therefore, as the court elaborated, of course, for the climate in this situation, it's not sufficient to just state that my right to live in a clean environment has been violated in order to get the compensation. But what the claimant should do, and what in fact in this case the claimant did in his very first claim, was to indicate that because of the violation of environmental standards and norms, his other rights, his other personal rights, like the right to health, to freedom, were violated. So, in other words, the breach of environmental standards resulted with the threat to other personal rights. With this clarification, this interpretation, the appeal court, using this reasoning presented by the Supreme Court, decided to overrule the verdict of the first instance court, and they decided to grant a compensation to the claimant, which is to be paid by the state treasury. And what the court in the justification of this decision explained, exactly because the claimant was able to evidence that by a violation of environmental standards, his rights, personal individual rights have been violated. His right to be healthy because he encountered some respiratory problems. His right to enjoy his property because he couldn't use his property as he would like to because of the air pollution. His right of freedom because, for example, the limitations regarding being outside or outdoor activities. And at the same time, because to get this compensation, of course, one thing was to first evidence that that certain damage occurred, and the court agreed that the climate has done that. The other thing, of course, was to find out if this damage has been caused by an unlawful action or a lack of action of the state treasury. And here the court argued that the fact that the pollution norms are exceeded, it is an evidence of violation of European norms by the state, which was also confirmed by some the verdicts of the European Court of Justice. And what the court observed was that the fact that the actions of the state were unlawful is that also the state made not really much effort to improve the situation within the area where the climate lived. The state treasury representative tried to argue that it's not the pollution is not made due to the state activities, but the key source of the pollution is the dispersed local heating system. So this kind of a low emission issues. But then the court argued with that, stating that even if it is so, that it's the individual heating sources that are responsible for the pollution, it's also in a way attributable to the state, because it means that there is a kind of a system problem that the state was not able to solve. And of course, that was not the sole case on the compensation, but a good illustration because it went to all instances and may be something that will be kind of a guideline for some further climates, indicating how the compensation case can also illustrate some more general problems related to climate change and environment protection. The other dimension, that was the administrative view on that, and here on the other, the administrative court dealt with the issue of so-called climate fee or local fee. In Poland, in the same way as it is sometimes in different other places all around the world, it is possible for the local authorities to impose the payment on the people visiting the given place because the given village or the given place lies within the area of some particular landscape, environmental, ecosystem, climate beneficiary area. So as kind of an additional charge for those benefits. And a tourist in one of the villages in the mountain was charged with kind of a local climate fee, which was not a high, because it was something like 10 euro probably altogether. And he questioned this payment, indicated that he should not pay that, because when he was staying in this village, actually not only he has not benefited from clear air, but because it was a winter time, and again because mostly of this local heating sources pollution, the air pollution norms were exceeded. So he should. There is no ground to pay the climate fee, or this he should not have been charged with that. It was subject to to a review by the administrative court, which was to decide if the resolution of the local council on establishing this climate fee is justified or not. The first question was, of course, is there a locus standi? Is there a justified claim of this tourist who appeared for a couple of days in this town? And here the administrative court gave an answer that yes, because he was charged with this fee and he needed to pay that. And as to the obligation to pay the fee, the administrative court decided that the local resolution established with the climate fee should be found void, just because indeed the village which tried to collect this fee has not fulfilled the environmental standards required for such payment to be made. And the observation of the court again was that the local authorities which want to impose that kind of fee cannot be passive. It's not enough to say that because our village was always a kind of a spa village, was a kind of a village where always people were arriving for holidays, for historical reasons, in a way can impose this payment. But quite the contrary, first of all, should actively verify each time what the conditions, what the environmental and climate conditions really are. And then, of course, if the conditions worsen, they would like still to have this climate fee imposed, it's up to the local authorities to actively try to improve the local ecosystem. So again,
excuse
okay.
me, 2 minutes. Thank you.
Okay. The last one was a kind of a European approach, which resulted, just to briefly discuss on that, dispute between the Czech Republic and Poland regarding the lignite coal mine in Turów. The case was not resolved eventually by the European Court because the countries reached a settlement. But an interesting element of this dispute was the inter-injunction which the European Court imposed. Because the Czech Republic, in the meantime, requested that, as an intermediary measure, to close the activity of the mine, which the Czech Republic claimed that was contributing to lowering the water level on the other side of the border. And what was interesting there was that the Court of Justice accepted this motion of Czech Republic, accepting Czech arguments that any day of delay in the operation of the mine can worsen the environmental situation and can contribute to a harm that will not be possible to be reversed. And even though this interim decision brought a lot of dispute and discussion in Poland, and indeed that's another thing, if one can think if it's possible to close the mine operations from overnight, that would probably have something to do with the quotation from Alessandro Massoni that Professor Keller had made before. But in the end, what was important, I think, was also putting an attention of the European Court that if we need to balance some goods like life, health, environment versus things like economy, energy security of the state, because that were the arguments of Poland for not imposing this intermediary measure. So the climate justice cases, they can also involve sometimes the need to balance quite a number of different goods and different perspectives. Indeed. So to conclude, using my time, I think all those three cases are quite interesting examples of how the courts try to deal with those new challenges, and I'm quite convinced that also from the Polish perspective, the number of those cases and those litigations will, the same as in other countries, increase, putting the attention to some more general problems, but also involving some new challenges that the courts need to need to somehow be able to address. Thank you very much for your attention.
Thank you very much. Really interesting. Now we have 10 minutes for the question, please.
Well, thank you very much first for these very interesting interventions and presentations. I have a remark and a comment on the second presentation by Judge Keller. And I would like to come back to the judgment of the German Constitutional Court, which you kind of criticized as being perhaps too much driven by crazy ideas of university professors. I see it a bit differently, I mean, Article 28A in our fundamental law, in the Constitution, says that it is a goal of the state, of the government, to protect the natural resources also, and that is said explicitly, in the interest of the future generation. So this intertemporal aspect is there. It's already in the Article 20A. And at the time when it was introduced, there was a huge political debate about whether to put this provision into the Grundgesetz or not. And it was deliberately placed after the fundamental rights in the chapter on the Staatszielbestimmung, on the goals of the German state, so as to prevent the jurisprudence from effectuating it or putting it into practice through the Verfassungsbeschwerde, through the individual constitutional complaint, which can be brought by individuals. And so what the court, and of course that was innovative, that there is no question, but what the court did is it sort of freed it from the, I would call it Dornröschenschlaf, the Sleeping Beauty existence of where it had been for political reasons, and made it and transformed it into a rule which is which can be challenged in the courts, and which can put it into real effect in the court. And personally, I think that the thread of thought used by the Verfassungsgericht, by the Constitutional Court, is very convincing. Because if we do not cut down on emissions now, the future generations will have to cut down on greenhouse emissions to such an extent that they can use only a fraction of the freedoms which our generation, if I may say so, has been the privilege to enjoy. And I absolutely think that this judgment is right. And the good thing is that it's not, I mean, it is not only on the specific Klimaschutzgesetz, the climate protection law, which was at issue in that individual case, but as we've seen in a judgment which is just 1 week ago, coming from the highest civil court, from the BGH, where it was used, the judgment and Article 20A was used to give more weight to climate protection than to property right, to ownership. So in the balancing of these rights, the BGH has said climate protection trumps ownership, and with reference to the Constitutional Court, and that's what we need.
Yeah. Alice.
And there is a second question, and after we are, please.
Thank you very much. Yes, I also wanted to come back to exactly the same point of Judge Weller. And of course, Professor Kieninger is much more aware of the ins and outs of German law. So I'm learning a lot now already listening. But my question was a little bit more general, but in the same direction. I understand that, I mean, your point that it's more for academics to conceptualize and to dream, basically, where the law should develop. But is it not also for the judges to do this exactly the same? And this is why, obviously, I mean, I think all of us in this room and far beyond this, we're so enthusiastic about the Urgenda decisions and the Milieudefensie judgment, but also Neubauer. These give new perspectives and indeed, I mean, it's interesting to see that it's not only, obviously, conceptualizing of the constitutional judge, it's grounded in the German law as well, but is there not also a role for the judge, indeed, to interpret the law in a way, like living instruments, adapting the law, which is always behind reality and behind politics, to develop in the direction for which the law perhaps was not written, but needs to evolve in order to address new challenges.
Thank you very much. Have you any other question? No. So please.
Oh yeah, that's a lot to do. Perhaps there's a misunderstanding. It's just my way to present things. Perhaps you know this from colleagues. If something very important comes from a court, and there's a little mockery. That doesn't mean that I really criticize this judgment, but I have difficulties to present the core of this reasoning to European audiences. In Greece, I had to translate it into French. And then you will see that it works perfectly in German. When you have a German education, when you are aware of the German jurisprudence, when you are aware of the eingriffsähnliche Vorwirkung von Planfeststellungsbeschlüssen, von der Anfechtung von Planfeststellungen. But it's, I mean, this judgment, Neubauer, I think it's for Europe, it's for the world. And therefore, I would prefer a more international language. That's nothing more. Who am I? Who am I to criticize this wonderful thinking? Huh? I mean, it came like a dream, a new insight. But with 20A, yes, I agree. Of course, it's meant to be binding, but I'm not sure. What they did is they combined the budgets from the Paris Agreement with 20A. And there is, for me, a kind of missing link between these two levels. And the idea, well, if the German government, if the legislator has made a self-commitment to the targets of the Paris Agreement, and it's constitutionally provided
that climate change necessitates international agreement, international cooperation, well, then they put two things together, I think, when it comes to a very concrete level. When it comes to this idea that you have the younger generation has subjective rights. And that's always the problem in Germany. You have to end up in subjective rights. And there they pushed a little. They pushed a little in this direction, which I would say is good for Germany. It perfectly worked in Germany. 2 weeks later, we had a new legislation. It was totally accepted. And here's a little bit of criticism. It may not work as perfectly for other countries, because they immediately made an English translation, French translation for the world. But I doubt that, whether this rather complex concept of subjective rights and constitutional level combined with the Paris Agreement, combined with a self-commitment of government, combined with an additional idea of subjective rights, perhaps, I don't know, perhaps I'm too complicated. Perhaps for the others it's totally clear. But it's for me very difficult to explain that in a way that the others in Greece or in France or in Poland would say, yeah, that's a wonderful solution, that's a wonderful dogmatic solution for us.
Maybe, yeah, you have another short question? Okay.
Yeah.
No, actually, I'm only professor of private international law, but I've read the judgment, and I absolutely agree that it fully adheres to the usual style of the judgments of the German Constitutional Court, 100 plus pages long, very complicated language, difficult to understand even for a German lawyer who's not a specialist, and even the constitutional law professors are not quite sure what it really means. So I absolutely, what that dogmatic invention really means, I absolutely concur. But I wanted to say something on the first part of your remark. I was listening the other week to a very good presentation by a colleague from the Humboldt University, Professor Eifert, who explained the judgment to the audience. And I remember one thought which I found very compelling, and that is this, why do we sort of, do we take the Paris Agreement and sort of break it down into a national compulsory rule so that we in Germany have to adhere to the Paris Agreement? Because that's not the content of the Paris Agreement. It's not binding in the sense, every state is still free as a sovereign state to pursue its own policy. And he said that adhering to the self-commitment which the German state underwent or signed when signing or ratifying the Paris Agreement is building trust, and that was the most important thing. So if a country like Germany is not able to adhere to the duties which it has entered into by ratifying the Paris Agreement, how should countries like India or developing countries do it. So it's really about trust. Nobody can force it from us. There's no international jurisdiction, but it's trust.
Yeah. And perhaps you could, if you want to have it a little higher, you could say it's a kind of categorical imperative. You don't want the others to behave like that. It's a question, how do you want the others to behave? And that's exactly how you should behave. And yeah, and I think as long as the acceptance is there for this idea, it will run relatively smoothly. But if politics are difficult, then we're in trouble. But I think now it's as concerns Germany, this judgment is very, very widely accepted. Perhaps not by all constitutional law professors there, but the society, the press, the politicians, and so on. And this is a remarkable step forward.
Thank you very much for your wonderful presentation, all the speakers, and thank you for the question. Now it's time for the coffee break, and we understand precisely what is the coffee break, please.
Ladies and gentlemen, and welcome back to our last session, a very rich one. It was already extremely rich, and now it's even richer, because we were lucky to have as a guest here Professor Wilbergarth Ulfbeck, who is an authority in regards of many respects, but also in regards supply chains, and therefore I'm glad to pass to her the chair and to give her the floor for coordinating this session. Thank you very much for being here, and thank you very much for taking the chair.
Thank you very much, Alberto. Thank you very much for giving me this opportunity to chair this session. It was not really planned, as as you just explained, but I'm very grateful you gave me this opportunity, and very honored, of course, to be able to chair this session on a very interesting topic, supply chains, which sort of potentially pulls together a lot of the topics that we have been hearing about today. We've been touching upon private law issues, administrative law issues, criminal law issues, international law, human rights law, and so on. And in a certain way, it all sort of comes together in the supply chain that can be looked upon as a cross-cutting topic that we will also approach from different angles in this session. And we have indeed a very distinguished panel that I will introduce as we go along. We start out with a presentation by William Boyd, who has already been presented, I think, introduced to everyone, also a co-ordinator of this conference, professor of law at UCLA, and at the Institute of the Environment and Sustainability, very relevant for this session. You also serve as a faculty co-director of the Emmett Institute on Climate Change and the Environment, Senior Associate Director of the Institute of the Environment and Sustainability, and Project Lead for the Governor's Climate and Forest Task Force. So we are looking very much forward to hearing your opening presentation on this session, so please, the floor is yours.
Thank you very much. I know it's late in the afternoon too. I hope everyone had some coffee, but thank you for coming to our last panel. It's been such an interesting set of panels all day. So the title of my talk, Privilege, License, and Consent, is an obscure reference to a famous law review article by the American legal scholar and Supreme Court Justice Oliver Wendell Holmes, Privilege, Malice, and Intent, where he was discussing principles of tort law and investigating when tort liability attaches and when certain actions that produce harm are protected by certain privileges. I recognize that this may not mean anything to European scholars and jurists, but I just wanted to explain the title. Now today, I want to turn the inquiry around and ask not about what privileges might protect certain actors from liability, but rather to ask instead what obligations or duties might flow from certain privileges, in particular the privilege of market access and what you might call the social license to operate. My focus is on supply chains, in keeping with the theme of the panel, and the climate obligations and liabilities that dominant or lead firms have for the climate impacts of their supply chains, and how we might think about the legal principles that provide the foundation for those obligations and liabilities. This is a rapidly developing area of law. There has been a tremendous amount of activity in the last decade in the context of voluntary corporate social responsibility approaches around supply chains. There are leading companies and consumer goods organizations are taking commitments for their supply chains. There are ongoing efforts to develop certification schemes for specific supply chains, and there are emerging regulatory efforts in major economies such as the EU, the UK, and maybe even one day the United States. I'm particularly interested in efforts to ensure that supply chains for major agricultural commodities are deforestation-free, focusing mainly on the big three commodities, soy, beef, and palm oil, which are the main drivers of global deforestation, but also timber, pulp and paper, cacao, coffee, etc. I'll just say at the outset, I'm not an expert in EU law, and I have no formal training in civil law, but I have been following the EU proposal on deforestation-free supply chains. I'm hoping Evelyn and others will talk some about that. My task is to think more broadly about the climate obligations of enterprises and the principles in which they are based with respect to their supply chains. So I just want to start with a few facts and then talk a bit about what we mean when we talk about supply chains, how we think with supply chains as a metaphor, as an image, as a way of mapping the global economy, and then talk a bit about some of these emerging regimes of supply chain governance and some of the principles. So a few facts. One recent study concluded that about 80% of global trade flows through supply chains controlled by multinational corporations. I have not had time to check that figure, but we can, I think, assume that it's a very large figure of global trade that is flowing through supply chains. An estimated 1 in 5 jobs in the world are tied to global supply chains. 95% of the environmental impacts of food and retail companies stem from their supply chains. Excuse me. The greenhouse gas emissions from supply chains are much more substantial than the operational emissions for dominant firms. That is, in certain key sectors, more than 90% of emissions for major corporate actors come from their supply chain rather than from their internal operations. Sometimes we call these Scope 3 emissions, right? Supply chains for major agricultural commodities and raw materials are also responsible for significant deforestation and loss of biodiversity, land grabbing, labor and human rights abuses. Supply chains are hard to regulate because they are cross-cutting. They cross multiple jurisdictions. They operate within legal gray zones. They operate within complex corporate structures and contractual relationships that are spread across multiple regulatory regimes. And of course, the pandemic, the war in Ukraine, the concurrent food and energy crisis have all underscored and reminded us of the critical importance of supply chains for the global economy. So what are supply chains and how do we think with supply chains? We all have, I think, an image of supply chains in our head as the kind of vertical link that connects different actors together. These are economic structures, but they are also obviously legal arrangements, and they illustrate in many respects the constitutive role of law in creating economic structures. You can think of supply chains in the context in which they emerged in the second half of the 20th century. So I think of the broad concept of commodity chains as essentially trading relationships that are as old as trade itself. But in the second half of the 20th century, we see the emergence of commodity chains that are controlled and governed by a dominant firm, right? This is what I mean when I talk about supply chains, or what some call global value chains. And the focus that I have here is on dominant firms, large retailers, commodities traders, large multinationals, recognizing that the category of supply chains is more complex and can encompass a range of different models. When, how, why did this model of supply chain capitalism emerge? It really goes back to the efforts by Japanese firms in the post-World War II period to find ways to access the American markets and to get around some of the constraints that the United States was imposing on Japanese firms. And so there's an effort to offshore and to find ways to get products into the American markets. In the 1960s, transnational firms generally adopt the global supply chain model in a search for cheap labor and limited regulations in an effort to reduce the cost of manufactured goods by offshoring production and manufacturing. And in the 1990s and 2000s, supply chains or global value chains really come to dominate most sectors, covering not only finished goods, but also components and subassemblies, affecting not just manufacturing industries, but also raw materials, food production, and all kinds of services, from call centers and accounting to medical procedures, research and development, and even law. How do we think with supply chains? Well, as I said, supply chains give us a picture or an image of the global economy as consisting of complex and dynamic economic networks made up of inter-firm and intra-firm relationships that are transnational in scope. But of course, robust government policies and supports often stand behind the development of these global value chains. And it's quite obvious to lawyers that law and legal arrangements play a critical role in constituting these supply chains. In my view, law has not really caught up in terms of how to regulate or govern these supply chains, but that, it seems to me, is starting to happen in very interesting ways. So I think it's important to keep in mind that global value chains are not just economic structures, but also complex legal arrangements that cross multiple jurisdictions and regulatory regimes. They link precarity with prosperity, at the same time that they work to separate the impacts of production, processing, and transportation from the consumption of goods and services. Supply chain governance seeks to understand and make visible these impacts, to unpack and make visible the labor and environmental conditions that went into producing a commodity. Corporate social responsibility pressures on supply chains have raised the profile of impacts across supply chains and forced some companies to take action or to take commitments, giving a rise to a proliferation of voluntary commitments, guidelines, principles, and codes of conduct. But companies taking commitments and signing on to voluntary principles have struggled to achieve them. Certification schemes have not really worked at scale, and there are ongoing concerns about greenwashing as well as concerns about impacts on competitiveness. Jurisdictions such as the EU, the UK, and the United States, and US states like California are also focusing on regulatory efforts to ensure more sustainable supply chains through public procurement, but also through the leverage they have in controlling market access. In my view, the most interesting developments here are really the regulatory initiatives such as the EU proposal to require that operators, companies importing into the EU markets, exercise due diligence over their supply chains to ensure that the products they're placing on the market are legal and deforestation-free in the deforestation context. In my view, this is the most far-reaching of the different efforts that are happening or that are emerging in this area. Supply chains are also an emerging focus of climate litigation. There was a recent case filed in France against the supermarket retail chain Casino, brought by indigenous peoples organizations from Brazil and Colombia, together with NGOs in France and the United States, arguing that Casino had sourced beef from slaughterhouses responsible for 50,000 hectares of deforestation in the Amazon between 2008 and 2020. And the case is grounded on the duty of vigilance under the French Commercial Code, which requires that companies conduct human rights and environmental due diligence across their supply chains. I think it's a very interesting area to watch to see if there'll be more litigation like this and to see where this case goes in particular. My question, or what are the principles that guide these legal developments? What are the principles that should guide these legal developments? What are the challenges facing regulatory authorities as they seek to govern supply chains? And how can courts fill gaps and create broader legal frameworks through the development of norms of supply chain governance? So a few words on principles and obligations. So the first principle, as I see it, that seems to be emerging in this space is that supply chain governance and regulation is premised on this notion of a privilege, the privilege of market access. And we can think of market access as a privilege that is conditioned on a public purpose, right? I think the EU has a more coherent approach to thinking about market access as a privilege that carries certain obligations. So for example, the REACH regulation on chemicals, which essentially boils down to the principle of no data, no market. If you don't have a dossier of information on the chemicals you want to put on the European market, you don't get access to the market, right? It's a privilege to have access to the market, and you need to take on certain obligations if you want to have that access. The due diligence requirements are another example. There are plenty of other examples we could come up with. There's also an old idea, old for the United States, an old idea in the United States where certain businesses are considered to be affected with a public interest, right? This was the core of public utility regulation that emerged in the United States in the late 19th and early 20th century. It has essentially been superseded by various other doctrines, but the idea is that certain types of businesses, particularly businesses in infrastructure industries that are providing necessities to the public, have a heightened responsibility and can't simply operate as other businesses, but have to take on particular duties, right? Have to subject themselves to particular types of regulation. And this was all happening at the state level, and the state police powers were used to do this sort of regulation. Second principle, market actors must secure and maintain a social license to operate as the foundation of this privilege of market access. So social license, you can think of that as the basis for a legal license, which contains the conditions for operators to access and place products on a market. Licensing laws are essentially permissions to participate in particular markets. Third principle, again, keeping with my title, the license to operate itself depends on consent. This may be a bit of a stretch, but I would argue that it depends on consent of the public, of the demos, not of consumers, but of citizens. Citizens acting on behalf of consumers, acting as a public. We are not just consumers demanding cheap Lufthansa flights and cheap gasoline, right? We are also publics demanding that our governments regulate market actors in a manner that reduces climate harms from our economic activities. That's the argument. Consent has another meaning here as well that intersects with human rights principles and reaches upstream to the upstream end of the supply chain, where we think about free, prior, informed consent for communities at the point of extraction or production, right? And this, I think, is important to think about the supply chain governance as a whole, right? Have communities been informed ex ante and provided their free consent to the activity in question? There are lots of other related principles we could get into. The duty of care has been discussed a lot today. I was particularly interested in Professor Weller's discussion of the duty of care, not under tort law, but under company law, and thinking about what that means from this morning. The duty of vigilance, obligations to conduct due diligence, and finally the duty of disclosure and right to know, right? So the duty of vigilance and obligations to conduct due diligence, right? To me, this is essentially saying firms have a responsibility and obligation to know what is going on in their supply chain. Not easy to do, right? To make sure that the supply chain does not include activities that cause deforestation and environmental damage and human rights violations. Not always easy to do. Disclosure and public right to know, again, also a form of consent. People have a right to know, publics have a right to know how the products they buy are being made and what impacts they have, right? They have a right to access to information about the products that they are consuming, right? And this then puts obligations on operators to audit and disclose, right? This is the core of due diligence. A few words on obligations, and then I'll wrap up. So there's a question in all of this is, what is the point of compliance or regulation? When we think about designing regulations, we need to think about the point of compliance or the point of regulation. And in the EU legislation, or proposed regulation, and the experts can correct me if I'm wrong on this, but my understanding is it's the lead firms or the operators that are placing, the entities that are placing products on the market or exporting products from the market, right? But if we think about it as if we go back to the idea of the dominant firm, it's the dominant firm that is bringing the products to market that has the obligation, right? And that ultimately has to make sure that they're exercising the due diligence across their supply chain. What about financial institutions, though? Banks and asset managers. There are really important questions here. Banks lend money to various actors along the supply chain. What are their obligations, right? And there's a lot of attention in the world of deforestation and deforestation-free commodities to the role of large banks in financing deforestation, right? This can act as a complement to pressures on lead firms to get deforestation out of their supply chains, right, by restricting capital or raising the cost of capital for certain activities. We also, of course, live in a world of asset manager capitalism where investors acting through a handful of asset managers can exert influence, perhaps significant influence on public companies. What are their obligations for the supply chains of their companies, of the companies that they're investing in, or do they have any obligations? Right? Insurance companies, pension funds, et cetera. There's a whole list of companies we should be thinking about in this respect in terms of how these supply chains take shape and are organized. All right, I'll conclude now. I think I have a couple more minutes. 3 challenges, 2 opportunities. The challenges, traceability, and again, this is focused mainly on deforestation, but I think it's broadly relevant to other supply chains. Traceability, challenge number 1. Smallholder exclusion, challenge number 2, monitoring enforcement of operators, challenge number 3. 2 opportunities, thinking about broader jurisdictional approaches at maybe the county district level or maybe the state or province level or maybe whole countries. And 2, the second opportunity, the need for experimentation, innovation, and learning, right? Challenge number 1, traceability. Under the proposed EU legislation, products must be deforestation-free. They must be produced on land that has not been deforested after December 2020 and produced in accordance with local laws. This requires traceability down to the farm level for major commodities. That is very information intensive, okay? So to meet the due diligence requirements, operators would need to provide the geolocalization coordinates, latitude and longitude of all plots of land where the relevant commodities and products are produced, as well as the date or time range of production, and assess the risk of mixing products with those from unknown origins or plots of land where deforestation has occurred. That's a lot of information. We do have remote sensing capabilities that can get down to the sub-hectare level. We can actually now count individual trees from space, right? We have, that part of the challenge is solved in some respects. But the question of whether that plot of land is in compliance with local laws, that's a much, much harder set of questions that requires a lot of information, okay? So traceability becomes very challenging if we're going to require it down to the farm level. And the current regulatory proposal seems to require that. Second challenge, traceability requirements will require more capital and more sophistication on the producer side, which will favor large farms and operators, right? Which will exclude smallholders. And smallholder-driven deforestation is significant in many tropical frontiers, and these are precisely the people that need the livelihood from access to these markets, right? We need to think about ways to avoid a situation where we create islands of sustainability in a sea of smallholder deforestation, right? A pristine supply chain in a larger geography of deforestation is not a win for the climate or social justice or anything else. Smallholders, though, under the current approach, become a risk for the supply chain actors. And so they're concerned, of course, their incentive is to exclude smallholders and avoid that risk. It's totally logical. Third, almost done here, monitoring and enforcement. The number of operators in the EU proposal for deforestation with obligations, compliance obligations, my understanding, please correct me if I'm wrong, is that it is about 200,000 operators. Even if it is a tenth of that, say 20,000 or 50,000 or 100,000, that is an enormous number of people to keep track of, an enormous number of companies to keep track of, right? And so the question here about regulatory capacity and the ability of the regulators to do the due diligence on the due diligence to make sure the due diligence was done, it is enormous. Maybe this can be done through sophisticated auditing strategies and things like that, but it's a big regulatory burden for sure. And there are questions here about the capacity to carry this out. All right, 2 opportunities, then I'm done. A lot of what we talk about in the space of deforestation, forest, and climate policy, right, is built around the concept of trying to get tropical forest governments, particularly subnational governments, but also national governments, to think about wall-to-wall, whole-of-government, jurisdiction-wide approaches to reducing deforestation. There's no little policy instrument that you can take off the shelf and say, this is going to fix deforestation. It's an incredibly complicated problem on unruly tropical frontiers where there is no governance in many respects, right? And so you need to be thinking comprehensively. My view is that this could provide opportunities for the supply chain initiatives as well. Instead of going farm by farm or palm oil mill by palm oil mill, right? You could look at a whole jurisdiction, a county, a district, a state, a province, and you could look from space to see if deforestation is going down and certain benchmarks are being hit in that jurisdiction. You could then do a preferential sourcing regime from that whole jurisdiction, right? This is where the consumer and the consumer goods companies and the importing jurisdictions need to think about creative partnerships with the producer jurisdictions as well. That, to me, is the only way you get to scale here. I don't think you can go farm by farm and mill by mill to really make this work. That could be wrong, though. Last opportunity, experimentation, innovation, and learning. Supply chain governance is a new area. It is marked by great uncertainty, like much of climate policy, about what will work and how it will work across multiple geographies and jurisdictions. And we need to give operators and producing jurisdictions space to innovate and experiment with new approaches. We know from past experience that when we use penalty, what I would call penalty default rules, this is one of these German concepts that we use and doesn't really mean anything, but the idea is that when you create a default rule that says you don't get market access unless you do certain things and hit certain benchmarks, if we make that too strict and it's not attainable, we lose the capacity for any innovation and experimentation. And so there needs to be flexibility in the system either on the regulatory side or courts or both, to create some ability to experiment with new approaches, because this is a hard challenge and there's no single pan-tropical approach that's going to work in every jurisdiction around the world, right? We need to be thinking very specifically about what's going to work in Indonesia with palm oil. It's going to be different than what works with Brazil, you know, with beef and soy in the Amazon, right? So I'll stop there, but I'll just say one last thing on the West Virginia case, because the West Virginia case that Judge Keller mentioned earlier has been much in the news, and it is really an administrative law case. It connects up, though, with this point about innovation and learning and experimentation, because what it does is it greatly restricts the ability of EPA and other federal agencies, well beyond EPA, to innovate, experiment, and to use their statutory authorities in creative ways to solve pressing public problems. That is the real problem with that case. It doesn't end EPA's ability to regulate CO2 emissions, but it does really constrain their ability and other agencies' ability going forward, unless Congress does something, and Congress is not going to do anything in the United States for the rest of my lifetime, right, at least. So administrative law matters a lot for the experimentation, and the design of the regulations occur in the context of these administrative law constraints. So I'll stop there. Thank you.
Thank you very much, Professor Boyd, for this really interesting and introductory talk, putting supply chains into a historical perspective and drawing the lines until today, and reflections on opportunities and challenges. We'll get back to much of that, I'm sure. We'll now move on to the second speaker. This is Professor Evelyn Terran, full professor at Leuven University, where you teach consumer law, commercial law, and company law. And you are also the sustainability coordinator within the Leuven-Gulag Management Committee and a practicing lawyer. You have been working quite a lot with sustainability issues, focusing on circularity, but also more broadly. So we look very much forward to hearing your presentation. Please, Evelyn.
Well, thank you very much for this introduction. And yeah, perhaps I should start with a disclaimer. I have been working a lot on sustainability, but mainly from a consumer law perspective. And one of the conclusions there was that we really need to rethink consumer law, that it can't only be about the interests of consumers and businesses, but that we need to integrate also environmental concerns. And I've also been working on circularity. And yeah, what becomes clear very quickly is that you can't have sustainable consumption if you don't see the broader picture. So I accepted to, speak here today, but it's slightly out of my comfort zone. But if we want sustainable consumption, we also need sustainable production and sustainable supply chain. So I'll look at a couple of, EU instruments today, and I'm sorry, but I'm not going to focus on the deforestation regulation, but I will talk about, the draft corporate sustainability due diligence as a more general instrument that has now been proposed recently. And my main point will actually be that, yes, I do think we need an instrument like the one that has now been proposed, although it has a limited scope. And I do think that it will also have a major impact on other aspects of EU law, but also of national law that also impacts that supply chain. And what you see there is that the traditional EU approach to supply chains, we have lots of instruments that have mainly focused on, the weak party in the distribution chain and the agent we should protect. And then recently we also have legislation on unfair trade practices in the agricultural sector. And of course, we also have competition law that plays a role if we have vertical agreements, typically in a supply chain. And we struggle with incorporating, environmental perspectives into these traditional instruments. So a discussion is ongoing there. All kinds of suggestions and proposals have been made, but I do think we will need to accelerate that discussion if we want also these more specific instruments actually to work. So, yes, we do have sustainability clauses, and the expert is actually sitting next to me. So Yeah, much of what I'm going to say in the next couple of minutes comes from Wiebes' work, and you have criticized what is, well, general contract law and unsustainable contract law, because it's very difficult to, right now, to implement sustainability clauses in a more general, unsustainable contract law. So, yes, lots of companies have codes of conduct and sustainability clauses. Well, there are plenty of studies, but like one of the more recent one refers to, well, about 80% using of the companies that were questions using these sustainability clauses, but only 50% monitor them, and then quite a large percentage, they don't know if they can terminate the contract if something then actually happens that actually conflicts with these CSR provisions. So the effectiveness of these clauses has been questioned, enforceability has been questioned, and also, and then I refer to Wiebes' work, traditional contract law is not well adapted, also not to this problem. So it's about individual interests, most of our national contract law. It's about, well, we have the privity of contract concept, it's not very well adapted to these chains. And it's about private interests, about individual interests, and if we have intervened in the last years, especially to protect consumers or weaker business parties, if judges can intervene, well, then it's to balance the interests of both parties to the contract, but not so much to bring in the broader societal perspective. So, solutions have definitely been suggested in the literature. And for example, interpretation, well, a new way of interpreting contract has been suggested, taking sustainability aspects into account. And we have broad concepts like the obligation to act in good faith that could be used also to have these additional duties or the implied terms. And you have referred to some cases in the UK where this concept was used to not only have a look at the interests of the parties, but also to broader interests. Or there are perhaps also possibilities to have a broader understanding of when a third party can actually enforce these contracts. But traditional contract law, and that's the case still in many countries, still looks very much at the intention of the parties. And if it's not very clear that it was intended to actually give rights to third parties, when then courts are not very inclined to give third parties those rights. And in any event, we had the prior remark, and not all courts are willing to go beyond the traditional interpretation of contract law. And we had a quite recent Belgian case where our highest court decided quite literally, and it was about a claim to prune trees that were overhanging branches, and about the abuse of rights theory. And there, our Cour de Cassation said, well, only private interests can be taken into account when determining whether there's an abuse of rights. There is no possibility to look at an adverse impact on the general interests, to look whether such a claim is manifestly disproportionate. It's a claim that has been, or it's a case that has been criticized. And in the meantime, so our property law has been changed, and the new specific provisions on overhanging branches, we have them, do refer to a possibility to have a look at societal or the broader interests, the general interests. But it shows that it could be quite helpful for judges to integrate such principle into the law. We have a reference in the draft common frame of reference on the rules, that the rules, including rules on interpretation, have to be read in the light of human rights. But then again, we have the discussion on how far these human rights go. We already talked about that. Well, and other laws, contract laws, even go further, and often this Chinese law provision is being referred to that actually refers to this duties of the parties to avoid wasting resources. But I won't go into detail. It's quite interesting to look at the concrete applications, because actually this provision is now being sometimes abused by contractual parties to actually be able to do things they couldn't otherwise do, and not so much in the interest of sustainability. Other problems with the current, well, legislative framework, Also something you have already pointed out, we have other EU instruments intervening in this supply chain, protecting the weaker party, like the farmer. We have an Unfair Trading Practices Directive with a very specific scope that has some blacklisted practices, for example, prohibiting unilateral changes. And you have pointed out that this could be problematic if you, from sustainability reasons, as a buyer, want to change the methods of delivery. It could be regarded as a unfair trade practice. So those provisions will also need to be somehow interpreted in conformity with other sustainability concerns. While national rules sometimes go beyond that, for example, we have a Belgian law that allows to intervene in all B2B contracts in a very broad way. No reference, of course, to sustainability, but that general norm has also been referred to as perhaps a possibility to insert societal interests when you have to weigh the interests of both parties and when you have to check whether a clause is unfair, because it refers to trade practices, and perhaps environmental sustainability could be seen as a trade usage, at least for multinational companies, but debated, definitely. Bigger problem, I think, for this new directive and not cleared out is the whole competition law debate. So many of these contracts, horizontal contracts, but also vertical contracts, if you want control in your supply chain, and that's also what the proposal now refers to, well, either you integrate or you need contractual assurances of your business partners. And then the new directive says, okay, yeah, it has to be in compliance with European competition law. But European competition law says that you can't restrict competition. Well, that's for horizontal cases, that's also for vertical agreements, and, well, some publicity there for the research of one of my PhD students, but she's not ready yet, but she's looking into that issue. Where are we today with competition law and sustainability? So I don't know to what extent you're familiar with the basics of EU competition law, so, there is the possibility to have an exemption if you infringe or if you reduce competition. There are a number of conditions to be complied with. There are block exemptions, and if you don't fall under the block exemption because you are too big, then you have to check whether you comply with these individual conditions. So efficiency, beneficial, also for the users. And it's again been the Dutch competition authority that has been at the forefront of this debate as well, because there was a proposal at one point in time of a number of producers of chicken that they would not bring, that they would only bring chickens onto the market that would have more space. And then the discussion was, yeah, but what, okay, the competition law demands that the users have a fair share of the benefit of this, of this agreement. And they interpreted it at the time like, okay, the users, okay, there should be some use for the users, and we will check if they were actually willing to pay more for a sustainable chicken. Consumers weren't, so this was then considered problematic from a competition law perspective. So where are we now at EU level? So we have new guidance on how vertical agreements can comply with competition law, and there's an innovation there. So for selective distribution, if you impose certain qualitative criteria or quantitative criteria on your distributors, and it's one of the ways to ensure your distribution chain is actually sustainable. It has now been made clear that those criteria can relate to sustainability, and there should not necessarily be a link with the product. So that was an issue of discussion. So you can, for example, one of the examples is given, you can demand that your distributors only use cargo bikes, has nothing to do with the product they distribute, that's still fine. That's now in the new vertical guidelines. That is a safe harbor then for the smaller companies, market threshold under 30%. The new due diligence directive applies to big companies. They might have more than 30%, so then it's far more unclear how they can actually be sure that their contracts are in compliance with competition law. We have more discussion on, so the exemption of 1013 in the draft horizontal guidelines, but still there's a rather limited view of how these exemptions should be interpreted. So we have this requirement that if you have a sustainability agreement, the users should have a fair share. Okay, if there's a quality improvement for consumers, fine. Very often this will not be the case. Price will rise if you have sustainability requirements. It's also fine if there are individual non-use value benefits. But then again, you will have to show that consumers or users are willing to pay more for a certain product through surveys, for example, because they feel good buying your more sustainable product. Might not be so easy. And then there is a reference also to, well, positive externalities to society that can be taken into account, but only if that overlaps with the relevant market. So if there is no overlap with the benefits to society and the consumers, we don't accept such a sustainability agreement. Could be still infringing competition law. So for example, if you say, that's the example the Commission gives, we will now have an agreement on sustainable cotton, so less chemicals where it is produced, less water where it is produced. People somewhere out of Europe might benefit from that, but not the ones actually buying the sustainable cotton. No overlap. You can't profit from the exemption. So this is a draft. We see that the Dutch have new horizontal guidelines, the Dutch Competition Authority, and they do go further. They do not require full compensation of the consumers in the relevant market for specific sustainability agreements. And quite interestingly, only last week, an informal opinion was given on collaboration between Shell and Total on CO2 storage, and there they very explicitly refer to, okay, benefit for consumers, but also for society as a whole are taken into account. So, what does this all have to do with the draft directive on corporate sustainability? Will require more control of the supply chain through, if you work with business partners, also contractual assurances. And, well, there will be interaction with competition law as well, and also with national B2B laws. And those, well, possible frictions, I think, need to be cleared out, especially because this especially applies to the big companies that might infringe competition law. Because as said, one of the articles of the draft directive requires these contractual assurances in conformity with EU competition law. It also requires these companies, the lead companies in the supply chain, if there are adverse impacts, well then as a last resort, they have to be able to terminate the business relationship. But there again, we can have competition law problem. We know that if you have a dominant position, and under certain national laws, even just a position of economic dependence, it can be an abuse to terminate a contract. So there again, we have the discussion, yes, do sustainability concerns then, can that be an objective justification for such an potentially abusive termination of the contract? There's even more limited guidance on abuse of position of dominance and on the extent to which companies can invoke policy arguments, environmental concerns. That's a little bit of case law, but in general, there has been some reluctance to accept that it's up to companies to apply public policies. So I'm coming to a conclusion. So what to take away from this? I'm quite happy that there is an initiative like the Corporate Sustainability Due Diligence Directive, but I do think that yeah, we will also need to rethink other parts of the law, and not only because of this directive. If we want to come to a more sustainable solution, I do think that we will need all areas of the law to rethink all areas of private law as well. And I am convinced that we are in the situation we are in because we have focused too much on individual interests over the last century or 2 centuries. And even in private law, we need to reintegrate this collective element. At the same time, it has already been mentioned here today, okay, definitely there are environmental interests, human rights interests, but there's also the interests of weaker parties in the supply chain, and that's also something, a concern to take into account, that all these obligations of this directive will not be posed on the weaker parties in the supply chain. So that will have to be balanced as well. And then finally, already a provision that was already referred to today, this duty of care of directors that is mentioned in the draft directive. And there was already a lot of ongoing debate at national level whether we shouldn't broaden this and also oblige directors to take into account broader considerations and not only the interest of the firm they're working for. This directive now actually requires member states to make sure that directors take into account these broader interests. It also states that this is necessary to ensure that this duty is understood and applied in a manner which is coherent with this due diligence obligations introduced by this directive. While probably the open norms in other areas of private law and also in competition law need the same reinterpretation if we want these obligations to be complied with. Thank you.
Thank you very much, Evelyn, for this very interesting presentation on both contract law and competition law, and pulling it all together in the proposal for this new directive. We will move on to the next speaker, who is with us online, I believe. This is Priscilla de Andrade, who works as a legal officer at UNIDROIT. Hello, are we connecting?
Hello, I'm connected.
Good to see you.
Good to see you too.
So, you are mainly responsible for the agricultural development and private law projects jointly developed with IFAD and FAO, and you hold a PhD in international environmental law from University of Paris, and before joining UNIDROIT, you worked as a legal consultant of the International Institute for Sustainable Development. So you certainly have a lot of qualifications, and we are looking very much forward to hearing your presentation here at this conference. So please, the floor is yours.
Thank you very much. Are you able to hear me well? Yes, okay, thank you. I do have some slides to share. I don't know if I can share my screen. Are you able to see my screen?
No.
No? Now I believe you will be able to.
Yes, here we go.
Yes? Okay. Well, first of all, I would like to thank the organizers for this invitation. It is a pleasure to participate in the first meeting of what I understood is the first meeting of the project on climate justice, organized by several universities and the European Law Institute. As you will see in the title of my presentation, I slightly adapted the title of the presentation to give a broader overview of climate-related issues in UNIDROIT instruments, and not only in the instruments that we developed jointly with FAO and IFAD. So my main intention here is to go through the challenges that climate change may be posing to the private international law and how private international law through UNIDROIT's instruments is contributing to sustainable development and also to this, the challenges of climate change. So very briefly, I don't know if all of you know, UNIDROIT is the International Institute for Unification of Private Law, and it has been widely recognized for its work on contracts, on the elaboration of the principles on commercial contracts, international commercial contracts, the UPIC principles. But the Institute also works on several other areas, as I mentioned here, on commercial and contract law areas. And as you mentioned in your introduction, when you introduced myself, I lead several of the projects that we do in the field of agriculture. So we are looking closely to the sustainable development of supply chains in several of our projects. So here, if we go a step further in the domain of agriculture, you will notice that we have adopted, or we are in the process of preparing several different types of international instruments. And just for the information, UNIDROIT is an international organization that elaborates international instruments, which are both hard law instruments and soft law instruments. So, for example, here in the list of the instruments that we've developed or that we are in the process of developing in the field of agriculture, you will see the three first legal guides are soft law instruments, and then we have the MAC protocol to the Cape Town Convention, which is a hard law instrument, and a modal law on warehouse receipts, all this in the field of agriculture. So, of course, even within the family of soft law instruments, each of these instruments have different legal normative force. UNIDROIT over the years has been thinking about sustainable development, and all these instruments mentioned on the left side of this slide address directly or indirectly these sustainable development goals that are highlighted in the slide. So for instance, I will be focusing this presentation on presenting how the legal guide on agricultural land investment contracts, so the second instrument that you see in the list, and the third instrument that you see in the list have been able to address directly or indirectly, as I mentioned, the challenges of climate change through the use of contracts or corporate law, as I will explain further. But also I wanted to point out that the MAC protocol is an instrument for access to credit and security, and it also indirectly contributes to the challenges of climate change through the promotion of use of better, safer technology instruments, more environmentally safe equipment. So going a step further in the context of the instruments that we elaborate together with other two international organizations which are based in Rome as well, FAO and IFAD. The ALIC guide, the legal guide on agricultural land investment contracts, is the second guide that we've developed within this tripartite partnership. And it looks at a certain segment, let's say, of the value chain, of the supply chain. So before the agricultural land investment contracts, we worked on the legal guide on contract farming, which looked at a specific sector of the supply chain, the production level. Rather than this guide on land investment contracts, it looks at the upstream, the downstream, at contract investment contracts, so lease contracts basically developed between government and multinational enterprises. So there on the slide, you will have a brief overview of the process of how this document was prepared. It was, as normally is the case at UNIDROIT, the instruments are prepared by a working group. Normally, the instruments are prepared during 3 to 4 years. And this guide is quite recent. It was launched last year in September, 2021. So why am I bringing this guide in specific to this presentation? Well, the guide has certain parts. The main objective of the guide, before I go into more detail in terms of the climate, how it addresses climate change, the main purpose of the guide is to address the legal challenges and the problems regarding land grabbing that were the big context in 2014-15 and continue until today. So the ALEC guide does not promote sales contracts, but it addresses how the lease contracts that continue occurring can be done in a responsible way. So the main feature of this agricultural land investment contracts guide is that it seeks to operationalize through private law, namely through contract law, several other international instruments that had been developed before. So it operationalizes instruments, soft law instruments developed by FAO and by other organizations such as the UN Human Rights Guiding Principles and several others. By doing so, it's a quite lengthy book. It has more than 200 pages, the legal guide, 7 chapters, and it covers the entire life cycle of the contract relationship. So it goes from the moment of negotiation of the contracts to the implementation, to how to address causes of non-performance, to dispute resolution and grievance mechanisms, so how to solve disputes. In terms of the obligations, so the chapter on rights and obligations, it clearly states several obligations, not only social, economic, monetary obligations, but also it brings environmental obligations, among which there are references to climate change as one of the environmental challenges that contracting parties should be aware of and should consider adopting provisions within their investment contract in order to have a responsible investment, responsible land and international land investment. So when we go deeper into the environmental obligations that are addressed in the ALEC, and when we consider the climate clauses that the guidance proposes, you will note that the guide gives guidance to how the contracting parties may adopt climate-sensitive clauses. And among the content that the legal guide suggests that could be adopted by the parties are the adoption of climate-sensitive agroecological approaches, so how to organize the farming at a certain level to avoid deforestation, to organize the agriculture locally for climate sensitivity. It also can bring provisions on net zero farming practices and sequestration of greenhouse gas emissions. And all of these provisions really depend on the challenges that say that the multinational company faces, it has the duty to comply with. So we've been hearing a lot about the due diligence legislations that are increasingly being developed, but also, for example, developed countries that have climate obligations internationally, and they reflect the regulatory framework reflects to the private sector the obligations to comply with climate change. So it really depends on the amount of duty of care that the enterprises need to comply with their corporate social responsibility in order to develop these provisions. The guidance does not develop contractual clauses, contractual templates, but it suggests content for the development of these clauses. So as I mentioned, we developed 2 legal guides already looking at the agriculture supply chain, right? The first initial stage of the supply chain on contract farming. Then I just spoke a little bit about the other interface of the supply chain on investment contracts. And now I come to sharing information about the current project that we are developing on legal structure of agricultural project. And this project is recent. We started developing it in 2020. We recently created the working group. The first meeting of the working group was held in February this year. And basically this project on legal structure of agricultural enterprise is looking at the entire supply chain. So how to regulate forms of collaboration within the entire supply chain. However, it has a focus. The focus of the guidance that will be developed is for the mid-segment of the supply chain. So it will be looking at smallholders and especially agri-MSMEs that wish to have better access to market, better access to resources, insurance, finance, and several other objectives. As I said, the project intends to look at forms of collaboration for the governance of the supply chain. So it analyzes both exogenous factors and endogenous factors. Our intention in this project is to understand, for example, as exogenous factors, how sustainability, digitalization, and climate-smart agriculture, for example, combining sustainability and technology, influence the transformation of the relationship among the actors within the supply chain. And what are the legal structures? What are the forms of collaboration available or more effective? What are the best practices in order to regulate the problems and challenges that may be faced? And it was interesting to hear the previous presentations because a lot of the three challenges that were previously mentioned have already been identified within this project. And the focus is to concentrate on what legal forms of collaboration among these enterprises permit sustainability and permit the transformation towards digitalization. But the legal guidance that will be developed is precisely to address challenges of the interdependence among the actors, the traceability, and the control. So what forms of collaboration are we talking about in this project? We are looking at multi-party contracts. So this project will not focus on a bilateral contractual relationship as was done in the contract farming legal guide and as was done in the agricultural land investment contract. It will look at these linked contracts. It will also look at corporations and several types of corporations with or without legal personality and cooperatives. So basically we will be creating a toolbox of options of guidance for that target audience that I mentioned, which participates in the mid-segment. So they avoid all the challenges of unfair commercial practices, of exclusion of their interests in the supply chain. So let's say that we are looking at the structure of the supply chain, not from the leader company's perspective, but at the mid-segment's perspective and how it can ensure that their interests, the interests of the farmers are represented and that they have an empowering negotiation bargaining power. So I'm going through the slides. Please let me know how many minutes I still have. But the basic idea, I think I already gave very briefly a notion, is that we will be looking at these collaborative structures to govern, how to govern and regulate the supply chain through the three types of instruments that I mentioned. So multi-party contracts, cooperatives, and corporate legal structures. And when we think of multi-party contracts, just to give an example, we're thinking of contracts between the members of the cooperative. It would be one type of contract, which would be linked also to the contract that the cooperative would have, for example, with the financial institution and the contract that they would have with the insurance company. So all those linked contracts we would be looking at. In terms of new work, and I'm happy to further elaborate during the discussions, but I wanted to draw the attention of the audience of this event to other new projects. The one that I just mentioned very briefly on the legal structure is a project that we are currently working on and is currently on our current work program. But we have a new work program approaching in 2023 and 2025. And recently, UNIDROIT's Governing Council approved these 4 instruments that I have listed here in the slide. And these 4 instruments have a relation with climate justice, climate-related issues. So the first project that I want to draw your attention to is the project on legal nature of voluntary carbon credits. On this project, we will be analyzing the differences between and seeking to uniformize the understanding of whether voluntary carbon credits are a contractual right or a property. So we will be discussing the legal nature in order to try to further uniformize the unregulated carbon market. Then we have a very interesting project on corporate sustainability due diligence and global value chains, which is precisely taking into account all these new legislations that have been adopted, especially within Europe. And the idea here is to look at the possibilities of uniformizing certain definitions that are within these legislations at the international level. So going beyond the European scenario, and also looking at how the contractual clauses could be adapted. As I mentioned, these projects are all in the pipeline, so we haven't started yet, but probably next year we will be organizing exploratory work and workshops, and I'm happy to keep you all informed if there is interest. We also have a new project on access to justice and environmental matters. And if you recall, in my presentation, I shared several of the areas that the Institute works on. Among them, we work on civil procedure. So one of the ideas is to work on manners to further uniformize access to justice. So to open the discussion in terms of procedural content in procedural matters, because some jurisdictions have the possibility, for example, of class actions for NGOs, for example, to access justice. Others permit third parties and third-party beneficiaries to access through contractual complaints, for example. So the idea is to look at the access to justice in specific environmental matters using the expertise that we already have in civil procedure. And the last project that I wanted to draw your attention is to a project that we will actually be working on with the ELI on global value chains, and especially the impact of artificial intelligence and technology on global value chains. So very briefly, of course, I don't have enough time to go in deep into each one of these instruments, but I wanted to share the information about the instruments that we work on and how they have been developed with sustainable development goals in mind, and not only commercial, economic, private law as was traditionally done in the past. So more and more, UNIDROIT has been adapting its working methods and its instruments to these new, let's say, public law issues.
Please, Priscilla, it's very rude, but please, could you wrap up within a minute
yes,
or so?
I just finalized. Thank you. That was all.
Thank you so much for this presentation, and sorry for interrupting at such a strange point in time. Thank you for these UNIDROIT perspectives, and we move on to the next presentation. And with us we have Professor Rolf Weber, Professor of International Business Law at Zurich University. where you are acting as a co-director of the research program on financial market regulation, and also as co-director of the Center for Information Technology, Society and Law, and as co-director of the Blockchain Center. So we are looking very much forward to hearing your presentation and your perspectives on this issue of supply chains. So please, the floor is yours.
Well, thank you very much for the kind introduction. We have heard a lot about national and regional regulations regarding supply chains, and I try to move now the whole discussion up to the global level, and obviously in such a situation I have to address WTO law. Why is it important? On the one hand, different legal systems or regimes lead to normative uncertainties. The product delivery on the supply chain is practically always of a cross-border nature. Then different concerned states and governments might have manifold and also differing environmental or sustainability perceptions. And finally, and very traditionally, we are always confronted with the fact that borders are used for controls. If you look at the sovereignty principle still governing a good part of international public law debates. In other words, looking from the backside of the medal, it's of course important to improve standardization and harmonization of the applicable regulations, and legal certainty is an important element for all participants on the supply chain. As I said, I'm going to address WTO law. You could ask the question, why? Because all of us, we know that the appellate body at the WTO is not anymore in function, since new judges cannot be appointed due to some reluctance from the United States. But, and that's in my opinion a quite important but, we do have panel proceedings, panels of the dispute settlement body still going on. It is true that decisions of panels cannot anymore appeal against, and they might not be enforceable. Nevertheless, they do have an impact on the whole cross-border supply of goods. Basically, WTO legal framework is composed of two major agreements apart from intellectual property rights. We do have the General Agreement on Tariffs and Trade, the GATT, and then we have the General Agreement on Trade and Services. The GATT covers the cross-border delivery of goods, and that's my main focus for the presentation. The GATT looks at cross-border rendering of services. As far as main principles are concerned, we do have the most favored nation principle. This is one of the two key pillars of WTO law. It obliges member states not to discriminate between like products originating in or destined for different countries. According to legal doctrine, despite some different objectives, it is acknowledged that the WTO accords and the climate-related multilateral agreements may be seen as complementary concepts for addressing the distributional consequences of climate change policies. And therefore, to make it relatively short, the MFN principle does not cause major concerns as far as sustainability objectives are at stake. Second key notion or key pillar, national treatment obligation, prohibits member states from treating imported products less favorably than like domestic products. It's very obvious. The term of likeness is here at stake, and that's somehow the crucial element of any kind of assessment. The appellate body has always said that the likeness concept should be understood in a relatively broad way. And it was also argued in connection with border taxes that the distinction between process and production methods should not be applied. Again, this would make cross-border deliveries easier. And overall, legal doctrine has been of the opinion, maybe not related now to the newest climate-friendly instrument, but to more environmentally oriented instruments, that it would be at least possible to design certain measures in a way that a violation or non-compliance with the NT obligation could be avoided. But the whole area is at least partly contested, and this means that whatever measure a nation state is introducing, it must be analyzed to what extent a risk of non-compliance could occur. Market access is something more directed to the rendering of services, so I can skip that. As I mentioned, NT obligation, national treatment obligation, is partially indeed critical, and therefore the next question is, of course, is it possible to justify a measure which is not compliant with the national treatment obligation? And the answer is the following. We do have justification reasons for national measures in GATT and GATS, in particular Article 20 GATT and equally Article 14 GATS. Article 20 GATT contains a long list of justification reasons, and if any of the listed justification reasons is fulfilled, it can be legitimately invoked, even if the measure as such would not be WTO law compliant. And in the context of sustainability or climate change, we particularly do have two exception clauses being acknowledged as non-trade policies. The first one is related to the conservation of exhaustible resources, that's litera G. The second one addresses measures necessary for the protection of human, animal, or plant life or health, that's litera B. So if any national measures would fall under any of the two justification reasons, in principle it could be applied, but subject to the fulfillment of two other conditions. The measure must be necessary and proportional, so it should reflect legitimate environmental considerations or policies, and furthermore, it must be indispensable and protect public policy interests. We have two other exception clauses, namely the national security, which includes cyber security in Article 21, not so important now in this context, and Article 19 GATT, the so-called safeguard provision. And if I would have had to give this presentation 18 months ago, I would have said, well, it's not really important, but this assessment has now changed, and for that reason, I have to come back to the safeguard exception at a later stage. I start now with the general justification reason in WTO law, and to make things relatively short, I may say that carbon border adjustment measures, CBAM, this morning, by the way, called carbon border tax adjustments by Professor Pestone, which of course is also a valid expression, or an expression used in parallel. So the CBAM concept says that under certain circumstances it is justified to introduce measures at the border, mainly a emission trading scheme, as in the European Union, and by the way also in China, or the taxes, having been the topic of Professor Pistone this morning. As I mentioned, under certain circumstances, what is the objective of CBAM? It should be avoided that enterprises are moving to the places, countries with the lowest environmental standards in order to achieve a situation with relatively low production costs. And in order to avoid that the national or domestic industry would be jeopardized by such movements, it can be justified to introduce CBAM measures. And as you are probably not very much surprised, the respective measures have to be analyzed in view of the conditions which I briefly explained in theory as applied in past appellate body decisions or in past panel reports. And the most important and foremost justification is the avoidance of a competitive disadvantage for national businesses. I just quickly mentioned this aspect. This argument indeed is the most prominent justification. The underlying assumption is that carbon-intensive goods produced in countries with no or relatively low carbon pricing regulations will become relatively cheaper, and this has two disadvantages: carbon leakage risks to more emissions on a worldwide level, because many enterprises are going to countries with lower environmental standards, and they produce greenhouse gas emissions. And secondly, as I also mentioned, carbon leakage can damage the integrity of the domestic carbon pricing measures and have a negative impact on the domestic industry. A second reason in this context is compliance with multilateral agreements, and insofar as certain change has occurred during the last 5 to 6 years. In the past, there was only the Kyoto Protocol available of 1992. In the meantime, the Paris Agreement and the Glasgow Agreement have become more important, and the aspect of compliance with multilateral agreements gain importance and increased attention. Buzzwords are, for example, just globalization or fairness in globalization, and this general policy reason could justify the implementation of CBAM measures. Then we have other justifications, reasons which I'm not going to discuss in detail. If such measures are introduced, of course, higher costs will be charged on the consumers in the respective countries, and it is argued that these higher costs are basically justified since the consumers also cause a climate footprint that should be eliminated. And then we have the other reasons such as the interest of becoming a climate leader in implementing climate-friendly provisions. This was somehow a message which has been conveyed by the European Commission. Or another reason would also be to collect money from the import taxes, and then the question would be how are these amounts applied internally in the respective country. I'm trying to be somehow very short on the assessment. Sorry, I was a little bit too fast with the slide. On the assessment of the respective CBM measures, the appellate body in the past, as well as legal doctrine, interpreted justification reasons of the natural resources and of health, human, animal, and plant health in a broad way. We do have cases, for example, relating to fish stocks, to endangered turtles, and in particular to retreated tires concerning Brazil. And here we have a very clear connects to protection of the environment. In other words, it is relatively likely that climate-driven measures would be considered to fall under either the natural resources or the health exception. That's basically the good news. On the top of that, as I mentioned, it is required to meet the necessity and proportionality text. In this respect, the appellate body has been more reluctant in the past. Panels partly not so reluctant, and as I mentioned, panel reports cannot be appealed against since we don't have an appellate body. And since the multilateral agreements on climate protection underline the crucial importance of fighting climate change, I would assume that the proportionality and necessity text can be met. And then we have a final obstacle in the introduction of Article 20 GATT, that's the so-called chapeau of the respective provision. The chapeau refers to the non-discrimination principle, and as a consequence, it would not be justified to implement arbitrary or unjustifiable discriminatory measures. This leads me now to the question, how should national climate-friendly measures be designed? And basically, I would have to wear here my hat as a practicing attorney at law or as an advisor to the Swiss government. I would assume that this is now not of major importance for our discussions. You can see from this slide that the measure would have to address a couple of issues, namely the object of the adjustment being an ETS or a tax solution, type and scope of adjustment, imports and or exports, calculation of the CBAM, embedded greenhouse gas emissions can be determined in a narrow or broad way and with more or less accuracy, interaction with other countries' policies, in order to avoid that we would have very disparate parallel regulations. And finally, and I mentioned this point, the revenue allocation. The revenue could contribute to the general budget of the implementing country following the same allocation rules that apply to other import taxes, but it could also be allocated to the goal of limiting the increase in global average temperature. In other words, to direct climate mitigation products. This leads me now to the safeguard provision, Article 19 GATT. And here I would like to say that we do have a relatively recent decision. You see on the slides the conditions which must be met by a national safeguard measure, namely unforeseen developments. Imports would much increase to the detriment of the national businesses. The amounts of imports causes serious injury to national businesses, which must be avoided, and the causal link. And these 4 conditions have been considered by a panel in a proceedings between United States and China called US Safeguard Measures in Photovoltaic Products. Why did it come to these proceedings? There were always some anti-dumping and countervailing duties in the United States, but President Trump has substantially increased these anti-dumping and countervailing duties, particularly designed against the imports from China. Allegedly, Chinese manufacturers had damaged cut-price solar products into US markets and received subsidies from the Chinese government. And then the panel has more or less done a declination to the 4 conditions which I have mentioned. In the interest of time, I cannot go now into the details, but the result was, according to the panel, the US measure was justified. And this has been said, notwithstanding the fact that in principle, solar cells are becoming more expensive if the cheap Chinese products are not anymore available in the US market. But some of the argument of the panel was, well, it must be avoided that US solar industry is somehow disappearing. That's not in the interest of a climate-friendly environment. And this leads me to my outlook. Sustainability issues gained importance during the last few years on the WTO level, and an increased sensitivity for sustainability can be diagnosed. As far as the WTO legal framework is concerned, the discussions about specific justifications have been broadened. Limiting and trade limiting measures are more easily accepted than they were in the past. Nevertheless, some legal uncertainties cannot be overlooked. And if I look into my personal crystal ball, I would say that the impact of climate justice considerations might probably be higher in the near future in the WTO dispute settlement procedures, and such approach would most likely be adopted, even if it might have some slight impediment for traditional cross-border trade. Thank you very much.
Thank you very much, Professor Weber, for these interesting insights into WTO law. We're a bit behind schedule, but we also started out 10 minutes late on this session, so I think it would be a pity not to leave room for a proper last presentation on this panel. This one. So Massimo Mattioli, pre-sales manager of Stack EMEA, Italy.
Yep.
The floor is yours.
Thank you. First of all, I have to say thank you to Professor De Franceschi to give us the opportunity to be here. To talk a little bit about our, we are part of the supply chain for the company of who are selling cloud services, public cloud services, or they are system integrator and so on. So Stack Infrastructure is a multinational company, was born in US, is spread all over the world roughly at the moment. So we have US and Canada, then we have in Europe. In Europe there are data centers in Italy, in Sweden, in Denmark, in Norway, and in Switzerland. Then we have in Tokyo, and so Japan and Singapore, and Australia. So it's well present all over the world. Maybe you are not familiar with data centers, but every day you are dealing with data centers. What my company is doing? My company essentially is providing co-location. What does it mean, co-location? We provide technical spaces to customers. Our customers, I told you before, are the big company, over-the-top company, and so on. So let's move on. On this slide, I don't want to show you which are the habits of the European people to play a little bit with our social networking. As you see, Italy is very on the low side of the side, is almost less than 50%, 53% that is the average side. And Denmark is in first position in terms of using the social media. But this is not the intent. But every time we are socializing in the network, we have to store our data somewhere. And the data are stored in the data centers. If you see, this is how the cloud computing is progressing in the year. This study is coming from a study done from the European community, and this is the last data that we have. You see, year by year, the cloud computing is increasing. And when it's increasing the cloud compute, is increasing other aspects that we discuss a little bit later. What is a data center? Essentially, a data center is a space where we provide power, cooling, connectivity, and physical security to customers. It's interesting, if you may see, that by the 2025, every 18 seconds that you are connected, you go to cloud computing systems. It's impressive. People, time to time, doesn't know, just pressing on a simple icon on telephone, what is doing exactly. There's a lot of work behind this. And we do a part of it, because, as I told you before, we provide space. So, which are the pillars of a data center? As I told you before, is power, cooling, connectivity, and security. But you see +1, but we will see a little bit later. Which are the main characteristics of the modern data center? What our customer or the customer asking for a data center? To have his data available in every moment. To have it like this, in a moment. So just pressing, I would like to have the answer immediately. So that is what our customer, everyone is asking for. If you are just watching, I don't know, a streaming, you really hate if you see, the things going around for seconds, and you are really disappointed about this. So that's why the need to have a data center spread all over Europe, all over the world. So you see there are a lot of things over there. Future-proof, built in a safe space, fault-tolerant. What does it mean? If you lose the power, the data center won't stop. We have generators, we have UPSs that guarantee you that you can still get access to your data. Future-proof, why need to be future-proof? Because you need to understand which will be the future of the data. We have a massive growth of data. It's impressive. And nothing more than we have to wait for the automotive to be there. Just think a self-drive car. What will bring to enormous data? We will see, I don't want to bother you about edge data center, hyperscaler data center, but in any case, data center is managing data based on what he has to do. So, the important thing, obviously, they need to be hyper-connected. They need to be especially installed in safe area. Our data need to be safe. You may think, are you going to install a data center close to a refinery, or close to a river, or close to, or maybe in an earthquake area? I don't think so. You would like to avoid this. And that's the best practice that we apply to have the data center installed. So let's go, because I don't want to bother you so much in these things. But this slide is just showing you the European data center market. You see there are 1,830 data centers that are doing a similar work that we do as my company do. You see 22% are in Germany, 14% in France, 13% in Netherlands. Likely Italy is at 9%. Let's go and see. Germany itself is a huge number of local players, but these data centers are smaller. They are more than the other, but they are smaller than the others. Obviously, the new design of a modern data center needs to be big. That's go big is better in terms of cost avoidance. Then there is France. France is a good market. There are just few players, and they have big infrastructure. The good thing for France, obviously, the cost of power is less than, for example, in Italy, because they have nuclear power. You know, essentially, in a data center, what you use is power, period. Then Netherlands. If you think that is a 16 million nation, I think, correct me if there is someone from the Netherlands, roughly, but you know, is one of the biggest in terms of data center presence if you compare the small size of the nation. Then Italy is coming back, but it's just in the few years is coming on the market, and Milan area is growing so much. That is a good thing for Italy. There are a lot of investment coming. You have just to think that one data center, modern data center, costs roughly 150 million euro each for a 10 megawatt solution. In a 10 megawatt solution, you may install up to 2,000 rack. A rack is something like that you see behind me, where the customer will install server or system where they can store data. They can store their systems. So this is just a sectional of our data center. You see it's composed by some parts. You see there is these handling units, there is a hot air plenum, this is a hot air containment module, there are high power corridor, UPSs room, and diesel generators. To build this kind of data center, as I told you before, is around 50 million. But the good thing here, this data center is really efficient. It's an expensive design because you may build a data center with a lower cost, maybe 30, 40% less than this, but you're gonna have a less efficiency on this. And we'll discuss about how we translate efficiency in less power consumption. Essentially, a colocation company is providing, his main job is to cool down the customer heat produced by the customer equipment. This is what we do, and we do it the best way. So this is like, you know, a dual layer roof is giving you a protection against the direct sun coming above, you know. The hot air plenum is collecting all the hot air created by the customer equipment, and then the air handling unit are aspirating the hot air and cool it down and brought it back in the HACM equipment. Then we have the high power corridor that is feeding the remote panel, power panel inside the room, and then we have the UPS room and the diesel generators. That is how a data center is basically designed. And now let's go straight to the sustainability. That was the fifth point that we were discussing. That is the important aspect for us. Sustainability is important for us because we are using power. And what we do to make it work, first of all, to be efficient. Second, to buy essentially power coming from renewable energy. Obviously, we buy a slice of a production of a renewable energy company, but we are happy to. It's a little bit more expensive, but we don't care. We do think that this is important for a climate aspect. Obviously, what we have to do to be efficient is not only a matter to have a nice design, to have a nice technical solution, but the quality need to keep going, because you have equipment that you need to maintain, to make them efficient. And that is why it's not only a matter to build it and then to maintain it in the year. This slide is giving you an idea which will be the power consumption in the next 8 years. You see, let's take, for example, the 2022, we are roughly at 1,000 terawatt hour per year. If you move to the 2030, we go up to, if we take the average one, up to 3,000. So 3 times more than what we are consuming. So that's why we have to go in that direction. We need to be efficient. We need to renew our data center arena, at least worldwide. This is another idea that is giving you how the things are changing. You see the traditional data center are going down even more. With the edge data center are increasing in terms of, then I will explain what are the edge data center. And then you see how much the cloud data center are growing in the coming year. But this growth, as you see in the figures, you see in the 2018, we were 76.8 terawatt hour, and we will be 98.52 terawatt hour in the 2030. So we have a 28% increase. So this is a lot to do in this aspect. So, in order to improve our quality, our efficiency, the Green Grid in 2007 provided a parameter to meet that is called PUE, Power Usage Effectiveness. If you see on the graph, a lot has been done in this year. We were 2.5, and now we are 157. But what is a power usage effectiveness by the end of the story? Is the ratio between the total facility power, so what we get from the grid, divided by the IT equipment power, so what our customer is consuming. With this parameter, it's quite easy. You should install all data center in the Nordics, because obviously in the Nordics, the average temperature are lower than, as in Italy, that we are on the 45th parallel, you know. But obviously, customer would like to have their server, their equipment close to their business, you know. But so you have technical solution that may help us to have this parameter a little bit lower. So the good thing, you know, you see this parameter is dropping down significantly, but now we are on the limit. As you see, it's almost stable. We have done a lot of investment in this area, but now nothing more we can do in terms of data center owner, in terms of data center company, you know. We need to have some other, let's say, the customer need to think a little bit differently. And I tell you why. Obviously, the key thing for us is to keep this figure as less as possible, because by the end of the story, is a cost for the customer, but as well is a reduction of emission, CO2 emission, carbon dioxide emission. So this is really important for this. One more thing that I would like to add is that we already reached this limit, but if you want to improve this, we have to ask the company who they have their server, maybe all type of server, that won't allow us to work with a higher temperature inside the data center. Work with a higher temperature allow us to do a good savings. For example, normally in the multi-tenant data center, we are using 21 degrees as the average temperature inside the data center. But if you just grow up to 25 degrees in the data center, that means you may save something like 20% of the power you are using to cool it down. Huge numbers. You see there, we can work over 2%, 1% in terms of efficiency with huge investment. We know if a technical refreshment in terms of hardware it will be again a huge investment, but we allow us to work with higher temperature. That means that allow us to have a better efficiency in our systems. Then the company, when talking about the supply chain, which are the parameters you have to take in consideration when you are choosing a company who is providing data center services? For sure, it's a matter of technology, it's a matter of technical solution implemented in the company, but there are some good certification that this company need to have. You see, we are talking about the ISO 4001, that you know is better than me, it's environmental management. So that is a big challenge for a company like us because they always giving us more requests in terms, what can you do better, you know? And for us, it's always a challenge. You do better, you know, you do better maintenance, you try to buy the best cooling system, you try to do everything you may do in terms of efficiency. Then you have, the same thing is for the ISO 50001, that is talking about the energy management. Energy management, so it's how you deal with energy. You may think that we, in our data center, we're taking trace of every single piece of the data center to take all the information, which is the power consumption. If we are losing efficiency, we are able to trace everything. That is quite important as well. Last but not least, you see that is a great job that the European Code of Conduct that for data center energy efficiency, that is the best practice that the European community is asking if you want to build a good data center. So it's a bunch of rules or best practice that you need to follow. And that's it, you engage this and then you become a part of this project. And every year you give them all the details, how much you are using in terms of power and how much you are virtuous in your power consumption. Last but not least, and for sure is the last slide, so I won't bother you any longer, there is a lot of attention on greenhouse gas emission. We do have a team of colleagues that are experts and they are doing all the maintenance on our systems. We are not using third party. Our company essentially is insourcing everything because we think that these are important things as well. We don't want to use third party because you cannot trust always on your third party. You prefer to trust to your team. That's all. Thank you.
Thank you very much for this last presentation on data centers in supply chains. Very interesting perspectives. So I actually think we don't have that much time for discussion. I don't know if we can take a couple of questions and then I leave the floor to you to close off the conference. Are there any questions at this late stage? A couple? Yes, please.
Well, I apologize for taking the floor once again. I have a number of of comments or questions. William, at one stage of your presentation, you said that the directive on deforestation, or rather on the prevention of deforestation, of course, would probably relate to about 200,000 companies, and that it would be very difficult for any supervisory authority to really effectively supervise these companies. And I mean, that's of course true. I just want to give you the example of the German Supply Chain Act, which will enter into force on the 1st January next year, and only a fraction of the number of 200,000 companies will be affected by that act. But even there, it seems that the authority, the supervisory authority, which is charged with supervising these companies, has problems to recruit enough people to do the job. According to the draft, 60 new posts are to be created in the so-called BAFA, Bundesamt für Außenwirtschaft, but it seems that even that number is not enough. So my question would be, is not the obvious solution for this problem to at least partially also engage in private enforcement of supply chain regulation? And I'm of course talking on one side on tortious liability in favor of the victims of unsustainable production processes, but also on the other hand, we could think of private law remedies for the buyers of products. Of course, if you buy, let's say, a garden piece of garden furniture made from timber from the Amazonas region, then probably that's the most stable piece of garden furniture you'll ever get, because it's tropical wood. So it's not a defective product in the strict sense of the word. But if the company holds itself out as not producing from tropical, its products from tropical wood, then probably it is still a defective product. And could it also be a defective product if the company does not hold itself out as such, but it's against European regulation, for example? That's an open question, at least in German sales law. And that brings me to the presentation by Evelyn Terrin, who talked, among other things, about sustainability clauses among the supply chain contracts, so between the different chains or elements of that chain. And I think that normally contract law is able to sort of balance the interests of the parties, or, I mean, if you have a normal sales contract, the buyer will look for his interest and will have a look whether the product is really worth the price, as well as the seller will look whether, I mean, you know what I mean. So the parties will look after their interests. But here the problem is that it's really third parties' interests which are at stake. So we must necessarily bring those third parties into the picture, and those are the employees of the place where the production takes place, and it's the buyers, the consumers who consume the goods. And my last remark goes to the presentation we heard from Priscilla Andrade from Unidra. I don't know whether she's still in some form with us, but anyway, if Unidra is entering, and I think that's a very good idea, topics like access to justice, global value chains, I'm wondering how they liaise, for example, with the Human Rights Council and the open-ended working group on an international binding treaty on business and human rights. Because that working group, under the auspices of the Human Rights Council and led by Ecuador, when you look at the draft, at the current draft, it is in urgent need of some input from the Hague Conference on Private International Law, or from UNCITRAL, or from Unidra, or from all three of them. I think there's a huge need for collaboration between these different players in the international arena. Sorry for taking so long.
Okay, thank you. I think maybe we'll just take the second question. Yes, a second brief question.
Thank you. I also have a couple of quick remarks, questions for Professor Boyd related to market access. So you define this as a privilege, and therefore following this privilege must be some public interest pursuit involved. I have two questions related to this. So defining market access as a privilege means that you entail access to a specific market and being particularly rewarding. And I suppose that because you talk about global value chains, which also have a leader, you speak about demand-driven global value chains. And so the privilege that you access is a consumer market, so a high level of consumption. And I'm wondering whether in your picture you've also taken into account a sort of emerging competition among different consumer markets, because now it's like the EU and the US clearly are higher than other markets. We're thinking about rising consumption in China might change a little bit the picture of your argumentation, perhaps. And the second is actually more a question. So if you talk about demand-driven market and specifically about market access, then you may want to consider not only global value chains that have a leadership, but also those global value chains where the trader and the distributor plays also a role, and that's not necessarily the leader of the global value chain. Thank you.
Okay, so thank you for the comments and questions. I think there were a couple of questions for you.
Sure, I'll be very brief. Yeah. Eva Maria, thank you so much. So on the challenge of administration, monitoring, and enforcement, you know, I've never seen the actual number substantiated. This was in a seminar that Hugo Schally gave and the ELI working group that Alberto and I have been chairing. I assume that the vast majority of commodities that are within the scope will be tied to a number of big players. And then there'll be a very large number of small players. And the question for the regulators, it seems to me, is how to efficiently assess whether those small players are meeting the requirements of the regulation. They're in the proposed, so this is a proposed regulation that is working its way through the various different bodies of the European Union, as I understand it, and perhaps there'll be some final drafting in late 2022. This is based on a report I just heard in Oslo a couple of weeks ago. But my understanding is that right now the proposal requires competent authorities at the member state level to carry out annual checks covering at least 5% of operators and 5% of the quantity of the relevant commodities, right? So you can do the math, it's still a pretty large number. The question is, and maybe this is my US perspective, when you have a relatively small number of a small sample size that's being audited, you know, people figure that out and game that. Like, this is what happens to the US tax system, right? I mean, we assume that cheating is rampant and that the IRS does not have the capacity to actually do sufficient numbers of audits. There could be creative ways to organize that. Your second point, though, is really important, and there is a provision, as I understand it, that says substantiated concerns may be submitted to competent authorities by any natural or legal person. And so there is a sort of citizen suit type provision, it seems to me, that could help quite a bit with the enforcement challenges. I also think that if you look at more creative ways on the producer side to think about doing this at scale as opposed to going farm by farm, right? That if you think about traceability to the broader jurisdiction and that's performing and not to the individual farm, you cut down on the information requirements for the operators, which is going to make the job of the regulator easier. But, you know, this needs to be tried, and great that the European Commission is moving ahead to try this. My understanding from people who are close to this is there's not enough resources built into the back end of this to do the kind of monitoring and enforcement that we need. But perhaps that'll get sorted out as this works its way up. Second question here on market access. So I guess my point was that, and people can tell me why this is wrong, one of the great assets of the European Union, and my understanding is the original reason for creating the European community was to create a common market, right, in some ways. And if you think of that as leverage, if you think of market access as a tool, as a privilege, there is an enormous amount, right, you can do. It doesn't solve the problem, because you're right, we could easily end up shifting, you know, deforestation to commodities that are going to the Chinese market. But large markets like the European Union and the United States, perhaps and others, starting to take bold action in this respect and starting to think about market access as a privilege could have a huge impact, right, it seems to me. So I do think it's worth exploring. You are absolutely correct that supply chains, the dominant firm model does not exhaust the category. We need to be thinking about different models and ways in which supply chains are organized, absolutely.
Thank you. And Evelyn, I don't know, did you want to make a comment on the question?
Really briefly?
Yeah, yes.
Yeah, well, thanks for the comments, and well, I think I totally agree that well, private law as we know it, okay, can perhaps deal with the interests of the parties, but even there, well, there might be some cases where it would be good to take other interests into account, even in balancing the direct parties' interests. And as for upstream and downstream, traditional contract law is not very well equipped with that. I completely agree. As for the private law remedies, there are already some possibilities if you look at the conformity requirements to look at what reasonable if you look at the conformity requirements, if you have bought something and whether it's not in conformity, to take into account public statements that have been made. And there will be more disclosure obligations here. But if that will really trickle down to what the buyer could expect when buying a product and whether courts will take that into account when interpreting whether there is conformity or not, it's not the strongest way of enforcing this. And you already see differing decisions right now, for example, on the Dieselgate, whether there is conformity or not, and whether the claims about emissions could be taken into account when what a consumer could expect in terms of conformity. So I don't think this will help so much or whether just Thales law will help so much in enforcing this.
Okay, thank you. Thank you, everyone. I think this is where we close off this panel. I wish we had had more time to discuss all these interesting topics, including this new proposal. I totally agree there are enforcement problems, definitely. One of the solutions that is incorporated into the proposal is a hope that private enforcement will also work. There's actually quite a lot of liability stuff in the directive, but that's a big question whether that will function. And in general, it would have been interesting to discuss also the focus of the directive, which is on human rights, rather than climate change, actually, but it sort of comes in indirectly, I suppose. But we will do that some other day, and right now I will simply close off this session by thanking all of the panel participants, of course, very much for your very interesting presentations, and I will then leave the floor, I believe, to you, Alberto, to maybe some concluding remarks and closing up the conference.
Okay, guys, it's been a long day. Thank you so much for all these interesting, thought-provoking, brilliant presentations that we heard today. Now, I think it'll be extremely difficult to sum up what is it we've heard, because I can hardly see any area or sector of law that we haven't touched upon. We've been talking about contracts in supply chain as well as public law in supply chain. We've been talking about company law, how it can be used to promote the protection of the climate. We've had discussions about the role of tort law in climate litigation and the development of the duty of care. Is it possible to do so? I think if we look historically at tort law, we'll find that product liability, for example, is a field that grew out of tort law, but also established its own niche within the law. So law is developing. We also heard about human rights. Human rights, as we've seen, national courts have applied the European Convention on Human Rights. We heard that there are cases at the European Court of Human Rights at the moment. And can the convention be applied in respect of protection of individuals, protection against climate change. Now, we must be aware of that. One thing is, for me, as a scholar, I have a certain academic freedom. I can be probably more political than the courts they can be. So the courts, as we also learned today, they must act within the constraints that they have legitimacy under the general principle of the rule of law. I have a liberty that the courts, they don't have. Having said that, the courts are extremely important in promoting the protection against climate change. And that is the way I see the law. The law is living. It's a living instrument. And if we consider it as a living instrument, and if we look at all the presentations today, I think it's safe to say that we can apply all these different sectors of law. They address the same issue about climate change. They can serve as relevant context. And that's where, how living is this legal instrument? It depends on how wide a context that the courts will apply in order to determine what is the particular law in the case. How wide can we take it? And that can also be different. We have to understand the differences between the courts. International courts, they might be under stronger constraints than the national courts. But nevertheless, what I would like to think of is that, for me personally, when I see this context that the courts can apply to fill in the gaps in the legal system, and I might be an old softy here when it comes to the law, because I like to think of the law as a coherent system. So what do we do to fill in those gaps? That's when we start to apply principles. And principles of law, what are they? They can be soft, they can be hard, they can start as soft and then eventually develop into a hard law. So there's not necessarily that clear division between soft and hard law when it comes to principles. They can have a particular character or they can have a general character. They can be higher ranking norms of law, for example, if they're entrenched at constitutional level, or in public international law, they are peremptory norms of public international law, what we call jus cogens. So I think that what I would like to take, and what I want all of you to consider, that is, how are all these areas of law that we've heard about today, how are they really connected? Because when we think about that connection, that's also when we start to establish that glue that keeps the coherence of the legal system together. And that's when we start to develop principles of law that we can apply in our legal argumentation, not only as academics, but also the courts. But thank you so much for all these ideas. I'm very inspired. I'm going to look at all these things now and see, can we, when we step away from the particular fields of law we heard about today, can we take something out for them and say, this is how they really are connected to establish these principles? Thank you.
So just a few words. Thank you very much also from my side. I was very impressed by the quality, variety, and dynamic character of today's presentation. I learned a lot. I'm really thankful to each of you. And yes, I would like to come back to the wise words of Eva Maria Kininger regarding the mosaics of this little town, Ravenna, which for over 300 years was the capital of the Western Roman Empire. And I had really the impression we composed a wonderful mosaic in being humble in each discipline, but delivering perspectives which creates synergies with other disciplines. And I think the result is very promising, and also, what is most important, very fruitful. So something seminal for further development. And I'm particularly thankful as we conceived this conference together with Henrike and William. The idea was to have a brainstorming and to put all things on the table, all relevant concepts and reflections in order to brainstorm and having the best basis for the day after when we start drafting principles and thinking about how to shape them. And I think I have the impression we succeeded. And if this happened, it's thanks to every one of you, not only the speakers and chairs, but also those who took part in discussion. So I can also only repeat my thank you and wishing you a relaxing evening and giving you appointment for tomorrow at 9 in this room for the Pars Construens, for drafting principles on the basis of what we said today. Thank you so much. Have a nice evening.